Robinson, you're okay with that? Okay. All right, then if I can see counsel for Mr. Robinson and counsel for the state back here, we'll go into back chambers to call the juror. His position. Well.
You're planning your day around it. You're planning your
For Jacksonville rapper Hakeem Robinson, also known as Queso.
You'll want to do, but are you okay with me calling her? Yes, sir. Her? Yes. I'll ask what you'll want to do, but are you okay with me calling her? Yes, sir. Okay.
Your Honor, is it something that is done at sidebar? I understand there's no camera in here right now.
Right. Well, which I'm not going to put her on speakerphone to speak. I don't know how else to do this other than, well.
Y'all go into chambers.
Yes, let's. Well, but then the defendants aren't going to be present.
Just fine with me.
Oh, she gave that number?
You have a picture of it? Number?
No, I have the warrant that Smith has to be able to search it.
Ooh, iPhone.
Yeah, that's the same number.
Oh, these are cool.
We have the property card, but also the search for the phone.
All right, so is it Mr. Robinson's position that you all can come back to chambers with me to call the juror and he remains out here?
Yes, Your Honor.
Okay, Mr. Robinson, you're okay with that? Okay. All right, then if I can see counsel for Mr. Robinson and counsel for the state back here, we'll go into back chambers to call the juror.
All right, good morning, y'all. We have another juror issue as we start the day off today. Welcome back. Make sure that you hit that like button if you haven't done so already. Share the video and subscribe. Subscribe to our channel. Now, yesterday was crazy, y'all. We had a whole lot going on yesterday, and I absolutely did not get the transcript until late yesterday, and so I did my little recap off of memory. Now I'm looking at the transcript feeling like, ooh, there's so much more that I could have brought in. Let me go ahead and pause to mute this because we don't want that video, that sound to flag us. But there was so much that went on yesterday that I felt like, ooh, we kind of missed it. I don't think I posted the video over here on YouTube, but if you follow me on TikTok, the video is definitely over there. I did go through all of the witnesses, starting with, let me go back and see what his name was. FBI agent Rob Corley. All right, he was the first person up yesterday, and he gave all of the cell phone location and call record analysis. The data sources that he used, I'm looking at the transcript right now, y'all. The data sources that he used was for T-Mobile, AT&T, and Sprint. And he was kind of looking at some of the iCloud subscriber records, but not in detail. All right. Just key stuff from his testimony was that he demonstrated how the phones connected to specific towers, in Jacksonville and showed their movements in relation to the homicide. What was interesting is that the defense got up on that one and they were basically saying, well, they put it in front of the jury, right? That your tower doesn't really determine your location. You could be miles away from that tower, but that tower has the best strength. And therefore your device would kind of ping off of it. He did talk about how cell towers kind of overlap. But essentially, he was just trying to put everybody in the location of the unalive. Excuse me. They had Shalonda up. Shalonda was the fingerprint expert. She basically lifted the fingerprint off of one of the guns that was left in the car, and that came back as a positive match for Hakeem Robinson, aka Queso. Then we had the David Ostra from the Jacksonville Sheriff's Office. Can't even get it out today. All right, he did the forensic examination of the downloads off of the devices. So he linked the Apple IDs to the House of Pain, which actually linked back to Abdul Robinson Sr., who is the father. He also said that that particular device had movement on the day of the unaliving. All right. He admitted that he did not investigate the context of that, and that's kind of all he really did, right? He broke down those phones. Who was using them? He broke down the Instagram post. He was reading some text messages out of there. Like, he was really, his job, I mean, in my opinion, his job was really trying to say that the digital data from those phones just kind of proved that, one, there was a beef, and two, those phones were moving around the time of the unaliving. But of course, he couldn't necessarily say who was holding those phones at that time. It's still early, guys, so I'm sorry. But after that, we went to none other than Abdul Senior. And baby, he told on both kids, all the kids, every kid that he had something on to tell about. He was telling. All right. Telling. What was interesting about his testimony is that, of course, he basically confirmed that both of his sons were a part of ATK. He decided to say that Queso was the shooter after looking at the picture of the gunman in the trial. They talked about the Willie Addison shooting that happened in 2019, where Willie was unalive. He was in the car with his son, Junior, and they were also shot. And that was the time in which Junior was shot in the head, and he was hospitalized for months. So what I think about when I think about that particular part of the testimony, we think about how Junior was really doing a lot of the orchestration. He was doing a lot of the phone calling and texting and saying stuff to people, but he wasn't necessarily in the car. He walks with a limp, so he had to go through like a full recovery after that unaliving. But it definitely puts it into perspective why he was really like an orchestrator.
Providing information to police, and she will be on her way. So we are awaiting her arrival. So we're not going to start trial at this. Clarify, we have had the call with the juror. She is fine. She is still at the crash site doing her statutory duty of providing information to police, and she will be on her way. So we are awaiting her arrival. So we're not going to start trial at this moment, but she is coming and she's going to serve. During this time, needs to be addressed. We can do it now. I may not be on the bench if it doesn't involve, and I'll just go and return when she is on her way. She's going to call us when she's on her way. In terms of logistics for the remainder of the trial, juries, although the evidence that was anticipated that would be presented that might have necessitated two juries wasn't. So now question is, how are we going to handle closings and instructions?
Your Honor, allow me to interrupt the court. One important, my client and I, we have had a chance now to discuss this. We would like to absent ourselves and excuse our jury for the presentation by Mr. Robinson.
Okay, all right. So my initial thought was, and I'll leave it to the state too, if you want to give 2 closings or just 1 closing. If the state wants to do 1 closing in front of both juries, and then we'll do Whitaker's closing, excusing Mr. Robinson's jury. State will get the rebuttal to Whitaker's closing. Then Whitaker's jury will leave, and we'll do Robinson's closing, and then state gets rebuttal to Robinson's closing. The question I have is, is there any issue with me bringing them back, instructing them together, understanding that Whitaker has an additional charge that Hakeem Robinson doesn't, and I can say, and as to this jury, you have an additional charge to consider separately and then letting one go deliberate while we're doing closings on the other one. Any thoughts, suggestions, comments, concerns?
I will be seeking an additional jury instruction that will not apply to Mr. Robinson. And I imagine if the court were to allow it, it would be too confusing only instruct. And I'll go ahead and articulate it. I'll be seeking an independent act instruction.
Okay.
I understand the court may very well not give it to us.
Okay. Well, and we'll discuss instructions, of course, at the respective charge conferences. But any issue then?
Well, the state's thought is this, is our plan is to give 1 initial closing argument in front of both juries.
Okay.
Then we can excuse the Robinson jury for a significant period of time, depending on when we begin those closing arguments. I was hopeful, obviously probably a little too hopeful, that we would get to the first closing today.
Okay.
That's obviously, I'm just an optimistic person. We would do that. So anyway, and then we would excuse the Robinson jury. We would do the Whitaker jury closing, rebuttal close, charge with a separate charge, have them start deliberating with the understanding the court may want, and the defense may want, and the state may want, to seal that verdict if they get a verdict before the Robinson jury is done. And then we would begin with the Robinson closing, followed by the state's rebuttal.
Okay.
So separate charges, separate rebuttal closes, but 1 initial closing where we present all the evidence of the dual trial.
All right. So that's what I had also perhaps envisioned. Is there any objection to that from Defendant Whitaker?
No, Your Honor.
Any objection to that from Defendant Robinson?
No, Your Honor.
Okay.
The only thing I'm thinking is in the event that something happens between now and closing, where we'd be asking for some sort of specialized instruction, but as it stands now.
Okay. Well, all specialized instructions need to be requested in writing. That's what the law is, and prior to trial. But if you're going to get me some, then get them to me today. Because I suspect then if we're finishing the testimony today, and I don't know how many witnesses Defendant Robinson intends to put on today, we would stay tonight to do charge conference. So I need to know what special instructions or additional instructions, I might add, are being requested.
And I have included a dual rough draft copy of the jury instructions. So obviously, if we are going to charge them separately, I'll need to amend that, and that should be pretty easy. It's just a matter of taking
Right.
2
So
names out and putting
then I'm going to need 2 drafts, 1 for each defendant. Okay.
that will not be hard to do.
So for scheduling then, because you've named or you've mentioned, Mr. DeCoe, several witnesses you were going to call, do you anticipate, assuming we can start here in the next hour and get through the state's detective, that you would be able to call all your witnesses this afternoon? Okay. Who can't be called this afternoon, or who's not available to be called this afternoon?
So we have certains and we have question marks. What I can say to the court, I'm a little bit reluctant to say exactly who because the state hasn't rested yet. I don't know if they're gonna, who they're gonna call, and there's a few that are still a question mark. What I can tell you is that we intend to have Howell here today. He's a quick witness. We intend to have 2 of the civilian witnesses here today. They were notified last night. They're, speaking to their employers. I don't think there's a problem. I did speak to Graham. He could be here tomorrow morning at 9. And then there's the question.
Oh, I thought he couldn't be here on Wednesday. He can now be here on Wednesday?
Be here on Wednesday.
Ah, okay.
Graham, because he's now retired and runs business, his afternoons are full with that business, and he can be here tomorrow to be the first witness. Then after that, there's a few of the question mark witnesses. One of the big one is Ahmad. We still don't know what time is going to work out because she's 7 hours in advance. Then there's a matter of impeachment witnesses for the testimony that Abdul Sr. would give as to his opinion because it's his son, even though he was away in prison for a vast majority of my client's life. We have a bunch of other family members, people that have the same relationship with my client that we intend to call to impeach testimony of Abdul Sr. and also to lay the predicate for his reputation for truthfulness within that community.
Okay, so can those folks testify today? I guess I'm trying to see how we're going to fill our time today with the defense witnesses. So then tomorrow it sounds like only Graham, unless these other witnesses can't be here today.
So one of the witnesses, Your Honor, is the manager that was spending a lot of time with my client, Johnny Shipes. He testified before the court in the Arthur hearing, and he did testify about the immense amount of time that he was spending, that they were traveling, that they were doing music videos. So he does have a lot of time with my client right up until then. I did speak to him and his assistant yesterday. My understanding, he's currently in Europe. We would like to call him purely for the impeachment via Zoom, like Ahmad, because he's potentially out of the country. We have a conference call with him tonight. He works weird hours, so this is something understanding Europe's ahead, that we have a conference call with him tonight at 6:30. So my intent would be to call him tomorrow. So we have a few in the morning tomorrow, a few in the afternoon today. I think that there's a potential that we use up the court's time and we keep a diligent schedule, and then we could go into closings tomorrow afternoon.
Okay.
A couple of points. First, beginning with Doug Howell, Your Honor, I would request that we proffer that testimony unless the defense can ensure the purpose of calling him is not for his personnel reasons and is some legitimate reason beyond impeachment. For the defense has brought that up before about some of his personnel issues. So we wanted to make sure that that was not the reason that he was called, and that would not be referenced in any way.
Okay, what is I don't know what Howell's testimony is going to be.
On January 14th, the day before the murder, less than 24 hours, about 12 hours before the murder, my client was in the JSO property room picking up property. Howell comes down, he's in a red shirt, has a long conversation with my client. There's also the video from the property room that shows what my client looked like. I mean, we've had testimony of a video shoot months later, months earlier, of a body scan years later. This is literally hours before.
Oh, so through him, you're going to introduce a video of Mr. Robinson from January 14, 2020?
Correct.
Okay.
And also his view of my client. He was deposed on this issue. He was asked a specific question. Based on the conversation that he had with Mr. Robinson that day, would you ever describe him as short? No. Would you ever describe him as slender? No. Now, if he were to try to deviate or explain and show some motive, then potentially for impeachment, we have no intent of trying to get in his tweets unless he were to deviate or soften or try to do something outside of the demo.
Well, we all know the rules of evidence. We all know the manner, mode, and methods of impeachment, either by prior inconsistent statement, by prior felony or convictions or crimes of dishonesty. How would the contents of his personnel file, of which I'm unaware, mind you, be relevant and or serve as impeachment for the expected testimony that you have just outlined that he may give? That is the description of the defendant from his contact with him on the 14th and the introduction of the video that shows the two of them together from the January 14th date.
It would go to bias, Your Honor. So if Sergeant Howell, let's say he gets up on the stand and he's like, well, you know, my understanding of slender is somebody that's under 250 pounds, right? Like something odd like that. Then the tweet where he says, what's wrong with America? Number one, marijuana. Number two, marijuana. Number three, black people. Then we would say that goes, my client is African American, that his bias towards, I mean, that's inexcusably racist what he wrote, that perhaps he's changing it because he is racist and he's testifying against my client. Again, I'm not trying to get that out. I want to get out the video that's hours before and to keep him confined to his deposition transcript, which is get a conversation, the person that they're saying the shooter the day before, not short, not skinny.
Okay. Well, when and if you believe we get to that point of impeachment, I would ask that let's bring it sidebar so I can make my ruling on that and decide if, in the manner and method in which the questions have come out, if that is proper or improper. So I would just ask for you to not go there until we have come sidebar and I can properly rule on it, in context, having heard his testimony.
Of course. I mean, if he just gets up there and he testifies consistently with his deposition transcript on that and other issues, then I'm sitting down.
Okay.
Thank you for that. The other issue is, to date, the defense is still not listed any witnesses. Now, I'm not going to ask for, to strike witnesses if they're on our witness list and we know what they're going to testify to. For example, Doug Howell. He was deposed. The woman from Northern was deposed. We're not going to make those motions because we want the defendant to have a fair trial. But there are the witness he just referenced that is in Europe, and then all these impeachment witnesses, they've never been listed. We have no idea who they are, and we would move to strike all of those witnesses as Richardson violations. And I'm putting the court on notice as to that. I don't know who these people are. I don't know what their records are. I haven't talked to them. I don't know who they are. The testimony from Abdul Robinson Sr. was known, anticipated, deposed on years ago. And so here we are today with surprise witnesses. So that have still not been named. So.
Okay. Have any of those witnesses, Mr. DeCoste, been disclosed in discovery to the state? But his mother's been seated throughout this entire trial.
And I made it known sidebar before they asked the question. Look.
And you all invoked the rule.
And I made it clear, sidebar, that if he's allowed to testify to this, because our position is no witness is allowed to comment on a video unless they were present at the time when she wasn't or an expert. And so I said, sidebar, turn to Mr. Cooper and it's on the record. In the event that you elicit this testimony, we have a whole bunch of people, including them, that would be called to impeach his testimony. By nature of impeachment, like if they were to call an impeachment witness, we don't have it listed. That's the nature of the rebuttal witness. So because they were able to open that door, then we're calling witnesses to testify. The fact that they were in here, the state knew that they were in here, knew that that was a community, because I also made reference to that is his community. They would testify as to his reputation for truthfulness. So this whole idea that the government is surprised by this is incorrect. Mr. Shipes testified years ago in the Army hearing. He's been involved throughout. The government has. They pulled up yesterday to refresh the recollection of Abdul Sr. contract. So they opened this door by eliciting that testimony, and we, by law, have a right to rebut it.
Don't you have to provide the names of the witnesses you intend to call to the opposing party?
If they were to call, based on the way that the state does a rebuttal witness many times, they don't. They just call the witness, and that's a rebuttal witness. Like if the defendant gets up on the stand and goes, I would never harm somebody, and then they bring up somebody who's a rebuttal witness. Many times we don't know that. They will know in advance the name of the person, the date of birth, they can do all the search. They know Johnny Shipes, they've known that since yesterday. His mother.
But I'm not so interested with Mr. Shipes, but when you've pointed to folks in the audience who, by the way, other than Mr. Hakeem Robinson's mother, who was in the audience or has been in the audience and watching trial, at least yesterday, pursuant to Mr. Abdul Robinson Sr.'s testimony, he didn't recognize anyone else as being part of his community, as you've outlined. So my question is, who of the folks who've been sitting in court watching this trial since the beginning are you intending to call, and how do I allow them to testify since they've been in here since the beginning watching the trial, and you all invoke the rule, which would prevent any witnesses from being in here and watching the trial, who have now had the benefit of hearing and seeing all the evidence.
So, Your Honor, to answer the question first about the ability to be able to color testimony, it's different when there's something where there's some gradient. On this, it's either it's a person or not. There's no coloring the testimony. If we ask a question, looking at that video, is that consistent with Hakeem Robinson's height and weight at that time? It's a yes or no question. So the whole coloring the testimony thing does not play into it. With respect to who would be called, for instance, Abdul Robinson Sr.'s daughter was sitting in there. He said, no, none of my family's there. His daughter was in there. And she did leave. Your Honor may have seen somebody get up emotionally and leave.
People have been getting up and coming out and going into this courtroom throughout the entire trial. I don't know who's who or who's related to whom. That I can't say. My question is, do you have the names of the individuals that you are intending to call? And if so, can you provide them to the state?
We are clarifying that now. We started the process yesterday of selecting, because we're not going to be cumulative. We want one or two family members to then call them. And yes, we would absolutely let the state know in advance that they can search it. Obviously, there's some people that are scared about getting up on the stand just by nature of it being public speaking and cameras. So we're trying to figure that out right now. I think by lunchtime we know exactly whom, if any, and we can give that to the state on the record and forward.
Okay.
And obviously, this is not the way trials and law is practiced, Your Honor.
No.
I will indicate that back, let me give you a date. You can see it, that Mr. Ms. Hawass listed, there is no date on here, but it was,
Go down to the certificate of service.
it's accepted by the Duval County Clerk on February 18th of 2021, so around that time. There is a list, it says hearing, witness and exhibit list. This was for the bond hearing, the Arthur hearing. They've listed certain witnesses, all in care of the defense, that they intended to call at the bond hearing, including Ms. Walters, Mr. Shipes, who he's referenced here today, and then the 126 Category A witnesses. We have let the court know, there's never been another discovery notice filed by the defense.
All right, we have someone from the Hakeem Robinson jury knocking on the door.
I'm honestly not sure what to expect. That kind of escalated pretty quickly. It really did. Okay, so Abdul Senior's testimony yesterday, y'all. What I found interesting is that like Abdul Senior was outside hanging out. Senior was outside with them kids and had been with them kids outside doing all this stuff, and then turned around and told on the kids. But the kids also telling on each other. Everybody telling. Everybody is telling. What's going on? So right now they are going back and forth about the rebuttal witnesses. They are saying that the defense did not disclose who they wanted to call as a witness, and the state or prosecution is saying they never had a chance to vet these witnesses and possibly talk about or come up with questions to cross these folks, so they feel unprepared. The judge is pretty much saying that the rule states that you have to, supply your witnesses ahead of time. But the defense is arguing that the prosecution opened up a door during testimony that they were put on notice about. And therefore, they kind of came up with the witnesses that they wanted to call. Another issue that was raised is that some of the people that they want to call are actually in the audience. And there was a rule that was inflicted by the defense that said anybody that's going to testify, basically couldn't be in the courtroom. So they're trying to, in my opinion, They're trying to kind of get around the rules so that they can call everybody that they want to call to impeach the testimony of Abdul Sr. They're basically saying he got up there and he was lying about some things, and they want to make sure that they have the opportunity to put people on the stand who, okay, what's
State
going on?
notice that these are listed witnesses that the defendant intends to call at trial. We are greatly prejudiced by not deposing people that the defense is going to call. Of course, we've been mentioning this at the final pretrial, and we mentioned it during the course of the trial, and the defense saying, well, everyone we've already listed before. That doesn't give us the opportunity to depose these people, to do any research for these people, and that is why discovery rules exist and require the defense to list their witnesses in a discovery exhibit of who they intend to call. And that is to be done, was it 15 days? I don't remember the exact times. It's to be done years ago. And so here we are today. I am letting it go. The state is letting go the people that we know what they're going to say if they've been deposed in the case. That's a little different situation, because I would agree that there's no prejudice to the state if we know what they're going to testify to. So we'll accept the lack of listing of someone like Doug Howell. But the listing of their family members and people they listed in the bond hearing, it greatly prejudices the state of Florida, and there's nothing we can do about it at this point other than move to strike the witness's testimony.
Your Honor, the issue then clearly is the rebuttal witnesses. First, I put on notice of it years ago. By nature of being a rebuttal witness, our discovery obligations are list people that we intend to call in trial. We have no intent to have to rebut their witnesses. That's something that happens during trial. There are many different things that can happen on rebuttal where we're getting witnesses that are outside of the witness list. Now, there's no prejudice to the government. There's no surprise in here. Specifically on the topic of the video, they know that the witnesses are going to get up there and say, that's not him. There's no surprise, there's no prejudice in that, but we have a right to rebut that testimony with people that fit the same parameters as Abdul Robinson Sr. I made it known before they elicited it, they chose to elicit it, now they claim prejudice. There was no argument yesterday sidebar as to the names of the people, the information, they chose to elicit it. So they're willingly in this position. And we haven't played some game. We let it known before trial. We have previously adopted the state's witness list and calling those witnesses. We would have to be clairvoyant to know who we're going to call in rebuttal should a witness get up there and say something that we are confident is never going to come up in trial.
Let me ask this question, because you did depose Abdul Sr.
Yes.
And in his deposition, whenever that was years ago, he identified his son as being in the video. Yes or no?
Yes.
Okay. So if you were intending then to call another family member to look at the video and say, no, that's not him, wouldn't you have known to do that at the time that you deposed Abdul Sr.? And if so, why wouldn't you have listed that person?
So, Your Honor, the answer to that is no. I was fully confident, without any doubt, that that would not be admitted because the case law is clear. The witness has to be either an expert or be present. You know, I've dealt with this in Tallahassee. I've dealt with this in the Middle District of Florida. I've never had a witness be allowed to comment on the identity of the person in the video unless they fit the strict parameters of the case law. So that was one of those things that I'm like, this is an admissible testimony. We did not expect that to come out, and we need to rebut it.
And do you have any case law, rule, statute that says rebuttal witnesses don't have to be listed as discovery exhibits to the opposing party or have to be made known to the opposing party? I'm going to take this under advisement, mind you. I'm not ruling right now. I will give you all the opportunity to find whatever case law you want, since no one has cited me anything at this point, to say that witnesses that you are calling at trial don't have to be disclosed to the opposing party.
They were disclosed. They've known about Johnny Shipes for years. They've
But-
known about Ebony Walters for years.
But what about this community of people who you are intending to call, whose names I still yet have not been told who they are? That's all I want. I'm not going to hear any further argument. I'm taking this under advisement. Y'all get me some case law, because this isn't an issue right here this morning. We still have the state's case that we need to call witnesses on. and then we'll likely have a lunch break. So I will give you this many hours to do some research on the matter, and then I'll rule before the defense starts its case. All right, so we have the juror on her way. Is there anything else we need to take up relevant to the detective's testimony, who presumably you are calling next? Okay.
I know yesterday we addressed some of the evidence regarding the Instagram records. I think that has been resolved.
Oh, has it?
I believe it was already stated, but I wanted to bring it up just to make sure. We had filed a notice of intent certified business record.
Right.
To get those records in. I don't recall if both defense counsel voiced their opinion on that or not, but I wanted to bring that back up. I do know that we had some discs that I intend to introduce, so I wanted to make sure that defense counsel looked at them and viewed them, to make sure they don't have any objections before I can introduce them.
And which exhibits are these?
Judge, we have 8F, which is a video surveillance of Dunkin' Donuts. We have 8N, which is Instagram live video of Hakeem Robinson, a legendary video. We have 8L, which is an Instagram story video of a child singing a song, case of homicide, and singing a chorus band down. That was the day of the murder. We have 8O, which is the Instagram story video of Charles McCormick rapping with the bye-bye waving hand emojis. And then we also have another Instagram story video of 8M, which is the nail salon video. I know we've seen part of that already in other exhibits, but this is posted to the Instagram story. It leads into the actual photo or the text that was photo.
All right, and I don't know that we addressed all these yesterday. I know Leroy Whitaker had no objections to 8J through 8O, but I had not heard from Mr. Robinson, and then we did not address 8F, the Dunkin' Donuts video. So as to 8F, is there any objection from either Defendant Whitaker or Defendant Robinson?
No objection on behalf of Mr. Whitaker, Your Honor.
Okay.
Subject to previous motion. Objection, Your Honor. I think it,
What are the previous objections on this?
my client wearing clothing, if you're going to try to make a propensity argument that he owns that clothing, and therefore he's a shooter.
What's in the Dunkin' Donuts video?
I think Council talked about another video. The Dunkin' Donuts is just surveillance video that captures from a different angle what Victor Krueger's dash cam captured at head-on, so it's from the side and a little further back. So it just captures a little bit.
Okay. So as to that video from Defendant Robinson? I guess it's another angle of the shooting?
Yes, it is, Judge, and I play a small camera that was further back into the side, so it shows when Charles McCormick actually arrived and goes into express employment. It shows Mr. Victor Krueger arrives in his truck with the dash cam, and it also shows when the shooter got out of the Nissan Altima and chased him down. That was not captured by the dash cam. This was
Okay. So with that clarification, any objection from Defendant Robinson? All right. So at the appropriate time, that item will be marked into evidence as 188. And then as to 8J through 8O, as to 8J itself, yesterday, Mr. Robinson did object, Leroy Whitaker did not object. And then 8K through 8O, we haven't heard from Mr. Robinson on those. Any objections to those videos? And by the way, is somebody out there to receive the juror when she arrives? Is somebody waiting on her? Okay. Is there an objection from Mr. Robinson?
device he recorded on, yes, he made it onto a disc, and that is the video, yes.
So Judge, as long as he's able to lay the predicate, I can't, it sounds like he was in a, and was subject to the previous objections that Mr. Nichols made as to the content of the videos, one of which is the, which I think is 8-0 as well. This is the same arguments they made as to the referencing to the code.
Okay, understood. Then I won't rule at the moment, assuming predicate can be laid and without objection from Leroy Whitaker's counsel, then those may come into evidence. All right. Was there anything else? Let me ask about yesterday. I don't know that we resolved it or that I had ruled on, I guess, the, what was it, the Instagram subscriber information or Instagram records. I don't recall what exhibit number that was at this point.
9S.
9S, which is a compilation of records from Instagram for Mr. Whitaker, Mr. Hakeem Robinson, Mr. Abdul Robinson, and Raekwon Howard. Is that correct?
Yes, Judge.
All right, and there were objections to this yesterday.
In regards to Raekwon Howard, Your Honor, Raekwon Howard is not going to be held.
Correct. Relevance is the objection on behalf of Mr. Whitaker. And so let me address that first. How is it relevant?
Yes, Judge. On Hakeem Robinson's Instagram account, right before the murder, there are video call events to the account that has been identified as Raekwon Howard's. If you recall, testimony from Dominic Warner indicated while in the vehicle Hakeem Robinson made an Instagram call to Raekwon Howard. And so that is reflected in those records, both for Hakeem Robinson's Instagram account showing the calls taking place, the video events. And then what we are seeking to introduce for Raekwon Howard is simply the account number. It has the target account number, and it has his email address, raekwonhoward4@gmail.com. But the target number that identifies the account is what links up to Hakeem Robinson's Instagram records. Because you can change a vanity name for the accounts, but that target number remains the same. And it is the same number that matches up to Hakeem Robinson's video call to Raekwon Howard.
Okay. Then as to Leroy Whitaker and the objection for relevance, that will be overruled. As to Hakeem Robinson, objections?
So, Your Honor, I'm going to say relevance as well, but also this is what my issue is going to be. They are going to put this detective on his back. Now, I know that Mr. Cooper just said, remember, Dominique Garner said this. I cross-examined him on that because this is an issue we raised with the Richardson hearing. Because the first time we're hearing of Dominique Garner's mouth about that supposed phone call was on the witness stand. Now, when I cross-examined him, I asked him, do you know who Raekwon Howard is? And he said no. Then I said, are you sure it was an Instagram account? An Instagram account? Oh, no, I'm not sure what kind of call it was. So that is a testimony from Dominique Garner as it relates to that call. That I don't want Detective Smith, who is not a cell phone expert, if he can lay the foundation saying, I obtained these records, they came to me. He is in no position to testify as to, well, this number when it comes to Instagram means that you can change this and this. That's not appropriate for his testimony. He can't testify. He can bring out, I got this email address, I subpoenaed these records, and on these records has the same email address. He cannot testify, not calling Raekwon Howard, that that was my account. They can make whatever argument that the name is the same, but apart from that, he is now going to be overstepping his boundaries. He is now going to be making, I think he even brought this up with him in Devil, about you are in no position to be testifying about how Instagram works. You are not going to be able to testify that Raekwon Howard has multiple accounts, and the reason I know that is because there is this phone number that's beyond the scope of his testimony.
Okay, are you, state, intending to go in that direction? In other words, asking him those types of questions to which he may not have the expertise or personal knowledge of Instagram?
As it relates to how the target identification number works, if you look at the actual records, So for example, turning to Hakeem Robinson's Instagram records, and for counsel, it's page 6677 in the binder, if you would like to look at it with me. It shows the video call events, and it tells who the author is, who the recipients are, and then next to the vanity name in parentheses contains the target number. So that identifies it. And then when you go to the actual subscriber account information that was received from Instagram, it contains, on the very first page, Instagram target number. It's the same target number. So that's how the two are linked up.
Well, certainly, and that's an argument you can make in closing. My question is, in terms of questioning the detective about the records he received and what it says, how much further beyond that are you intending to go?
I'm not. I intend to have him say, I reviewed the records from Hakeem Robinson's Instagram. I saw these video call events. Based on that, I sent a search warrant to the received accounts information for Instagram, which I got back was Raekwon Howard, based on here's the target number, here's the email address, and that was the account that I know received that video call based on the target number.
All right, let me stop you for a second. Defendant Whitaker needs a restroom break, so we're going to let him go. He doesn't need to be here for argument involving Robinson, so he can go ahead and go to the restroom. But we won't address any other matters involving Mr. Whitaker until his return. All right, so with that, I understand the objection. Is there any other objection?
I have no problem with all of Mr. Cooper's questions until that last question, where he says, that is how I know that that is how it's linked. You only know that because Instagram, whatever research you've done on your own, tells you that.
I'm sorry, what's happening?
She's ready to move. I got her, the juror.
Oh, okay. Then let's let her cross over.
If it's kind of low and you can't hear it, they're basically arguing about Doug, I think his name is Doug Howe's testimony. He's going to be the one that's going to bring in they're going to bring in some Instagram posts through him. And the defense is basically arguing that he's not an Instagram expert. And so he cannot validate the owner of the accounts. And so that's what the argument is about.
And
And what I was saying is that final opinion, which is him saying, that is how I know that this account is linked to this. That is improper opinion recommended by a detective who is not qualified as an expert, relying on things that he knows outside the scope of his knowledge. He can say, and they can make, like exactly what you said, Judge, they can make their arguments and their connections to closing. But to have the lead detective on this case, when I'm sure they're going to try to do a narrative, then make an opinion that this is somehow connected, like through Instagram, this is how Instagram works, so that means that these are together. That's my goal.
all right, and I understand the argument. I think what I'll need to do is listen to his testimony in totality to determine whether it is beyond the scope of his personal knowledge or experience. You may, of course, make your objection at the appropriate time if you believe a particular question is so beyond his knowledge or experience. But as to relevance, as you heard me state with Mr. Whitaker's counsel, I am going to overrule. And then in general, and I don't recall what other objections were made to this yesterday, but of course, this being a business record, it is an exception to hearsay. The overall documents under 90.803 subsection 6, a business certification, as I understand it, was provided to the parties. So that the availability or unavailability of Mr. Raekwon Howard as a witness is immaterial, as long as the authentication has been completed under 90.902.11, which, as I understand it, was in this case. So the records will be admissible and subject to the beyond the scope exception or objection. I'll hold off on ruling on that until the actual testimony of the witness. All right, so we've got our juror present. We'll await Mr. Whitaker's return. Anything else we need to take up from the state involving Mr. Robinson? Anything else from Mr. Robinson? Okay, then we'll just wait for Mr. Whitaker's return, and then we'll bring the juries out to get started.
Okay, so she basically ruled that the Doug Howe, whoever he is, with the personnel issues is going to be able to talk about Raekwon Howard's Instagram account, and he's going to be able to say, this is how I knew that this account belonged to that person. So she ruled on that. It's still up in the air if Queso's mother is going to be able to get up and rebut against Abdul Sr.'s identification of Queso inside of that video. Their argument basically ended with the defense saying, like, yeah, we are supposed to provide our rebuttal witnesses or our witnesses ahead of time. We did provide them in one place, but when that door was open, we didn't know the door was going to be open because we kind of basically had already kind of talked about it.
Yes.
And him using that video, there's case law against him being able to say that this is this person to make an identification because he was not there. So the judge is taking it under advisement. She's telling them that they need to find some case law to support that. And I guess we'll find out if Queso's mother will be able to testify after lunch. So the juror has arrived from her car accident and she's going to serve. So whenever Scotty gets back from a lunch break, they're going to bring in the jury so that we can begin trial.
Is this exactly the same as the case that we?
Sorry, I didn't hear you.
Is this exactly the same as the bonders that we reviewed yesterday?
Yes, and Tara is in the building today. So Shay, what I think I'm going to do is push out another video about Chris Brown and the testimony that I just seen in the transcript about Chris Brown, because is Chris Brown the shooter? Who the shooter? I need to find a picture of the car. So if anybody has a picture of the car, DM the car to me or text me if you got my number. Also, if you're new here, make sure that you subscribe to our channel, hit that like button, hit the like button, push our video out there, and say hi, jump in the chat.
All right. We are back on the record. Both defendants are present with their attorneys as our counsel for the state. Now we do have all members of both juries present and accounted for. Are all sides ready to proceed?
Yes, Judge.
Yes, Your Honor.
And for Mr. Robinson?
Also, I want to say thank you to our new subscribers. We jumped like 20
Let me ask,
subscribers this
as
week.
I will every morning and as I have so far, whether during this overnight recess any of you inadvertently watched, read, or listened to any television or newspaper stories that may have been printed or aired about this case. If so, please raise your hand. All right, I see no hands raised on either jury. And has anyone attempted to speak to you, approached you, shared information with you about any issue involved in this case or the people or places involved in this case? If so, please raise your hand. And I see no hands raised from either juror. And lastly, have you all shared your thoughts, feelings, opinions about anything having to do with this case with anyone else or with each other? If so, please raise your hand. All right. And for the record, I see no hands raised. All right. I do want to apologize for our late start, ladies and gentlemen. It was unavoidable, but we are ready and set to go here this morning, and we will continue with the state's case in chief. And so at this time, I'll call the state to call upon its next witness.
Sergeant Smith.
All right, sir, if you'll come forward and be sworn. If you'll have a seat there, and please sit up close to the microphones and speak loudly and clearly so you can be heard by all. You may proceed.
Thank you. Would you please introduce yourself to the jury?
I'm Sergeant Christopher Smith with the Jacksonville Sheriff's Office.
And how long have you worked for the Jacksonville Sheriff's Office?
Since April of 2014, about 11 years now.
And what's your current rank and position at the Jacksonville Sheriff's Office?
I'm a sergeant in the Robbery and Violent Crime Unit.
Now, prior to becoming a sergeant in that unit, were you working as a homicide detective?
I was.
And were you working in that capacity back on January 15th of 2020?
I was.
And on that date, did you get dispatched to the shopping plaza located at 7001 Merrill Road in reference to a homicide investigation?
Yes,
And that's in Duval County, Florida?
it is.
And do you recall around what time you were dispatched to that location?
It was about 11:49 a.m.,
And do you remember when you arrived?
12:18.
What day of the week was January 15th, 2020?
It was a Wednesday.
What was the temperature like outside that day?
High 70s.
Now, how was the homicide at that location actually reported to police?
Several 911 calls.
When you got to the shopping plaza, were other officers and patrol officers already on scene?
Yes.
And had they already worked to ensure that that scene was secured?
Yes.
Now, because you were dispatched to that location, were you the lead homicide detective?
Yes.
Were you working that investigation alone?
No.
Can you kind of briefly explain to the jury how homicide investigations work?
So the homicide operates in 6 teams at that time, 6 teams of 4 detectives. We work through a rotation, like a batting order. We just cycle through. Typically, the 4 members of the team would be dispatched through it, but we got, I believe, 2 murders around the same time. So the other half of that team went somewhere else, and we needed other detectives from the office to come and assist.
What was the end of 2020 in your investigation?
Charles McCormick.
And around what time did that murder take place?
Before 11 a.m.
That had been shortly before 11?
Yes.
When you got to the location, was Mr. McCormick's body still on the scene?
Yes.
And where was it located?
On the sidewalk near the Express Employment, between I think it's a Baptist Primary Care.
Did you notice any visible signs of damage to that area or the surrounding area?
Yes, there was a bullet, appeared to be a bullet defect on the glass of the Express Employment, and then the sidewalk had also been hit several times.
Were there any shell casings located at the scene?
Yes, 11 .223 caliber shell casings.
And was a crime scene unit requested to respond to actually help process that scene, photograph it, collect physical items of evidence?
Yes.
And was that Detective Dunn, was that the lead detective?
Yes, she was.
Now, as the scene was being processed, did you and other detectives that arrived interview potential witnesses who were on scene?
We did.
Now, did you personally interview Victor Kruger?
I did.
And did Mr. Kruger have any evidence or information that was relevant to your investigation?
Yes, he witnessed the incident and had a dash cam.
That dash cam recorded the murder?
It did.
Were you able to watch that video while you were there at the scene?
Yes, we requested a technical support unit detective respond out, and he was able to allow me to view the footage. I think he took the SD card out of the device and played it.
So that a copy of that video could actually be recovered as evidence?
Yes.
Now, when you watched that dash cam video footage there at the scene as part of your initial investigation, did it assist you or provide you any investigative leads when you viewed it?
It did.
All right, and what was that?
Gave a description of the shooting suspect and the firearm used to shoot, and it also provided, sorry, that was later. I only watched the only clip of the murder at that time.
Did you later learn that it also captured a vehicle that was used?
I did.
Okay. And what type of vehicle was that?
Appeared to be a gray Nissan Altima.
When you were there on scene conducting your initial investigation, did you learn
where that Nissan Altima was located?
Yes, it was, it crashed on Townsend Road.
Had it been pursued by law enforcement?
Yes, it was pursued by Officer Jimmy Collins.
Now, when that Nissan crashed on Townsend Boulevard, were any of the occupants, the suspects inside, apprehended by Jacksonville Sheriff's Office?
No,
During this investigation, was Jacksonville Sheriff's Office still actively looking for those suspects from that vehicle?
yes.
Now, prior to leaving the Merrill Road Shopping Plaza, did you attempt to locate any other cameras or video surveillance that may have captured part of this incident?
Yes.
Did you find any other cameras?
Yes, we went to the Dunkin' Donuts that's right there. I think it's closed now. They had video surveillance which captured the parking lot where this took place.
Did you get a copy of that video surveillance?
Yes, we were told we had to go through their corporate, but eventually we did get a copy of it.
And have you viewed that video surveillance?
Yes.
Now, is the quality from the Dunkin' Donuts camera as good as Victor Kruger's dash cam?
It is not.
Can you briefly tell the jury what you observed on that Dunkin' Donuts video surveillance that assisted with your investigation?
You can see the victim park his car before he goes into the express employment business. You can see the gray Nissan park about a parking spot behind and a parking spot to the left of the victim's vehicle. After the victim comes out, you can see someone appear to exit that vehicle and then run up to Mr. McCormick.
Your Honor, may I approach the witness?
Yes.
Showing you what's been marked for identification is State's Exhibit 8F. Can you tell me if you recognize that disc?
I do.
And what is this copy?
It's a Dunkin' Donuts video.
And is this video fairly inaccurately depicting the footage of the Dunkin' Donuts in 2015?
Yes.
Your Honor, at this time, the State would seek to remove 8F from the evidence as the appropriate number exhibit.
Okay. Any objection from Mr. Whitaker and from Mr. Robinson? Okay, 8F will be marked into evidence as State's Exhibit 188.
Judge, may I publish?
Yes.
I want to play a couple clips from video surveillance. Tell us what we're looking at in this particular clip. It'll be on your screen.
All right. That's the victim about to back into that parking spot right there.
And then this next clip.
It appears the victim's going inside the express employment. You can see the gray Nissan Altima driving that way, coming, it's about to park. It's going to go out of frame for a few seconds and come back in. And there it goes. And it's going to park kind of behind the victim's vehicle, like I said, and a little bit to the left.
Is there an individual at the top of the screen that's walking?
Yes.
And who is that?
Appears to be Mr. Kruger.
Is that where his vehicle was parked?
Yes, the red truck there. And it appears the victim is exiting the business. At the same time, someone exits the passenger side of the Nissan and is starting to chase him down. As the Nissan and the trucker start to go forward at the same time. And it appears the person gets back into the Nissan. And they both take off in the parking lot.
After you finished your initial investigation and kind of walked through the Merrill Road Shopping Plaza, where did you go next?
After that, we went to the crash location of the Nissan Altima.
When you got there, were other officers still on scene?
Yes.
And was the search for the occupants of that Nissan Altima still in progress?
Yes.
Did that include the Jacksonville Sheriff's Office aerial unit, a helicopter also being routed to that area?
Yes.
Was there any type of alert sent out to the citizens in the surrounding area?
Yes, the Jacksonville Sheriff's Office sent out a kind of emergency text with a brief description of the suspect.
Now, in addition to officers looking for the occupants of that Nissan Altima, were other detectives investigating an active burglary to a home just down the street,
Yes.
specifically at 1033 Townsend Boulevard?
Yes.
And that was down from where that Nissan Altima had crashed?
That's correct.
Who was the reported victim of the burglary to Townsend Boulevard home?
Barbara Buckley,
And who was the lead detective assigned to that investigation?
Detective Richardson.
Now, based on the location of her home and the time frame of when that crime took place, did you believe it was possibly connected to your murder investigation?
Yes.
And with that in mind, did you and Detective Richardson stay in touch and kind of work the case together?
Yes.
Were you able to determine who owned the Nissan Altima?
Yes.
And who was that?
It was registered to an Ever Gooch Merritt. She has since passed away. I talked to her son-in-law.
Were you able to rule her and her family out as suspects in this case?
Yes.
How so?
The vehicle had been stolen in November of 2019.
And that was reported?
Yes.
Because that Nissan Altima was on Townsend Boulevard, did you request additional crime scene detectives to arrive to assist with documenting that and collecting any potential evidence once it could be removed from the scene?
Yes, the vehicle was sealed and towed to our evidence warehouse, where I later obtained a search warrant for it.
Now, did you, as well as crime scene detectives, participate in the search of that vehicle after you had the warrant?
Yes.
Was anything of evidentiary value found inside the Nissan Altima?
Yes, there are 2 firearms left inside the vehicle, 2 white shirts, and then several swabs were taken by crime scene.
Right, so did you request DNA swabs from the Nissan Altima,
Yes.
including the interior?
Yes.
Did you request that Nissan Altima, the car itself, be processed for any potential prints?
Yeah. Yes.
Were there any prints of value found on the exterior of the Nissan Altima?
No.
Were any prints of value found on the interior of the vehicle itself?
No.
Did you request any additional testing be done for any of the items you just mentioned that were collected inside the Nissan Altima?
Yes, the firearms were sent off for latent prints as well as DNA swabs. The shirts eventually went to FDLE for DNA testing, and then I sent several swabs for DNA testing as well.
Did you also submit the firearms, the Glock and the rifle that were recovered to FDLE so that they could be tested for operability and compared to any shell casings from the murder scene?
Yes.
And we'll come back to that in a minute, but did you also seek to find any potential video surveillance in the neighborhood of Townsend itself based on where that car was located and what happened to Ms. Buckley?
I did.
Were you able to find any video surveillance?
Yes, I was.
And did that include video surveillance from 1430 Townsend Boulevard?
Yes, it did.
And that's already in evidence, but what did that video surveillance reveal to you?
It depicted a orange Dodge Challenger driving down Townsend Road towards the location of the home of the 1033 Townsend Road. Sorry.
And why was that video significant to you?
Given Ms. Barbara Buckley's description of the vehicle the suspects left her house in, it matched.
And how many suspects were reported to be involved in her case?
2.
Did you find video surveillance from 1214 Timber Lane as well?
Detective Gibson did and requested our TSU unit respond over there, and the video was collected.
And that video is also already in evidence, but did you have a chance to review it?
Yes.
And what does that video depict?
It shows 2 individuals in dark colored clothing hopping fences in backyards.
And that would have been after the Nissan Altima crashed?
Yes.
And what about video surveillance from 1204 Belmead?
Yes.
And what did that video depict?
It depicts a male wearing a gray and black hoodie, running, and then a good, I can't remember the exact amount of time passed, but you can also see Officer Collins running that way as well.
Now, at the time that the individual in the gray and black hoodie was captured on a Bellmead video, was that the same time that the other two individuals were captured in the opposite direction on Timber Lane?
Yes.
Now, with regard to Ms. Buckley's investigation, were any items of evidence collected so that they could be submitted to FDLE for potential testing?
Yes, swabs of her neck and wrists were collected, and her clothing as well.
And was that submitted to FDLE for potential DNA testing?
Yes.
While waiting on those results, was Ms. Buckley that same day able to provide any information, description that assisted in identifying any potential suspects that day?
She was.
Right. And briefly, what was she able to provide that assisted in that?
She described a tattoo on one of the suspect's arm. It said 1993. I believe Detective Richardson conferred with our crime analyst unit and located a male matching that description. A photo spread was made from there.
So based on the location and the specific tattoo,
Yes,
the general characteristics, was that photo spread presented to Ms. Buckley?
it was.
And were you made aware of the results of that photo spread?
Yes, she picked out Dominique Barner as a suspect who entered her home that day.
And based on that, was an arrest warrant for Dominique Barner obtained that same day?
It was.
And was Dominique Barner arrested on that arrest warrant on January 15, 2020 in the evening?
It was, along with Janera Smith.
When Dominique Barner was taken into custody on January 15, 2020, did you observe any tattoos on his body matching the description that Ms. Buckley provided?
I did.
And were those tattoos documented?
Yes, a crime scene detective responded and photographed him.
Your Honor, may I approach again?
Yes.
Going with the mark for identification as state 7Z, 8A, and 8B. And tell me if you recognize the photograph.
Yes.
And what are those photographs?
Those are photographs of Dominique Barner. Tattoo on his right arm that says Butta, which is his nickname, and a tattoo on his left arm that says 1993. Yes.
Okay, any objection from Defendant Whitaker? And from Defendant Robinson? Okay, then, thank you. State 7Z will be marked into evidence as number 182. 8A will be marked into evidence as 183. And 8B will be marked into evidence as 184.
And may I publish, Judge?
Yes.
Detective, or sorry, showing you states 182. Who's depicted in that photograph?
Dominique Barner.
States 183, is that his right forearm?
Yes.
And then states 184.
Yes. That's his left arm, shows 1993.
After Dominique Barner was arrested for the crime against Ms. Buckley on January 15, 2020, did you continue your murder investigation?
Yes.
Was the Jacksonville Sheriff's Office latent print unit able to examine the firearms you submitted for potential prints from that Nissan quickly?
Yes.
And in fact, on January 16th of 2020, were you made aware of some of those results?
Yes.
Now, based on the results, did you have an investigatory lead that led to another potential suspect associated with the investigation?
Yes.
All right, and what was that?
There was a print found on the Glock handgun that came back to a Hakeem Robinson.
Were there any prints of value found on the rifle?
No.
Now, do you see Hakeem Robinson in the courtroom here today?
I do.
Can you please tell us where he's seated and what he is wearing?
He's on the second row in the middle, wearing a beige suit, glasses.
Your Honor, if the record will reflect, he's identified Hakeem Robinson.
All right, the record shall so reflect.
Were you able to get DNA results back on January 16, 2020 as well?
No.
So unlike TV, does it take some time for FDLE to process DNA submissions and to get those results back to you during an investigation?
It does.
Now, on January 16, 2020, based on the evidence from the Nissan Altima and the information Ms. Biden, were Dominic Barner and Hakeem Robinson both considered suspects, potential suspects at that time?
Yes, at that time.
Now, excuse me. In March of 2020, did you learn from FDLE that some of the DNA testing that had been requested in Ms. Buckley's investigation, the swabs from her neck and wrist and the clothing, that testing had been completed?
Yes,
Was Dominic Barner's DNA found on any of those items?
it was.
And was there any other DNA identified that provided you with another lead to a potential suspect?
Yes, there's DNA that linked back to Leroy Whitaker.
And where was that recovered from? Do you recall?
Her pants.
Based on Leroy Whitaker's DNA found on Ms. Buckley's pants, was an arrest warrant obtained for Leroy Whitaker in relation to Ms. Buckley's crime?
Yes.
And when was Leroy Whitaker arrested on that arrest warrant?
It was April 6th of 2020,
Where was Leroy Whitaker located when he was detained on that?
East Point, Georgia.
And so did the East Point Police Department detain him and serve that warrant for the Jacksonville Sheriff's Office?
Yes.
Was anyone else with Leroy Whitaker when that arrest warrant was served on him?
Yes.
All right, who was with him?
Hakeem Robinson, Abdul Robinson Sr., Abdul Robinson Jr., Malquise Worthen, and Torgon Williams.
Was Leroy Whitaker then brought back to Jacksonville?
Was.
And do you see Leroy Whitaker in the courtroom here today?
I do.
Can you please tell us where he's seated and what he is wearing?
He's in the front row wearing a gray suit, red shirt, looks like a gray bow tie.
Your Honor, if the record will reflect.
All right, the record shall so reflect.
During your investigation, did you later receive additional results from FDLE regarding the shell casings collected from the plaza where the murder took place?
I did.
And what did you learn regarding those 11 shell casings?
Obviously, they're .223 caliber, but they did not knight him back to the handgun or the other rifle.
So were the Glock and the rifle that were recovered from the Nissan Altima excluded as having fired those?
Yes.
Did you ever locate the actual murder weapon?
I did not.
Later, did you also get DNA results back from FDLE regarding the testing of the interior swabs of the Nissan Altima?
Yes.
Did that DNA testing also provide an additional investigatory lead regarding potential suspects?
Yes, the swab from the driver's compartment came back to Hakeem Robinson, as well as a mixture of other people.
Now, what about the two white shirts that were recovered from the Nissan Altima? Did you also get notified of the FDLE results regarding DNA on those shirts?
Yes.
And did that include DNA from both Leroy Whitaker and Hakeem Robinson?
Yes, and it included a hair from a Shefton Hogan.
So once you were made aware of a hair whose DNA matched Chiffon Hogan,
I'm saying his name correctly, I'm sorry.
maybe me, did you attempt to investigate him in any way to determine whether or not he was a suspect?
Yes.
And were you able to actually speak to him?
Yes,
Did you also identify a phone number that he was using at the time?
I did.
And do you recall what that number was?
904-240-5517.
Did you request cell phone records associated with that specific phone number?
Yes.
And did that include cell site information and location?
Yes.
And did you request to have that information mapped by the FBI CAS unit to determine where that device was located at relevant times?
Yes.
And based on those results, was Chiffon Hogan ruled out as a suspect?
Yes.
Are you familiar with an individual named Chris Brown?
Yes.
Did you ever receive any investigatory leads from FDLE regarding DNA testing from the Nissan Altima or any of the items within it identifying Christopher Brown?
No.
What about Torgon Williams?
No.
Their DNA is in the system that FDLE has access to? Objection, Leader.
All right, sustained if you'll re-ask the question.
Are you aware of whether or not Christopher Brown's DNA is in the system for FDLE to access?
Not that question, overruled. The Question is he aware, yes or no?
Are you aware of that?
Yes, I performed a CODA search for their DNA. It is in the system.
Objection, strike, hearsay.
Okay, I'll sustain on hearsay.
You're,
I'll ask the jury to disregard that last answer to that last question. We don't strike anything, we just ask that they disregard it.
sorry, Jay. During your investigation, because you are aware of who Christopher Brown is, did you attempt to verify whether or not his DNA had been collected in any other cases?
Yes,
Okay. And had that been done?
I have been.
And were you, again, just to be clear, did FDLE ever submit to you any investigatory leads regarding DNA recovered from the Nissan Altima or any of the items inside matching Christopher Brown?
No.
And the same for Torgon Williams?
Yes.
During your investigation, did you also attempt to identify social media accounts that belong to Hakeem Robinson?
Yes.
Did you find any?
Yes.
And do you recall what his Instagram account was?
It's Queso 23X.
Were you able to view some of the content on that Instagram account very early on in your investigation?
Yes.
Very early on, day of and the days leading after McCormick's murder, did you see anything that you believe to be relevant to your investigation posted to that account?
Yes.
And what did that include?
It included, there's a small child singing the song. That was about the day of the murder. And then on, I think it was the 19th of January, the victim was posted. And the caption, or the text that was over it said bye-bye. And then I think a day later, there was a video of someone in a salon getting their, looks like a pedicure, with the caption, "Kill a nigga and get my toes."
Was there also an Instagram live video that you observed?
Yes.
And, Your Honor, may I approach again?
Yes?
Showing was the mark for identification statement with 8L.
Yes.
And what is that about?
The child singing.
The date of January 2020? And did you make a copy of that recording?
I did.
All right, is that a near an accurate copy of that? What is that?
It is the video of Mr. McCormick on bye-bye.
And did you make that recording?
Yes.
I'm also going to show you 8 and just take a moment until we recognize those.
Uh, 8M appears to be the nail salon video with the text saying, "Kill a nigga and get my toes done." 8N appears to be the live video from the Queso 23X account.
And you were able to make recordings of those when you observed them?
Yes.
And these are all fair and accurate? Your Honor, this now seems to introduce each of those items as evidence of the
All right, any objections from Mr. Whitaker? Any objections from Mr. Robinson? All right, then we'll begin with 8L. That will be moved into evidence as number 194. Okay, thank you. 8M will be marked into evidence as 195. 8N will be marked into evidence as 196, and 8O will be marked into evidence as 197.
I'm showing you what is now in evidence as State's Exhibit 197. Can you tell us what we're looking at here?
It's a live from the Queso 23X Instagram.
And why was this video significant to you?
The sweatshirt he's wearing.
It's queso.
screen, is that the Queso 23X Instagram account icon, I guess, that you can see at the top of that where that's being filmed?
Yes.
And you said that the clothing was significant. Why was that clothing significant? What was that based on?
It is very similar to the clothing seen worn by the shooting suspect.
Page 194. Is this the music video that we just talked about that was posted on January 15, 2020?
I'm sorry?
January 15, 2020, is this the Instagram story video that you recorded on January 15, 2020?
Yes.
Are you familiar with that song?
I am.
Who's the artist that recorded that song?
Young and Ace.
What's the title?
Queso Homicide.
And states 196.
Yes, that's the victim in the purple shirt, as was posted to the Queso 23X Instagram account, like I said, with the caption, "Bye-bye." That appears to be a snippet from the Bang It Out music video.
And then lastly, states 195.
This is the pedicure, and then you see Kill a Nigga.
Overruled.
So that last video was posted on January 20th of 2020?
Yes.
Based on that information, the videos we just discussed and that everyone got to see, did you attempt to get a search warrant, or did you get a search warrant for the Instagram records associated with the Queso 23X account?
I did.
And were you also able to identify an Instagram account for Leroy Whitaker?
Yes.
All right. And do you recall whether or not you were able to identify an Instagram account for Abdul Robinson Jr.?
Yes.
Oregon Williams?
Yes.
How were those accounts verified by review of those individual accounts that you were able to make yourself?
Yes.
All right. And by reviewing those Instagram accounts, were you able to see photographs and videos associated with the account and the usernames?
Yes.
All right. And based on that information and other information you gathered during the course of your investigation, did you submit search warrants to obtain records for each of those accounts?
Yes.
And did you receive those records?
I did.
And were you able to review the Instagram records for those accounts?
Yes.
Did a review of those Instagram account records assist you with identifying phone numbers being used by those individuals at the time?
Yes.
In addition to identifying phone numbers, when you reviewed Hakeem Robinson's Instagram account of Queso23X, did you see any communication on there on January 15, 2020 that caused you to seek the records of an additional account?
Yes.
And were you able to identify the target number of that account that that communication was made with?
Yes, I was able to find the target account, which is the Instagram ID number.
Okay. And did you submit a search warrant to get that account information?
Yes.
And did you receive that?
I did.
And, Your Honor, if I may approach one.
I'm sorry?
Yeah, approach one more question.
Yes.
Showing you 9S for identification, take a look at this binder. Tell me if you recognize what's contained in that.
Yes. It's certified business records from Meta or Facebook. It is complete with the usernames, IP addresses, registration information for the accounts for Hakeem Robinson, Raekwon Howard, Euro Whitaker, and Abdul Robinson Jr.
Yes, any objection from Mr. Whitaker?
Just those prior stated.
And any objection from Mr. Robinson?
As to the second item, Your Honor, as to the identity of the owner of that Meta account.
Okay. And understanding those objections, I'll overrule, and at this time, States 9S will come into evidence as 227.
Sergeant, I'm showing you page 1 of the Instagram records for one of the accounts. Do you recognize this?
Yes.
All right. And who is the registered email address for on this account?
RaekwonHoward4@gmail.com.
And at the top of the page, there's a column that says target. Is there a number next to that?
Yes.
Now I'm going to, still part of stage 227, but this is a different account, page 1 for, do you see the target number as well as the account name underneath that at the top of the page?
Yes.
And whose account is this?
It's the Queso23X as Mr. Hakeem Robinson's Instagram account.
Now further down the page, there is a registered email address. Do you see that?
Yes.
And did you take note of that?
Yes,
And did that come into play later in part of your investigation?
it does.
And specifically, what did you do regarding that email address?
I looked at it compared to the phones of Mr. Robinson.
Were you able to obtain Apple records associated with that email address?
Yes.
And did that lead you to one iCloud account?
Yes.
And did you obtain records for that iCloud account associated with that registered email address?
I did.
Going to page 2 of the same account, is there a phone number associated with it?
Yes, it's the 904-704-1595 number.
I'm going to go to page 2353 of the same account. Do you recognize this?
Yes.
All right. And can you tell us what is depicted in the text at the bottom of that page?
RIP, big brother, you know I stood on all 10 about you. There's some emojis or something, and then it says it's been a year.
Now, did you find a corresponding photograph for that text on a cell phone belonging to Abdul Robinson Sr.?
Yes.
And who was depicted in that photograph?
It's the graveside of Willie Addison.
Do you see the upload IP address associated with this?
Yes.
All right. And did you take note of that when you viewed this account?
Yes.
And we'll come back to that in a second. Still part of stage 227, page 2049. Do you recognize that?
Yes.
Overruled.
2050. You see the photo ID at the top of that page?
Yes,
All right. Is that photo ID for the image that was on page 2049?
it is.
And does this upload IP address exist for this image as well?
It does.
And does this also contain information showing when that image was posted?
Yes.
And is that consistent with the video we just saw moments ago when you downloaded it on January 20th, 2020?
Yes.
This is just in UTC time?
Yes, sir.
Page 2155 of the same account, does that indicate a photograph including text at the bottom?
Yes.
Right. And what is the text?
We don't play.
Right. And you also have the upload IP address associated with that.
I do.
And when was this photograph uploaded?
UTC time, it's January 5th of 2020.
The next slide, is that the photograph associated with that text and photo ID from the previous page?
Yes.
The next slide, 2145, is that another photograph that was contained on that same Instagram account?
Yes.
2143, another image.
Yes.
And 2144, that photo ID at the top, is that for the previous photograph we just looked at?
Yes.
And does it contain the same upload IP address as the other images in the nail salon video?
It does.
Now going to page 6677. You recognize this page?
I do.
And can you just tell the jury briefly what's the significance of this page and what you see on it?
So if you look at item type, it says video call event. It says it's between one RPG Poppy. You have to look at the target ID. You'll notice it's the same as the one for Raekwon Howard, and then the Queso 23X account.
And when were those video calls taking place?
January 15th of 2020.
Does it show a time?
It does. It's 15:53.
That UTC time?
It is.
And so would that be 10:53 a.m. in Eastern time? When was the murder again?
I'm sorry, it was January 15th around just before 11.
Showing you a different Instagram account. Do you see page 1 on this, sir?
Yes.
All right, and who is the account name at the top of the page?
It says Aki Scotty.
Is there, going to the next page, a verified phone number for this account?
There is
And what is that phone number?
904-803-3671.
Next page, is this also part of that same Instagram account?
Yes.
And what's the significance of this photograph?
Depicts Mr. Whitaker.
And then page 278 on this account, does that just reflect the information associated with the image we just saw a moment ago?
Yes.
And then page 437, are these a series of messages
Yes.
in that account? And how is reviewing some of these messages, how did that assist you in your investigation?
Verifying phone numbers. If you look, there's a message between the target account and a Big Wani 64. He asked, "Shit, what's your line?" That person, the account holder, then replied, 904-803-3671.
Can you actually circle that on the screen?
Sorry. It is these two texts, specifically right here and right here.
And then page 1057, the same thing?
Again, you see the target holder talking to underscore KEKAOIR. And basically, right here, you see a message where it says, "Laugh my ass off, we will FaceTime you later." There, and then they reply with this number here. Again, it's the same 904-803-3671 number.
Now, this message is on January 31st of 2020.
Yes.
The prior message was that in December of 2019?
If you could go back, I could tell you, but I believe it was before.
Yes, do you see it there?
Yes, it was December 19th of 2019.
So that same phone number was being given out on December 19th of 2019 and then again at the end of January 2020.
Yes.
Abdul Robinson Jr., you indicated you identified an Instagram account. Do you recognize page 1?
I do.
The account name for this account?
It is KKRAXY, and the name is Crazy K.
Is Abdul Robinson Jr., does he have a nickname
Yes.
that you're aware of? And what is it?
Kareem or Crazy.
Page 436. Can you tell the jury what we're looking at here? And you can circle it on the screen.
You're looking at messages between the K Crazy account and various people. There's one message from the author that says, "Send me your number." It's right here. And then
437, is that a continuation of that same communications?
yes, you can still see the veto 4.0.
And then going to 438, what do we see?
The continuation of the conversation, and eventually the author of the K Crazy account sends a phone number at the very top right here. It is a 904-624-3684 number.
And then page 694.
Same thing, you see the K Crazy account talking to Queen of Diamonds, but it's spelled differently. At the end, at the bottom there, she asks, "What's your number?" Oh,
Sorry about that.
sorry, right there. "What's your number?"
And then on 695, do we see that number?
Yep, and then he replied here with a 478-491-2831 number.
Going to page 1172. Midway.
Again, you see the K Crazy account talking to a beautified tip, is what it says. And the author sends a message, or the K Crazy account sends a message. "You can tell old boy to call me at 904-624-3684, right there.
And is that on January 4th of 2020?
It is.
$11.16 of the same Hey Crazy Instagram account. You recognize this page?
Yes.
And is this the data associated with a video file that you found on Instagram, on this Instagram?
Yes.
And is this that video file?
That is it.
Based on your review of the Instagram records you received, did you also identify a phone number for Torgon Williams?
I did.
Do you recall what that number was?
It's 305-321. I can't remember how it ends.
0896, does that sound familiar?
It does sound familiar.
That number that you identified, did you ultimately get cell phone records for each and every one of those numbers?
Yes.
All right, so the number associated with Hakeem Robinson, his Instagram account, Leroy Whitaker's, and Abdul Robinson Jr.'s,
Yes.
in addition to Torgon Williams?
Yes.
Did you then receive from the cell phone carriers for each of those numbers subscriber information, call detail records, cell site location information, data files, if available?
Yes.
Did you find anything in your review of those records that connected Chiffon Hogan to this investigation?
No.
Based on his cell phone records and where that device was located, was it anywhere near the shopping plaza at the time of the murder? Or Townsend Boulevard where the Nissan Altima was located?
No.
Was there any communications from his cell phone records that you found connecting him to any of these suspects?
No.
I want to show you demonstrative aid states 10F. The cell phone records are currently already in evidence, but I just want to go through some of the information that's been provided for these phone numbers for the jury. And so this is essentially a color legend. Do you recognize that?
Yes.
All right. And are these cell phone records that we're about to look at color-coded?
Yes, they are.
And is that just for ease of reference for the jury as you're explaining some of these?
Yes, because there's there's various numbers, and it's hard to keep track of whose number whose.
And all of the records are actually on disk and evidence for the jury, but at this point, just for ease of reference, we're going to go through some of those selected phone numbers and the calls, okay?
Overruled.
Start with phone number 478-305-9583.
Okay.
And actually, before we go into that, can you explain to the jury how you identified this specific number?
So while going through the Instagram account of the Queso 23X account, I observed several IP addresses. I subpoenaed the IP addresses to various phone carriers. The phone carriers returned the 478-305-9583 number, and I then did a historical cell site warrant for that number and got, I believe, data records.
Now, the IP address that you referenced, that you noticed and caused you to send that subpoena request in, that then identified that phone number, was that the IP address we referenced a few moments ago associated with the upload of the nail salon video and image,
Yes.
as well as the images of Hakeem Robinson and Leroy Whitaker together on January 4th of 2020?
Yes.
Now, once you identified the 478-305-9583 number, did you also request records from Apple associated with that account?
I did.
And did you identify an iCloud account associated with that specific number?
I did. It was a House of Pain 904.
And was the 478-305-9583 number, how was that connected to that account?
So, I don't know who has an iPhone, who doesn't. So whenever you set up an iPhone on your iPhone, it asks for an Apple ID. Typically, it's an email address. In this case, it was the House of Pain 904.
Was the 478-305-9583 number the verified number for that account?
Yes.
So starting with the 478-305-9583 is the subscriber information that you received back from T-Mobile related to that specific number.
It is.
And who is the subscriber name for this?
Is a Daryl Watts.
And when's the activation date?
Activation date is 11/12/2019.
Next slide, can you tell the jury what we're looking at here that is highlighted?
So the two highlighted portions, you'll see the calling number is that 478-491-2831 number.
Sorry.
There's two calls on January 15th.
And the time frame, it says 14:13:46 and 14:26:29. Is that in UTC time?
It is.
So would you have to subtract 5 hours to get it in Eastern time?
At that time of the year, yes.
And so that would make it, what time? Actually,
Around 9:13 a.m.
I'll keep that account for a moment. Going to 904-704-1595. That's the verified number for the Queso 23X Instagram account.
It is.
And who is the name associated with the subscriber information for that phone number?
Ebony Walters.
The next slide associated with this account, can you explain to the jury what we're looking at in terms of the highlighted portions at the top and bottom?
You'll see two phone calls, one on January 15th, another one on January 17th between the 904-704-1595 number and then the 904-624-3684 number.
And so the 904-624-3684 number, based on Instagram records, you believe to be associated with who?
Abdul Robinson Jr., sorry.
All right, and so that's a very brief call, but that's on January 15th, 2020, and it looks like just after midnight?
Yes.
Now, the next series of slides, still associated with 904-704-1595, do these depict the data usage for that phone on January 15th, 2020?
It appears to, yes.
And does it appear to be fairly consistent data on that phone beginning just after midnight through the bottom of the columns on this page?
Yes.
And that takes us to about 5:08 a.m. on January 15th, 2020?
Yes.
And then next page, columns 26 through 33, that continued data activity.
Yes.
And then the next slide, 34 through 42, again,
Still activity, yes.
next slide, 43 through 53. And let me go back actually to the prior slide. It ends at 42. What's the time for the last activity for this phone on January 15, 2020? Slide.
12:11.
So that would have been approximately 7:11 a.m.
Yes.
And then the next slide, the data activity begins at what time?
18:10,
Right, so that would have been approximately what time?
1:10 in the afternoon.
So from just after 6 to 1:10 in the afternoon, no activity as reflected in these records.
As reflected in these records, yes.
Going to phone number 478-491-2831. Do you see the subscriber name associated with this account?
I do.
And what is that?
It is Daryl Watts.
The 478-491-2831 number, where was that identified as in Instagram accounts?
It was identified as Junior's number, one of his numbers.
Abdul Robinson Jr.'s?
Sorry, yes.
And so is this under the same account information as the other 478-305-9583 number?
Yes.
What's the activation date for this phone number?
11/12/2019 as well.
So is that the same for both 478 area code numbers?
Yes.
And can you tell the jury what we're looking at here on this slide?
We are looking at 2 phone calls at the very top between the both 478 area code numbers, and then after that, there's a phone call between the 904-624-3684 number and the 478-491-2831 number. And then in the middle, I think it goes to voicemail of some sort, but I guess they intended to call that number. So,
Now, going to a different phone number, 904-624-3684. I believe you already indicated that was Abdul Robinson Jr.'s number.
yes.
This is the subscriber information for that number.
The account name is J Brown with an account effective date or activation date of 10/24/2019.
That's the same number that was given out in his Instagram account.
Sustained.
Is that the same number?
Yes.
All right. Going to the next slide, can you tell the jury what we're looking at? Are these call detail records?
Yes, they are called detail records. The highlighted red line appears to be a phone call between Mr. Robinson's 904-704-1595 number and the 904-624-3684 number.
And what time is that?
It's January 15th, 2020 at, that's 5:24.
Is that in UTC time?
It is, sorry.
You can have to subtract 5 hours.
So it's about midnight 24.
The next slide.
At the bottom, you'll see the 2 in the green, that's 904-624, which is Mr. Abdul Robinson Jr.'s number, calling the 702-918-4911 phone number, which belongs to Mr. Barner.
And what time is this call?
It is 9:42 UTC -5, about 4:42 in the morning.
And then the next slide, we have a lot of different colors.
Yes, there's various calls from the 904-624 number. In the green, you'll see it's again Mr. Barner's number. In yellow, it is Mr. Lear Whitaker's number. In gray is Torgon Williams, and I think that's everybody's numbers, but it's constant phone activity from.
For what's highlighted in green, predominantly those 1, 2, 3 calls at the top, what are the time frames for those calls?
That's 9:45 UTC or 4:45 in the morning, and then the last one is 10:26 UTC, which is then 5:26.
Now, the calls that are in gray, whose number was that again?
The phone number in gray belongs to Torgon Williams.
What time do those calls take place?
That call is at 10:48 or 5:48 a.m.
And does that continue to about 1,300 hours, I guess, in UTC time for Torgon Williams?
Yes,
And then there's an additional one at the bottom of the screen at 1619?
yes.
What about the calls in yellow? You said those were calls between Abdul Robinson Jr. and who?
Mr. Lear Whitaker.
What time are those calls predominantly taking place?
It is 16:04, so right around, I think that's 12, no, yeah. Or 11, sorry.
Going back to the top of the screen, though, what's the first call in yellow?
First call in yellow is at 10:48 or 5:48 in the morning.
And then a couple calls after that, shortly thereafter?
Yes, 11:01 to 11:08. You got 2 more calls.
And Then going, as I think you were just referencing a moment ago, the majority of the calls at the bottom that are in yellow are around what time?
16:04 to 16:19 UTC.
That equates till just after 11 a.m.?
Yes,
Does that continue into the next slide?
it does.
And again, are all the calls in yellow between Abdul Robinson Jr.'s number and the number you identified as Leroy Whitaker's?
Yes.
There's also a box in orange for at least one call. Do you see that?
Yes, the one in orange is between the 904-624-3684 and the 478-491-2831 numbers, which are both attributed to Mr. Abdul Robinson Jr.
Approximately when was that call?
That is at 16:54 or 11:54 and 11:55 a.m.
And then now we have boxes in blue.
So then in the blue, it is 904-866-2370, which is the primary phone number for Abdul Robinson Sr.
When did those calls begin to take place?
Those calls start at 17:20, so 12:20 in the afternoon.
And then the next slide, not as many highlighted, but who are those calls between?
Again, in the gray, we have the 305-321-0896 number, which is attributed to Mr. Torgon Williams. And then in the yellow, we have the 904-803-3671, which is Leroy Whitaker's numbers.
And approximately what time are those calls?
The call with Mr. Torgon Williams is at 19:34, so about 2:34 in the afternoon. And then the calls of Mr. Whitaker starts at 22:23, so that's 5:23.
For 904-803-3671, we don't have to go through all the calls, but is this the subscriber information that you obtained for that account as well?
Yes.
And then, just as a visual reference, what are all these calls?
Is a myriad of calls between the 904-624-3684 number and Mr. Whitaker's number.
So Abdul Robinson Jr. and Leroy Whitaker?
Yes.
Now, are these all on January 15, 2020?
Yes. Yellow, you have the 904-624. And then in blue, you have the 904-866-2370 number, all on January 15th, 2020.
904-866-2370 number that's in blue. Who did that phone number belong to?
Abdul Robinson Sr.
Based on a review of those cell phone records, the numbers that you identified, did you obtain, I guess, the historical cell site information and data files, if appropriate and available, and submit those to FBI, have them mapped to see kind of where those devices were located?
Yes.
Who was the agent that actually did the mapping?
Corley?
Was Agent Corley?
Yes.
Were you made aware of his results of mapping that data?
I've seen them, yes.
Did that assist you with your investigation?
It did.
Did it provide you with any indication of where your suspects, the people that you identified, were located?
Yes.
Right. Relevant to the areas and times appropriate in your investigation?
Yes.
And did it support the suspects you had identified?
It did.
Well, to leading, it's overruled, and improper corroboration, what was the question? Did it,
I asked if the results that he was given by the FBI in terms of mapping, did that assist him with his investigation and corroborate what he was doing?
Clarification, bolster.
overruled?
You can answer.
Yes, it did.
Now, when Leroy Whitaker was detained in Georgia, were there any cell phones that were actually collected by the East Point Police Department as well?
Yes.
And were there multiple cell phones?
Yes.
During your investigation, were you able to eventually take possession of those cell phones and bring them back to Jacksonville?
I was.
And did you obtain search warrants authorizing you to attempt to download those devices?
Yes.
Now, is that something that could be done relatively quickly, or does it sometimes take time?
Sometimes it takes time.
Did it take time for some of the devices in this case?
Yes, I think the last one broke earlier this year.
And is that because you did not have the password or code to get into the devices?
That's correct.
And who actually would have done the examination of the devices that you submitted?
A computer forensics analyst or detective.
Okay. Now, the phones that they were able to get into, were you provided a copy of the data obtained from those cell phones?
Yes.
And did you have an opportunity to go through the data associated with those devices?
Yes.
Was a phone that was using 904-803-3671, the phone number you identified as being used by Leroy Whitaker, was that phone ever found?
No.
Was a cell phone for 478-305-9583 ever found?
No.
Did you recover a cell phone that was using phone numbers identified as belonging to Abdul Robinson Jr., the 904-624-3684, as well as the 478-491 and 2831?
Yes.
Did you also identify a phone using Abdul Robinson Sr.'s number, 904-866-2370?
Yes.
Were any phones that were being used by Hakeem Robinson identified?
Yes.
For what phone number?
It was the 904-704-1595 number and the 904-704-8910.
And was the account for the 904-704-8910 activated after the murder of Charles McCormick?
I believe so, yes.
Now, as part of your investigation, did you also become familiar with someone named Natalie Gant?
Yes.
Were you able to identify her phone number?
Yes.
All right. And what was that phone number?
It was a 904-485-7529 number.
Did you obtain cell phone records with her identified phone number?
Yes.
And did you submit those records to FBI to see if there was anything that they could map?
Yes.
Was there anything mappable?
I don't believe so.
In April of 2022, was Natalie Gant subpoenaed to come in so that you could speak to her?
She was.
And did you have a conversation with her at that time?
I did.
Not getting into the specifics, but did she provide information that was relevant to your investigation?
She did.
After that conversation, did she lead you to any place?
Yes.
Right. And where was that?
That was the apartments where she picked up Mr. Robinson.
Do you recall,
Hakeem Robinson.
do you recall the address of that
I
location?
want to say it's the 7201 Arlington Expressway,
What type of location is it?
apartment complex.
And just behind that apartment complex, are there woods?
It backs up to the Tree Hill Nature Preserve.
What's on the other side of the Tree Hill Nature Preserve?
There's a small body of water, and then it leads up to Glen Echo.
And where is Glen Echo in relation to 1033 Townsend?
It is, by looking at a map, I want to say southeast. I have to look at a map.
Is it in that residential neighborhood?
Yes, it's in the same area.
Is it in the direction of travel that the individual caught on Belmead home video surveillance run across the street? Was it in that direction, general direction?
Yes, after obtaining the video from 1204 Bellamede, that's what led me to go to Glen Echo.
Okay. Were you familiar with the 7201 Arlington Expressway apartment complex based on your investigation before speaking to Natalie?
Yes.
And why is that?
There is a woman by the name of Miss Boston, referencing someone mentioned the description of one of the suspects getting into a vehicle, a white female.
Did you have that apartment complex photographed after you were taken there by Ms. Gant?
I can't recall this time.
Are you familiar with another apartment complex, I think it's currently called Meza Apartments?
Yes.
Where is the Meza apartment complex located?
It's off of East Port Road.
And what is Eastport Road next to it, that location? Do you recall the other road?
It's not too far away from, I believe, Brown Jersey Court. And
Do Do you recognize Palm Lake Drive? Is, there,
Yes, I do.
is that off of Eastport Road, Jacksonville?
It is.
And is that near that apartment complex?
Yes.
After you were conducting your investigation, did you eventually get arrest warrants for Hakeem Robinson, Leroy Whitaker, and Abdul Robinson Jr. for their involvement in the murder of Charles McCormick?
Yes.
And were they arrested on that warrant for second-degree murder?
Yes.
And then, can you arrest someone on first-degree murder?
No, they have to present the case for a grand jury, and the grand jury will indict them.
Did you also get an arrest warrant for Abdul Robinson Sr. for accessory after the fact?
Yes.
Now, after they were arrested, did you continue to work on your investigation, waiting for results and reviewing evidence?
Yes.
And was that an ongoing process?
Yes.
During that investigation, did you also identify a YouTube channel that was being used by Hakeem Robinson?
Yes.
You had a search warrant for that?
I did.
And did you identify or find anything that you thought was relevant to your investigation on that YouTube channel?
Yes, several videos and IP addresses.
What were the two videos that you found to be relevant?
That same song, or the song of a child singing that Queso Homicide song was on there, and I believe there was a clip of the, sorry, if I review my records right now, I can't really remember exactly what was on there.
Yeah, Your Honor, may I approach?
Yes.
Showing what's the marker identification of state. Take a moment for you to recognize that.
Yes.
What is it?
It is part of the YouTube download results, search warrant results.
And what is the name?
Videos, FaceTime video call. It was Mr. Robinson.
And why was that FaceTime call relevant?
The clothing he's wearing in the video. It is a copy of the video Bang It Out by Mr. Hakeem Robinson or Queso 23X.
And why was that video significant?
When we spoke with just a rifle that looked very similar to the one used in murder.
Your Honor, I didn't ask him to move evidence is significant to murder exhibit.
All right, any objections from Mr. Whitaker? Any objections from Mr. Robinson?
Previous motions, objections,
Okay, thank you. Those objections are overruled, so 8K will come in, I'm sorry, 8J will be marked into evidence as states number 192, and 8K will be marked into evidence as states 193.
Showing you what's in evidence, it states 192. Do you recognize this?
Yes,
And what is it?
it is the FaceTime video. You can see it's a gray body and appears to have black arms, or dark-colored arms and shoulders.
Your Honor, the evidence speaks for itself.
Okay, sustained.
Request to disregard.
All right, ladies and gentlemen, you'll disregard the last answer. You may view the video and determine what it shows.
To the right of this video, there's a box. Does that contain the metadata provided by YouTube?
Yes,
All right. And looking at this, you have a upload IP address.
yes,
All right. And does that upload IP address look familiar to you?
it does.
And what was that IP address?
It's the same one as I found on the Hakeem Robinson case of 23X Instagram account. It also led me to the 478 number.
And it states 193.
call me queso.
During your investigation, you indicated you identified an iCloud account associated with the 478-305-9583. Is that correct?
That is correct.
And you received the records associated with that account?
Yes.
Did you review it?
Yes.
And did that account contain both photographs and videos?
It did.
Who was depicted in the photographs and videos of the House of Pain iCloud account?
Mr. Hakeem Robinson.
Was it Hakeem Robinson by himself, or was he with other people? What was predominantly on that account?
He was predominantly by himself, but there'd be other pictures of people known to him.
But would he be, was Hakeem Robinson in all of those photographs and videos?
Yes.
Did you ever see Christopher Brown on that iCloud account?
No.
Did anything in your investigation ever link Christopher Brown to this crime in terms of cell phone records, physical evidence, DNA, fingerprints, anything like that?
No.
Was there anything in your investigation that linked the 478-305-9583 number to Christopher Brown?
No.
For the records you obtained for the 478-305-9583, you recall approximately when the last activity was on that device?
Not off the top of my head, no.
Judge, I have no further questions.
Okay, cross by Mr. Whitaker.
Excuse me, may it please the court?
Yes.
Good morning.
Good morning.
Mr. Smith, I'm sorry, Sergeant Smith. And before that, Detective Smith, sir. How many years with JSO?
11.
11 years. And you started off in patrol, sir?
Yes, ma'am.
And I'm sure after you successfully completed the police academy?
Yes, ma'am.
Okay. And part of your training at the police academy is learning the criminal laws, right?
Yes, ma'am.
Because you have to learn the elements of theft charges, robbery, violent charges, narcotics charges, sexual assault, the whole gambit, correct?
Correct.
Because as a patrol officer, you never know what you might be responding to, correct, sir?
Yes, ma'am.
Okay. And there are many, many times that officers have to make quick decisions, kind of right on the spot, to take that legal knowledge they've learned and apply it in real time, correct? And part of that legal concept also becoming familiar with the legal concepts of attempt, like attempting to commit a crime, sir?
And the grounds? Not based on that question, I'll overrule.
You're aware of the legal concept of attempt?
Yes, sorry.
Okay. Aware of the legal concept of a principle to a crime, right?
Yes.
Aware of the legal concept of being an accessory after the crime, correct?
Yes.
And for example, even back kind of in your patrol days, you might have responded to an allegation of theft at a store. Two friends shopping at a store, and your job would be to investigate, should one be arrested, should both be arrested, correct?
Correct.
And you would arrest both of them if you had sufficient evidence they were working together, correct?
Correct.
And even as you have been promoted through your 11 years with the JSO, you still continue to apply this same kind of analysis, correct?
Correct.
And in fact, anytime you make an arrest, and especially on the level of homicide detective, you're going to actually be articulating your probable cause, right?
Yes, ma'am.
I mean, you'd either do it if you ended up in a situation where you did what they call a probable cause on view arrest, you would write up your probable cause in an arrest and booking report, right?
Yes.
Otherwise, you would do it through what's called an arrest warrant, right?
Yes, ma'am.
And in that arrest warrant, just like the arrest and booking report, you're going to articulate everything that you feel supports your probable cause to make that arrest, right?
Yes.
Okay. So going to 2020, sir, by that time in your career, you had been promoted as a homicide detective, correct?
Oh, okay. Sorry, homicide detective, not promotion at the Jacksonville Sheriff's Office.
Okay.
It's a lateral move. Yep.
Okay, yes, sir. But being a homicide detective does carry an extra pressure, does it not, sir?
Yes, ma'am.
Because I imagine one of the very first things that would be your responsibility as a lead homicide detective would be to contact the next of kin for that person who has passed, correct?
Correct.
And I imagine that that is probably one of, if not the most difficult thing you're asked to do.
It can
Is
be.
that fair, sir?
It can be.
And I have to assume that that does put the pressure on you as a detective of kind of an urgency, that you want to be responsive to these people that have lost their loved one, correct?
Yes.
And I'm sure it doesn't change your professional standards, but you'd agree with me that is an extra pressure that you carry, correct?
It can be construed as that.
And a pressure to hold those responsible, right?
Yes, ma'am.
Now, in this particular case, you ultimately arrested Dominic Barner, who was 26 at the time of his arrest, correct?
I believe he was 26, yes, ma'am.
And Abdul Robinson Jr., who was 25 at his arrest.
I don't recall the exact age at the time.
Okay. And Hakeem Robinson, who was 21 years old, correct?
Correct.
And Abdul Robinson Sr., who was approximately 50 years old.
Or somewhere around there.
Okay. And then Leroy Whitaker, who you know had just barely 19 years old.
I can't remember his exact birthday, sorry.
At any point in your investigation, did you feel like the ages of these people were significant?
Significant how?
You tell me, did you find them significant or not, sir? Doesn't sound like you did.
No.
Okay. So let's talk for a second about your investigation. And obviously, you've kind of laid out that the first break, if you will, in your investigation was Barbara Buckley's description specifically of Dominic Barner, right?
Yes, ma'am.
And based on the facts that you knew even that day, on January 15th, did you feel confident that there was a connection between that crashed Altima and the burglary at Miss Buckley's home?
Yes.
Okay. And was that just basically based on the proximity of the two locations?
The proximity and then the video surveillance from the 1214 Timber Lane.
Okay. And you obviously were aware and saw even that day this video surveillance footage that we've all seen that appears that there are two people jumping fences, correct?
Correct.
And might as well talk about it right now. You did have access to that day, as well as the dash cam video that actually captures the homicide, right?
Yes, ma'am.
And you were able to compare those two videos, obviously.
Yes.
Did it become obvious to you that the two people that are jumping through these yards could not have been the shooter?
That's correct.
And it's fair to make that assumption because the clothing is clearly different, correct?
Correct.
And you were able to determine, although it may have been several hours on January 15th before you had access to the ring surveillance videos showing the backyards, you were able that day to see the two different videos live to see that the clothing did not match.
I didn't see the 1214 Timberland. Eventually I saw it. I believe Detective Gibson showed it to me.
Okay?
But I did not see it like from the victim or witness whose house it came from.
Okay. They provided it. You have a specific unit as well as officers. Some just have better technology skills than others, and you might have an officer that's able to download something himself, and if not, you have a specialized unit that does that, correct?
That's correct.
And everything as lead detective comes to you, right?
Eventually, yes.
I mean, ultimately, in terms of this investigation, you are the captain, correct, sir?
Yes.
You make all of the decisions, oftentimes in conjunction with the state attorney's office, of how your investigation flows, right?
Yes, but for as far as the investigation to Barbara Buckley, that was headed up by Detective Richardson for the most part. I worked in conjunction with him.
Sure. And obviously, as that was your, I guess, most major lead at that point, you would have wanted to keep close tabs with Detective Richardson in terms of how his investigation was going, correct?
I don't know about close tabs. It was, he would come update me whenever something happened.
Well, I assume that you got updated that day that Barbara Buckley identified in a photo spread Dominique Barnett, correct? You did not put that photo spread together yourself?
I did not.
You would have let them do that pursuant to their obligations for a burglary, correct?
Correct.
You were made aware that Ms. Buckley never was able to identify the second person in her home, correct?
That's correct.
She was ultimately shown a photo spread similar to the one prepared for Mr. Barner, 6 photos that approximately looked like Mr. Whitaker, and she was not able to pick anyone, correct?
I was not made aware of how the photo spread went.
I'm sorry?
I was not made aware of how the photo spread went to Leroy Whitaker.
Meaning you weren't aware that 6 photos were shown?
No, I wasn't aware of when the photo spread was done and who did it and anything like that.
You just knew that ultimately when it was done, she wasn't able to identify anyone?
I have heard that, yes.
Because obviously that would factor into your investigation as well.
Correct.
When Mr. Barner was arrested back on January 15th, he did agree to be interviewed by yourself?
And Detective Richardson, yes.
I'm sorry?
And Detective Richardson, yes.
And Detective Richardson. Ultimately, he lies to you on January 15th, correct?
Yes.
Your investigation, as you kind of explained, was ongoing, correct?
That's correct.
And over that spring, you were able to get, you've described Florida Department of Law Enforcement records, correct?
Yes.
And that would have given you, as you termed the investigative lead, that you believed you had evidence to put Leroy Whitaker's DNA inside the Buckley home, located on her pants, and inside this Altima car, correct?
Again, Detective Richardson, but yes.
Okay. And ultimately, he let you know that based on that, he was going to be seeking an arrest warrant for Mr. Whitaker for burglary, correct?
Yes, which he did.
Okay. And your investigation, though, still ongoing, correct?
Yes.
And as that spring of 2020 continues, you also get what you believe to be cell sites for a phone number associated with Mr. Whitaker, correct?
That's correct.
Okay. And you believed that these phone records showed him at the locations that were relevant to your homicide investigation, right?
That's correct.
Okay. So with the DNA and with these phone records, you did not arrest Mr. Whitaker for murder, correct?
Not at that time.
Okay. On August 27th of 2020, Dominique Barner agrees to be a state witness, correct?
Correct.
And on that particular day, you meet with him, correct?
Correct.
And it was actually in the Jacksonville Sheriff's Office homicide unit, was it not?
Yes, that's correct.
And you met with him in one of your typical interview rooms, correct?
Yes.
And in this interview room, just for our jurors' knowledge, this is a room that has a basic table, however many chairs are necessary. There's nothing on the walls, correct?
That's correct.
And this room is specifically equipped with recording devices that can be turned on and off at any time, correct?
Correct.
And they're also hidden, correct?
Not really hidden.
Well, if someone who did not know what that room was, is there a visible camera, such as we see in the back of our courtroom?
Yes.
There is a visible camera? Has that changed recently?
No, there's a visible camera. It's in the corner of the room, and then there's one in like the wall.
Okay. But at any time, you can turn those on, correct?
Yes.
Okay. And on August 27th of 2020, those cameras were eventually turned on, were they not?
Yes.
Eventually. And I do say eventually because you talked to Mr. Barner for quite a while first, right?
Yes, ma'am.
Okay. And the benefit of Mr. Barner for your investigation being willing to be a witness in this case is it means you have full access to him, right?
Generally, yes.
Once someone becomes a cooperating state witness, number one, he's housed in the Duval County Jail, correct?
He was, yes.
Okay. So obviously, you can walk right over and talk to him anytime you want, right?
Typically, not at any time I want. Typically, we wait for his counsel to be present.
But all you have to do is call counsel, correct?
If I have their number, but I have to confer with the state because I don't have his number.
Well, his counsel was at the August 27th meeting, correct?
He was.
Okay. And the benefit of having full access is that any questions that come up in your investigation have a source to go to, correct?
Correct.
But in this particular case, that didn't happen, did it?
As far as what now?
Well, after August 27th of 2020, when Mr. Barner eventually gives his sworn statement, you don't have another interview with him, do you?
No.
You don't ever sit down with him again and say, let's go through this again. Let me just make sure that I have all the details and I've pursued everything that you could possibly help me with, right?
Right.
That didn't happen in this case. Okay. Because if it had, maybe you could have gotten his iCloud, correct?
So, no. The reason I didn't get his iCloud was his cell phone records come with an IMEI number. I ran through an IMEI checker. That IMEI did not come back to an iPhone, so I could not subpoena Apple for that IMEI.
Did you ever sit down with Dominic Barner and talk to him about his iCloud, his social media accounts, how to log in to his social media accounts so that you could review?
I don't believe he had any social media accounts at the time that we were able to identify.
Your belief as we're sitting here today is that he just didn't have any social media?
Not that I was made aware of, no.
Okay. Did you ask him?
Not that I specifically can recall right now.
Okay. Because if you did ask him, you'd probably make a note of it, right?
Yes,
And you did write a very detailed report in this case, did you not?
I did.
Okay. And you'd agree with me, in that report, you do not mention attempting to or inquiring anything in regards to Dominic Barner's iCloud, correct?
That's correct.
Now, in that August 27th meeting, Dominic Barner does give you something you didn't have before. And that is, he claims Leroy Whitaker was a full part of this murder, right?
That's correct.
Before August 27th of 2020, you didn't have any evidence besides Barner, right?
At that time, I can't remember the DNA came back on the shirt inside the car.
Well, and let's go through that. Because ultimately, when you did do the arrest warrant for murder, you did do an arrest warrant in this case, correct?
I don't remember if I did one for Leroy because he was already in jail.
Your Honor, may I briefly approach the witness?
Yes.
Would you refresh your recollection to actually look at the arrest warrant that you completed in this case, sir? And please feel free to. And sir, you did a tremendous amount of paperwork in this case, correct?
Yes, ma'am.
Okay. And in that arrest warrant, you lay out your probable cause, correct?
Yes.
And you'd agree with me, in this arrest warrant, and this arrest warrant, I believe, was served on September 11th of 2020. Does that sound about right?
That sounds about right.
Okay. In that arrest warrant, you articulate how Mr. Barner was described by Ms. Buckley with the 1993 tattoo, correct?
Correct.
And then ultimately, Ms. Buckley is actually able to pick Mr. Barner out, right?
Yes.
And you articulate that you had received the Florida Department of Law Enforcement records that allege Mr. Whitaker's DNA is inside this car on a T-shirt, correct?
That's correct.
As well as separate FDLE results from the Buckley home suggesting Mr. Whitaker's DNA is inside that house, correct?
That's correct.
And then finally, you articulate Mr. Barner's claim that Leroy Whitaker was not just in that car, but that he was supposedly participating, correct?
That's correct.
And that is what made the difference for you to file for a murder arrest warrant, right?
Yes, at that time.
Okay. And as the state, I think, had you mention on direct examination, after September 11th, 2020, your investigation does not stop, correct?
That's correct.
And so you still have the ability, if it would be important for your investigation, to continue to order more phone records, correct?
Correct.
More Instagram database, that kind of thing, correct?
Correct.
And in fact, the digital evidence was extremely important in this case, correct?
Correct.
Okay. And you mentioned you had some physical phones that you did a complete download of, correct?
Yes.
Okay. Mr. Whitaker's was not one of them.
It was not.
But then you also sought specific cell phone records, including call detail as well as historical cell sites, right?
Yes, ma'am.
Okay. And even for some, an iCloud, correct? Okay. What dates of records did you seek, sir? And specifically for the records that you feel were associated with Mr. Whitaker?
As far as,
Well, for call detail records.
I did probably the day before the murder and maybe the day after.
Okay, day before the murder and day after.
Yes.
Okay. Have you ever heard of the term historical cell phone records for analysis? Ever heard of that kind of technique?
No.
Okay. Would you agree with me if you were concerned that you wanted to identify who was actually using a particular cell phone? It'd be helpful to see what calls were being made over, say, a 30 or 60-day period of time.
It could be helpful, yes.
Like, for example, if someone grabbed my phone today and they looked at every call I made and they found out I called my mom 4 times, I called my husband, I called my children, and I'm doing that repeatedly, that'd give you a pretty good indication, hey, that's Julie Schlax's phone.
Such as a pattern of life.
And I'm sorry, you used the term?
Pattern of life?
Pattern of life, okay. In this particular case, in regards to Mr. Whitaker and the phone number you believe he was using, you did not do that.
No.
But you agree it can be helpful?
It could be, yes.
Okay. It would be helpful to determine specifically if Dominic Barner, based on his allegations, was having any contact with Leroy Whitaker leading up to January 15th, wouldn't it?
Potentially.
Okay. But we don't know, correct?
No.
In regards when you did have access, full access to Dominic Barner, you ended up not asking him why he was willing to kill Charles McCormick, did you?
No, ma'am.
In fact, you thought it was probably for money, right?
What he thought about why Mr. Barner committed this crime?
Yeah,
And then I'll sustain the objection.
Okay. You never asked him, right?
No.
Okay. And Mr. Barner had claimed that he had personally reached out at some time before he committed this homicide, specifically to Charles McCormick, that he had reached out to him through his fake Instagram. And he even gave us the name, Kevin Gates. I guess Kevin Gates is some kind of, I don't know, rapper or comedian, but that was his fake Instagram. That's what Mr. Barner explained to us. Number one, did he ever explain that to you?
No.
Did you obviously ever look for that?
No.
When you spoke to Mr. Barner to get his full explanation, and I've asked you about Mr. Whitaker, but after you spoke to Mr. Barner, it wasn't just Mr. Whitaker you did an arrest warrant for, correct?
That's correct.
You also did an arrest warrant for Abdul Robinson Sr., correct?
Yes.
At the same time, you're also doing an arrest warrant for Abdul Robinson Jr., correct?
Yes.
You're also doing an arrest warrant for Hakeem Robinson, correct?
Yes.
Okay. Did all those at the same time based on your conversation with Dominique Barner, right?
And other corroborating evidence, yes.
Okay. Well, for Mr. Whitaker, you had all of that corroborating evidence. What allowed you to arrest Mr. Whitaker was specifically Mr. Barner, right?
Yes, and at that time.
Okay. Because at that time, you had what you believed to be cell phone records, right?
Yes.
You had what you believed to be DNA, right?
Yes.
But those things, at best, if they were believed, would only put him at the scene of a crime, correct?
Yes.
It certainly wouldn't prove to you that he participated in it, right?
Again, the only thing I can say to that is inside the Nissan, there are 2 guns recovered and a third one that we never recovered. There's 3 guns, 3 people. That's kind of hard to say he had no idea what was going on.
Okay, so you assumed that anybody who's in that car must have known. Is that what you're telling us?
Again, 3 cars, 3 guns.
Okay.
That's a very loud statement.
So again, you assumed.
Actions speak louder than words.
Yes or no, sir?
At that time, yes.
Yes. So the ultimate answer is yes, you assumed.
Yes.
But when you spoke with Mr. Barner, you did not have any further discussions about the involvement of Abdul Robinson Sr., correct?
No.
And in fact, you did not press or further question Mr. Barner specifically in regards to, might Mr. Robinson have had some kind of involvement in this before the murder, right?
No.
You were aware at that time that Mr. Barner was willing to testify against Abdul Robinson Sr., correct?
Yes.
Abdul Robinson Jr., correct?
Yes.
Leroy Whitaker, correct?
Yes.
Hakeem Robinson, correct?
Yes.
And Torrigan Williams, correct?
Yes.
For the McCormick homicide, right?
Yes, ma'am.
You were also made aware that Dominique Barner is a cooperating, testifying witness against Chris Brown, right?
Yes, ma'am.
Derek Hudson, correct?
Yes.
And Abdul Robinson Sr. in a separate homicide, correct? Now, the Jacksonville Sheriff's Office does have something called a license plate reader, does it not?
Sorry, yes, we have access to a license plate reading system.
Okay. And if you will just briefly explain to the jurors, what is that?
Certain cameras are set up throughout the city that capture license plate data.
And you, as a member of the Jacksonville Sheriff's Office, has that, I guess, I'm going to call it a database, I don't know if that's the correct word for it, that you can put in a known license plate and see if it's been read to determine, hey, has that particular car with that particular license plate been in these areas of Jacksonville, right?
Yes.
Did you do that for the Nissan Altima in this case?
I believe I did at some point, but I can't call the exact date.
Okay. And again, I realize, I think you told us at one point, you spent hundreds of hours on this case, right?
Yes.
And you have many different cases, correct?
Correct.
And so the way that you're able to testify confidently is you write stuff down, correct?
Correct.
You write detailed reports so that if 5 years elapse and you're being asked on whether or not you accomplished something or didn't, you can just look at your report, right?
Yes.
You'd agree with me that there's nowhere in your very extensive report where you indicate that you had put the known license plate of the Nissan Altima used in this case through that license plate reader.
I don't believe there are any scans of note, so no.
I'm sorry?
Scans of note? Sorry, license plate scans.
I'm sorry, say that for me one.
I don't believe there's any license plate scans of note.
Okay, so your testimony without a written note in your report is that your memory is that you did this, but it wasn't helpful. Is that what I'm hearing you say, sir?
At my best recollection, yes.
Okay, but you'd agree with me when you're drafting your report that documents for your benefit to be able to testify accurately as to everything you did in your investigation, that report does not indicate you ever put that license plate into the scanner.
That's correct.
Okay, Ms. Schlax, I hate to interrupt you. The jury is asking for a recess or a bathroom break, so we're going to do that now, although it is 11:50. I don't know if we can, I don't know how much longer you have. I don't want to cut your cross in half.
I want the jury to be comfortable, Your Honor.
No, we'll do a bathroom break. I'm trying to decide whether we bring him back out here, conclude with your cross, and then send him to lunch, or just send him to lunch now if you have longer to go.
I would say I probably have 20, maybe?
Okay. All right, why don't we do this, ladies and gentlemen? Let's take a bathroom break, then we'll come back, finish with Ms. Schlax's cross, and then we'll take our lunch recess. So if you will please put your notepads behind, have a step into your respective jury rooms, and we'll bring you out here just as soon as we can. Thank you very much. All right, both juries are out of the courtroom. We'll be in recess. Okay. While we're waiting on them, okay, let's wait for a second. While we're waiting on them, I just have a question because I know you have published State's Exhibit, I don't even remember the number, but it's the Banging Out music video that actually does not have any audio except for one short portion that says, I'm queso, or this is queso, or something to that effect. I'm sorry? Okay, and that's what I wanted to be certain. I didn't know if we were having audio issues or if that was the intent of the parties. I wanted the record to be clear that other than that one phrase, there is no audio in the entire music video. Has that been done with the agreement or approval of the parties? And was I supposed to read an edited recording instruction? So I just want to be clear then, notwithstanding any other objections you may have made to the admissibility of the evidence, is there any objection to the fact that the audio was not played on that video from Defendant Whitaker,
No objection, Your Honor.
from Defendant Robinson? You want the lyrics and the audio of that video to be played to this jury? Okay.
Some of the lyrics are irrelevant and very prejudicial. The entirety of the video, however, is relevant given the fact that it shows that there are other people holding what they believe to be done.
And I'm not questioning that part. I was only asking about, the video's in evidence. It shows what it shows. But when they played it in full, I noticed, other than a short portion that mentions queso, there was no audio. And so I didn't know if that was a failure of technology, no offense to my wonderful IT people who are sitting here, or if that was the intent of the parties, or if that was a failure in the recording, and if it had been edited in order to take out the lyrics, I then should have given an edited recording instruction to the jury prior to them viewing it. I did not know or realize that. But first and foremost, I wanted to be sure that the evidence as admitted, again, notwithstanding your other objections, but just the absence of the music lyrics, the music and the lyrics, was done and is with the consent of the parties. Okay. Okay. Sure.
So here's where my issue is. That was not shown to us before, that it was going to be played in that way. And then just put me in a portion that says, I'm queso. The issue I'm having now is that leads the jury to believe that the audio, and the majority of it is being kept out. In their mind, why can't we hear the rest of the audio? What should have been played was with no audio. There's no question that the person in the video is a he. So for them to say, I'm queso, was completely irrelevant. And so now we're in a situation, if they don't need it, it's cumulative. No one is disputing that that's Hakeem Robinson in the background video. Therefore, it's just specified. So now, I'm realizing this now just because that was not given to us before and it wasn't discussed with us before. The jury is now going to realize that the lyrics were removed or the remainder of the song. And to me, that's why can't we hear the remainder?
Well, that's why I would give my edited recording instruction, which tells them specifically, and this is a standard instruction, I'll read it now. It says, members of the jury, you're about to view and listen to an audio-video recording. The court instructs you that the recording has been edited to eliminate irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you view, listen to, and consider this evidence. I am happy to read that instruction to the jury when they return, if we are going to address that part of the video again or in some other fashion, but I am certainly willing to do that to clarify any confusion so that they understand why the video was edited, and they're not going to wonder why or think what's going on. That is not unusual, and I do that in other cases. Leaving in the portion that says queso, if your argument to that is relevance or cumulative, I would overrule, because it is relevant. I mean, that's what this whole thing is about, and I understand other witnesses may have identified him as being in the video, although the video hadn't been moved into evidence until now. But that being the case, that doesn't mean that because someone else has looked at that video and said, yes, that's queso in the music video, or Hakeem Robinson in the music video, that the portion that shows him saying, I'm queso, or this is queso, should be excluded, so.
I mean, of course, assuming we ever have a voice authentication, that the person saying I'm queso is actually queso. Just to add that to it. Your Honor, what I would ask is if you are going to give that instruction, that you would tell the jury this should have been given to you before it was played.
Sure, I'll say that. That's on me. Okay. All right. Anything else?
No, Your Honor.
All right, let's bring the jury out. Leroy Whitaker's counsel's cross-examination of the witness. You may proceed.
And thank you. Detective Smith, we had kind of left off and we were talking about investigative efforts in regards to this car that you believe was used, this Altima, correct?
Correct.
And the Altima you had learned had been reported stolen?
Yes.
Okay. And I think you told us roughly from November of 2000 and, I guess, 18?
19.
19, thank you. So roughly about 2 months, maybe a little bit over 2 months?
I can't remember the exact date, but yes, it was roughly about 2 months.
Okay. And I think you mentioned that maybe you talked to her son-in-law, the actual owner?
Yes.
Okay. Was he the one that had driven it the last before it was stolen?
No, his daughter drove it for whatever reason. I think it was, I can't remember if it was at his house or her apartment when it was stolen. And the last known address I could find, I think he's the one that reported it stolen, which is why I went and talked to him.
Okay. But you ultimately weren't able to talk to whoever had it kind of physically stolen from them? And what I mean by that is, do you know where the keys left in the car?
No, sitting here without looking at the report, I couldn't tell you where they were.
Okay. And I guess my real question is, did you make any effort to look for surveillance videos or anything that would help you determine who might have stolen this car?
It was 2 months, almost 2 months later.
Okay. So in your mind, just wasn't going to be worth anything?
No, we have an auto crimes unit, or I think it was auto crimes now, that's responsible for investigating that.
Did you talk to anybody in auto theft? Was there a detective assigned?
I don't recall.
Because you probably are very familiar that when someone reports their car stolen, of course it's going to be put into the JSO database so that any patrol officer can be looking for that car, right?
That's correct.
Okay. But the number of cars that are stolen, to have a detective actually assigned, there usually is a suspect involved, correct?
I don't know the exact qualifications of when they assign cases on the crimes. I've never worked there. I don't recall seeing a sup from a detective at this time.
Okay. And you don't remember reaching out to anybody in the auto theft department to see, hey, I don't know if anyone's trying to investigate this, but can you coordinate with me?
No.
Okay. And you would have received all of the photographs that the evidence technicians took as they're actually searching this Altima, right?
Yes.
And I think you mentioned on direct, you were physically there.
Yes.
Right? So you knew that there was this Bible found in the trunk.
I can't recall it at this time.
I think sorry, I should have done this on the break. Can I get photograph 76, or no, I'm sorry, 96 from the Nissan Altima? I believe it would be, if we can just throw it out there so that Detective Smith can see it.
Just the Bible photo?
Yes. Let me see if this refreshes your recollection. While we're looking for that particular photograph, did you also determine if this Altima, if anybody had ever hooked up their phone to the Altima?
I checked to see if the car was Burla compatible. It's not.
I'm sorry?
Burla compatible?
Okay. Meaning that a cell phone was unable to connect?
No. Like for me to download the vehicle via search warrant to get all that information, it was not compatible.
Okay. And I'm sorry, I apologize, I don't understand what you're trying to explain to me.
It's Burla. It's
Is that an acronym for something?
I'm sure it is. That's a company. Basically, you could download a vehicle's infotainment system, and it could tell you all that kind of information. That vehicle is not Burla compatible, so therefore I wasn't able to do that search warrant on the car to see all that stuff.
Okay. How about just turning the car on and seeing if there is any iPhone that's been connected?
At this point, I can't recall if we even had the keys.
Okay. I'm sorry.
I can't recall if we had the keys to the vehicle.
Oh, in terms of whether you could turn it on or off?
Yes.
Okay. You do remember that the car was running when you got to the scene on Townsend?
I don't remember if it was still running when I got there.
Okay. And I guess ultimately, the bottom line is, we don't know.
Yes, that's correct.
Because you'd agree with me that people of a younger generation tend to connect their cell phones to cars to play music. Is that a pretty common occurrence in your experience, sir?
Yes, ma'am.
Now, you've kind of told us about some Instagram searches, and we heard a lot about Team Robinson's account. Did you ever do any searches specifically in regards to Charles McCormick? And if there was anybody else out there making comments about Charles McCormick's death?
No, I mean, I couldn't really just search Charles McCormick and then his life story pop up, no.
Okay. The fact is you never did any searches, right?
On Instagram?
Yeah.
No, ma'am.
I'm sorry?
No.
No. Okay. You did, I guess, fairly quickly realize that this homicide occurred on the one-year anniversary of the death of Willie Addison, correct?
Eventually, yes.
Okay. And I'm sure that would cause you to become at least familiar with what happened to Willie Addison, correct?
Correct.
And you would have become aware that Willie Addison was in a car with his father, or who he looked up to as a father, stepfather, Abdul Robinson Sr., correct?
Yes.
And Abdul Robinson Jr., correct?
Correct.
And Torgan Williams, correct?
Correct.
And that all of them were shot, correct?
That is correct.
And in fact, Mr. Robinson Sr. told us yesterday there was an additional 2 people there, one by the name of Moody, goes by Antonio McLaren. Are you aware that he was in the car when Willie Addison was shot?
I believe it's Antoine, but yes.
Okay, you were aware of that, sir?
Yes.
Okay, and then somebody else he referred to as Sammy, who evidently ended up paralyzed.
I don't remember Sammy.
But it was significant because obviously you're having some allegations where Abdul Robinson Sr. and Abdul Robinson Jr. their names are being brought into this investigation specifically by Dominique Barner, and you're aware of this anniversary, right?
Yes.
And Dominique Barner was very clear that Torgan Williams was involved in this homicide, correct?
Yes.
He told you back on August 27th of 2020, hey, you're going to want to be looking, and he names Torgan Williams, right?
Yes.
And that would probably hold special significance because Torgan Williams, in fact, was in the car and was shot himself when Willie Addison was killed, right?
Yes, ma'am.
Because in looking into that investigation, you obviously became aware that Leroy Whitaker wasn't in that car, right?
That's correct.
Hakeem Robinson wasn't in that car, right?
That's correct.
And Willie Addison was older than Abdul Jr., correct?
I believe he was, but I have to look at the date of birth to verify.
Certainly much older than Leroy Whitaker.
Correct?
And so, based on your conversation with Dominique Barner back in August of 2020, it was your intent to investigate and ultimately attempt to interview Torrigan Williams, right?
At some point.
Okay. But that didn't happen, did it?
It didn't.
Okay. Torrigan Williams, and you actually put out something called like a person of interest, right?
Yes, ma'am.
Okay. And that's in your JSO database?
Yes, ma'am.
Okay. And that's supposed to be for officer. Every patrol officer, it's a specific note that if they come into contact with Torrigan Williams, they should contact you, right?
Yes.
Okay. And I think you've told us before, you put that into the system, right?
Yes, ma'am.
And do you think you would have done that after August 27th of 2020?
It would have been around the time I became aware of his involvement.
Okay, which would have been August 27th, 2020?
Yes, around that time.
Okay. And you're aware Torrigan Williams had been arrested since August 27th, 2020, right?
Because I said he's just because he got arrested doesn't mean they called me that night when he was arrested.
Okay. And he's physically in this courthouse on multiple occasions.
I can't verify any of that.
Okay. You weren't aware that he was in court on September 21st of 2021?
I don't recall anybody making me aware of that.
Okay. How about September 28th of 2021?
Again, don't remember anybody making me aware of that.
Okay. How about October 28th of 2021?
Don't recall anybody making me aware of that.
December 2nd of 2021?
Same.
Okay. How about when he actually pled out on June 28th of 2022?
Same.
And your explanation is no one contacted you and let you know that Torrigan Williams, who you always had wanted to interview and were actively investigating in this case, was physically in the Duval County Courthouse.
That's correct.
Okay. Even though Mr. Atkinson was the one prosecuting him. Were you aware of that?
Vaguely, I think I might remember that. Sorry.
But the bottom line is, you didn't speak to Torrigan Williams. You didn't have the kind of interview you wanted to have with him, right?
No.
The interview you had with him was in February of 2025, right?
That's correct.
And that's just something lawyers arranged, right?
Yes, ma'am.
We did see on your direct that you were identifying in these phone records that there were calls with Torrigan Williams that day, correct?
That's correct.
Okay. Which I guess would have just further supported Mr. Barner's claim?
Yes, ma'am.
So no formal interview of Torrigan Williams. No formal interview of Chris Brown, correct?
That's correct.
And Mr. Barner gave you a lot of information about Chris Brown, right?
I don't know about a lot of information.
Well, were you aware that Mr. Barner claims that Chris Brown is the confidant that originally went out to the complex to make sure that Mr. McCormick was there? They went out in the middle of the night, in the early morning hours of the 15th. Did Mr. Barner explain that to you?
I don't recall that being explained to me.
Okay. And you don't remember, or you don't recall it being explained that he was with Chris Brown and they were actively talking about the benefits of killing Charles McCormick?
At some point I heard that, but
Okay. But you never sought to interview Chris Brown?
no.
Even though he's sitting in the Duval County Jail?
Yes, because it was explained to me that he left before the homicide took place.
Okay. Did Mr. Barner explain that evidently, according to Mr. Barner, Chris Brown came back? He came back to that complex. Supposedly, when everyone's there, Chris Brown comes back to that apartment complex. Did Mr. Barner explain that to you?
Yes.
Okay. But that still didn't make you want to go interview Chris Brown?
No.
Okay. Even though he's sitting at the Duval County Jail?
That's correct.
Ultimately, your decision in this case was you didn't feel you had enough evidence against Torgon Williams, right?
That's correct.
You did arrest Abdul Robinson Sr. for accessory after the fact, correct?
That's correct.
You did not arrest Leroy for accessory after the fact, did you?
I did not.
But according to you, your evidence at that time was supposedly at the Buckley home. According to Mr. Barner, he was arranging for a car ride out of there, right?
That's correct.
You mentioned this, there was a rifle and a handgun found in the Nissan Altima, right?
That's correct.
Okay. And according to Mr. Barner, that rifle was Leroy Whitaker's, right?
According to him, yes.
Okay. Only according to Dominic Barner, right?
Correct.
I mean, you don't have any physical evidence, right?
Correct.
Okay. We've seen Instagram photos and such. Do we have photographs of Mr. Whitaker holding this firearm?
We do not.
In fact, I did not hear you testify, sir, to any kind of Instagram posts by Leroy Whitaker, correct?
No.
And Mr. Whitaker is not in this video that we saw of Charles McCormick dancing around, correct?
I'm sorry, of him dancing around?
Of Mr. McCormick dancing around, the video that you felt was
You're referring to the
the bye, bye, bye video?
No, he was not in the video.
You never ended up doing any kind of a search warrant at Mr. Whitaker's home?
No.
Never spoke to his father?
No.
And the reality is, sir, after the arrest of Leroy Whitaker for murder in this case, after you laid out your probable cause, and you told us your investigation continued, right?
Yes.
But you never developed any further evidence that Leroy Whitaker had anything to do with the death of Charles McCormick, did you?
No.
I don't have anything further, Your Honor.
All right, then we are at this time going to take our lunch recess, ladies and gentlemen. It is 12:25, so I'm going to give you an hour, as I do every day, to enjoy your lunch. You may eat in the jury room, you may separate and go about your personal affairs, but whatever you do, not to talk to anyone about this case or let anyone say anything to you about this case. So please leave your notepads on your seats, and we will lock them, secure them, and return them to you when we reconvene here in 1 hour at 1:25. Thank you very much.
Doesn't know any of these individuals from Adam about what he observed from Mr. Ali's intent, that it was an intent to commit murder. that. As you can see in your instructions, there's some other instructions that follow along with that. So let's skip over to count 3 first. That applies to both Ihsan and Zara, and that is the unlawful imprisonment of Fatima. So you have the instruction that tells you what unlawful imprisonment is, how unlawful imprisonment is defined. I've highlighted for you the intent element, which is knowingly. A person commits that crime when he or she knowingly restrains the movements of another person in a manner that substantially interferes with the other person's liberty. If the restraint is without legal authority or without the person's consent, and the person knows that restraint is without legal authority and without the other person's consent. What is restraint? Restraint is without consent if it is accomplished by physical force, intimidation, or deception. You have that definition in your packet. I'll tell you I don't recall what the number is. For those, I don't have them all committed to memory. And then you have knowledge, what knowledge is described for you. Throughout the course of your instructions, you have a number of different intent elements that are described for you, or mental states that are described for you. Knowledge, intention, doing something with intent, and as you'll see later, reckless. Okay? The person acts knowingly when he or she is aware of that fact, circumstance, or result. You don't have to know that the thing you're doing is a crime by NRCW. You have to know that the thing you are doing is the thing that you are doing. You're acting with knowledge that you are doing the act. If I walked over here and pushed Miss Zoe, I don't have to know that that is a particular type of an assault. I have to know that I am pushing Miss Zoe, right? If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. And when acting knowingly as to an element is required to establish the element of the crime, that element is also established if that person acts intentionally. So if I walked over here and shoved Miss Zoe, I know that I have to know that I've shoved her, right? Not like I tripped or somebody bumped into me and I had no idea that I actually bumped her or pushed her at the same time. If I walked up and 2-hand shoved her, if you agreed that I did that intentionally, then you also agree that I've done that knowingly. Intentionally is essentially one mental element higher than knowingly. So as it pertains to Ihsan Ali, that is your to convict instruction, count 3. You have that in your packet, and we're going to come back to these. And then you have the same instruction for Zara, exactly the same, except again, it has for Zara that principal or accomplice language. That is the only difference between those 2 instructions in your packet, okay? So again, those elements as it applies to both parents, remember I said that we are going to talk about what overlaps between them first. So what applies for both, don't anticipate that there is going to be an objection, or not an objection, a disagreement by defense counsel that has happened on October 18th, 2024. I also don't anticipate that there is going to be a disagreement. Again, you still have to find that I have proven it to you, but that the defendant knowingly, and as to this element, restrained the movements of Fatima in a manner that substantially interfered with her liberty. You have to find it, but I don't think the parties disagree that Fatima's movements were restrained. Ihsan strangles Fatima. She's unable to get away without help. Zara holds on to Fatima after, strangles her, would not let her go. Again, Fatima is unable to get away without assistance. So I submit that these are not going to be issues that are going to be really in contention between the parties. That restraint, as it relates to both parents, that restraint was without Fatima's consent. That is the testimony of everyone. She is fleeing her house and her parents. She has run away. She has been actively avoiding her family all day. Exhibit 34, you see that she is trying to run from Dad. She is fighting Dad. You have exhibits 74, 75, 78, 77, 81. You see all of those injury photos, and we're going to look at them in a little bit, but they show all those scratch marks to her neck, and you heard the testimony. I believe it was Dr. Gilbert, it may have been Lisa Wall, talking about she's clawing at Dad's arms, and you hear all of the students talk about that. Clawing at Dad's arms, trying to get him off of her neck. Clearly, that demonstrates a lack of consent by Fatima to be restrained, let alone restrained in that fashion. And then Fatima tells you too, she's trying to tell her mom to let her go. She is not consenting to her mom strangling her. She is not consenting to the manner in which her mom holds her. And I want to be clear, we're going to come back to it, or not come back to it, we're going to get to it in a little bit because you have a parental discipline statute. The state is not asserting that a parent cannot restrain their child. We know that that is the case, right? There are things that parents have to do to correct restrained children, but this is not one of them. So as you're starting with the initial baseline of whether this happens with Fatima's consent, it certainly does not. And you have ample evidence of that fact. And then you have exhibit. Mom is strangling Fatima around the neck at about 2 seconds in, grabs her again at about 8 seconds in. And you have those screenshots. It's far away. It is harder to see, I would submit, but it is there. The location of Mom's arms. You have that Fatima, you see her forward, and then you have her leg going up, and you see that she is being pulled backwards at about 6 seconds in. She is trying to get away. She is looking to Isaiah for help. Her balance is being pulled off, and that is Mom who is holding her at that point in Noah's video. Again, that applies to both parents, that the defendant knew that restraint was without Fatima's consent. That's the testimony of everyone. Her parents know that she does not want to be restrained by them, certainly. And all of that evidence is exactly the same. Not only was it without her consent, but that same evidence tells the parents that they know that it is without her consent. They're not under the mistaken belief that somehow she's okay with it, and that any of these acts occurred in the state of Washington. Same information that you had previously, okay? So what is the unlawful imprisonment as it relates to element 4 only for Isan? First and foremost, without legal authority. You cannot strangle your child to restrain them. It seems really obvious, but apparently it has to be spelled out. You cannot strangle your child to restrain them. Instruction 21 is the self-defense instruction for assault, but I submit to you it is instructive for explaining the limitation on parents' rights for either correcting or restraining your child. You forfeit your right to use parental discipline to restrain your child when you do so in this manner, when you strangle your child and impede their breathing. It should be obvious. The other examples given in that instruction, you can't burn your child, that should be obvious to correct them or restrain them. You can't throw your child, you can't cut your child, you can't punch your child with a closed fist. Those should be really obvious things as parents, right? You do not, that force is incompatible with the duty to care for your child as a parent. So you cannot restrain your child by strangling them and cutting off their air. That is not an appropriate use of legal authority. And element 5, as it relates to Isan, the defendant knew that restraint is without legal authority. He knows he's not allowed to strangle his child. You go back to that instruction 32, knowledge, subjective and objective components to knowledge. There's a subjective, he knows all the facts that what he is doing is not simply restraining her movements, right? It says, based on the facts and circumstances known to the person at the time, he knows he is not merely restraining her movements. Everybody there says it too, right? They're watching it. It's his arms around Fatima's neck. That objective measurement, if a reasonable person in the same situation would believe that fact to exist, then you are permitted but not required to find that he acted with knowledge. A reasonable person, I submit to you, with all of those same facts and circumstances known to Isan at the time, knew that restraining her in that manner was not with legal authority. There's no good faith belief here that such use is reasonable or moderate. And the law does not require you to know that that act is unlawful specifically or an element of a crime. It doesn't require you to go to an RCW or a jury instruction element 5 and say, well, I didn't know it was that element, so therefore you can't hold me accountable. That would be absurd, right? You have to know that the behavior itself is wrong and without legal authority. So how does that apply then to Zara? Again, same information. You can't strangle your child to restrain them. She watches Fatima being strangled by Isan. She then puts her own arms around Fatima's neck. She's not comforting her. She's strangling her to keep her from fleeing. Her breath is impeded. Fatima's breath is impeded by that hold. She testifies to that and told the medical professionals, you heard that from the professionals specifically, that she reported that by her mom to the medical professionals. You look at that instruction 21 and those limitations on what parents can do to their children to discipline or restrain them. She's doing it both herself as the principal, and she's continuing her husband's actions for that same purpose as an accomplice. That the defendant knew that restraint was without legal authority, that information is the same as it was for Isan. And then again, how do you know that she knows that that's without legal authority? Her own statements. Her statements are about how people have treated Isan at the scene. She has talked about, where is my daughter? Give my daughter back. I want to see my daughter. And I want to see my daughter. I want to talk to my daughter. Right? Her focus consistently is on Isan. It's not on the health or care of her daughter. Just location and access to her. That is all she expresses to law enforcement. So same thing, family or household member. This is your verdict form, C1. No change to that. Exactly the same as the last one. So now we're going to go to Isan Ali, count 2. And now that's the overlap between the two parents. Now we go to separate crimes for each of the parents. And we're going to start with count 2 for Isan Ali. That is that assault in the first degree. Assault in the first degree, the crime of assault when with intent to inflict great bodily harm, he or she assaults another by any force or means likely to produce great bodily harm or death. And then you have the definition of assault. We'll come back to that. That will apply when we get to the assault on Isaiah. Touching or striking, harmful or offensive. Right? Great bodily harm. And great bodily harm that creates a probability of death. Bodily injury that creates a probability of death, or significant permanent disfigurement, or causes significant permanent loss or impairment of the function of any bodily part or organ. Right? If you take somebody's eye, you're talking about great bodily harm as an example. Or if you use a measure of force that creates the probability of death if that force is not then otherwise interrupted. And that's what we're focusing on in this case. So you have those definitions, or excuse me, you have the overall elements. You're given that in your packet. There's 4 elements. So let's go through them. Well, we're going to talk about this first, actually. Physical discipline of a child that the force used was lawful as defined. We just kind of went through that. That force is lawful when it is reasonable and moderate, when it is inflicted by a parent for purposes of restraining or correcting. And you must determine whether the force used, when viewed objectively, as a reasonable person looking at that same force, is that force reasonable and moderate? And that definition goes on, as I said, things that the law identifies as that you may consider unreasonable. Striking a child with a closed fist, interfering with the child's breathing. The other examples we talked about, burning, throwing a child, kicking a child, all of those things. As part of your determination of whether force used was reasonable or moderate, you shall consider the size, age, condition of the child, the location of the injury. Certainly the smaller the person, the younger the child, the more concern there is for how that force is used on that child. It's not a binding inference, right? But that is an example of things that you can determine are. So that element, as it pertains to ESON, again, the things that I submit to you are not going to be in contention between the parties. Right? October 18th, it's Fatima Ali and State of Washington. Those are not facts that people, I submit, are going to be arguing with you. Element 2 is where I think you're going to be focusing the majority of your discussion in this case, as to this issue. So let's talk about the evidence that you have. Element 2, that it's committed by a force or means likely to produce great bodily harm or death. So first you heard from Lisa Wall, and you're going to see LOC because I run out of room in each of these, right? Loss of consciousness. What happens when you lose consciousness? Your muscles relax. The damage becomes easier to inflict, and the easier the damage is to inflict, the result is death. That is the next logical step following loss of consciousness, is death in that process. You have the exhibits from Synovia Rivas, 67 through 81. She talks about the symptoms that she observed immediately afterward during that exam: headache, dizziness, lightheadedness, again, loss of consciousness, memory loss, a fuzzy feeling. Fatima reported feeling fuzzy, confusion, weakness and numbness, vision changes. She says everything got dark, and you heard her talk about that. Hearing changes. She had ringing in her ears. She had neck pain, external neck pain, and you see all the bruising from that. You hear her talk about her sore throat, her difficulty and pain swallowing, those voice changes, the hoarseness. They describe her as hyperventilating. She was still hyperventilating after the fact. All the redness, abrasions, and bruising, and then the petechia around the eye that she describes. Fatima described a 5 out of 5 for pain, told Ms. Rivas she thought she was going to die, and it felt like it went on for 5 minutes. It felt really long. She said, I'm sure it wasn't, I know it wasn't, but it felt really long from where she was. And think about what Dr. Gilbert, when Dr. Gilbert went through and talked to you about what the effects were of jugular vein occlusion, carotid artery occlusion, tracheal occlusion, she correlated all of that to those symptoms specifically. Why do you get headaches? Because you have that buildup of pressure, right, in your brain. Why do you have loss of consciousness? Because there's not oxygen going to the brain, right? There's not bad blood coming out, there's not good blood going in. Why do you have memory loss or fuzzy feeling? Because all of that brain function has been interrupted as that process goes. She talked about the eye changes and the hearing changes because your brain stem is interrupted, and the ability for your brain stem to process and connect to the vision in the eyes has been interrupted and is unable to do so. Hyperventilating, you talked about panic. One of the natural symptoms, your body's natural reaction is to panic when it can't breathe, and that panic continues on until it no longer feels like it is in threat or fear. She's describing hyperventilating to Synovia Rivas while she's arriving at the hospital, still after the fact. She has not come down yet. Her brain has not taken that threat away so that her breathing has returned back to normal. Dr. Gilbert talked about all of those things. So then you heard also by the force or means likely to produce great bodily harm, you heard from Dr. Kim, who was not excited to testify, right? He talked about that. It was terrifying for him. But an otolaryngologist, I'm sure I am mispronouncing that. He's a specialist at that point, called him by St. Pete's, right? Strangulation can result in death. This seems to be a very accepted premise. Strangulation can result in death, not one really for argument. He says that there was air in the esophagus. They didn't scope it because they were worried that there was a tear in the esophagus, so they're not going to put a scope down there and increase that danger. That air is from damage to the throat, not from compression to the chest, not because she fell down and people landed on her. That's not where that happens. That happens below. And the air that he saw was higher up in the throat area. He said it's better in 24 hours, but he can't say it's gone. Remember what he said? Like, it had not gotten worse. It wasn't gone. And he can't say it's gone because we don't do that kind of exam for that. We don't want to put that much radiation into this very small 17-year-old. Dr. Stankus is an ER doctor. She testified for the defense. She said pneumo mediastinum. She agreed. It can certainly result from strangulation. She agrees that the standard of care for pneumo mediastinum, the air that was higher up in the chest, to admit the hospital for observation and retesting, we don't send those folks home, right? It's not benign. It's not a mole. That was her example of something benign. We don't send those folks home. If you present with pneumo mediastinum, especially as the result of strangulation, you're getting admitted, and we're going to watch you because it absolutely is dangerous. And Dr. Kim said, I had significant concerns. We were worried about her. That's why we admitted her. And Dr. Stankus agrees. Strangulation can result in death. Then you have Dr. Gilbert's testimony, and she talked about being a child abuse specialist and a 30-year medical practice. And she gave all of those strangulation effects on the body that we've previously talked about. She talked about that jugular vein occlusion. Remember, 4 pounds? That's that lack of ability to remove the deoxygenated blood. 4 pounds of pressure. It takes about a minute to lose consciousness with jugular vein occlusion only. 20 to 30 seconds for petechia, 3 to 4 minutes for death, if there's only jugular vein occlusion. Carotid artery occlusion, slightly different. Greater pressure required for carotid artery occlusion. 11 pounds of pressure, you lose consciousness in 20 to 30 seconds. Death is anywhere from 1 to 3 minutes. It's a range, right? You can't say specifically, but it's a range. And she talks about that. She said when a carotid artery occlusion, you're going to see a more global result. You're going to see loss of consciousness. You may see seizures. Then you move to brain death or death and a loss of muscle tone. When Dr. Gilbert watches that video, she says, I believe that I see a seizure. There's a moment right after or right before she loses consciousness that her arms, I believe she says, flail without any movement. And prior to that, there's some significantly focused intentional movement. And then there's a moment of flailing, and then she goes limp. Fatima goes limp. Caleb says, that's the word he uses. Isaiah uses, she like frizzed, and then she went limp. So what are those kids describing to you? They're describing a difference between the moments where she is fighting, Fatima is fighting for her life, right before she loses consciousness. And I submit to you that is a seizure. And that is what Dr. Gilbert watches that video and believes she sees. She said, we can't test for it. That's not the kind of testing that we're able to do, but I submit that's what I see. And that is consistent with what the science says. And it's consistent with what the witnesses observe. So how do we know that we've gotten to the carotid artery occlusion? Because about 30 seconds in that 20 to 30 second range, when you watch the video, that is when Fatima loses consciousness. So we know we don't have solely jugular occlusion. We also have carotid artery occlusion. He is imposing enough force on that child's neck to create significant damage, great bodily harm, and the likelihood of death, but for the interruption. And that death can happen in 1 to 3 minutes. Tracheal occlusion results in the lack of oxygen to the brain, that buildup of pressure. And again, Dr. Gilbert describes there's going to be immediate panic. You've got that CO2 buildup that's telling your brain that you have to breathe, and then it results in death. She describes observing the pneumomediastinum, the subcutaneous emphysema, that air in the throat, and anytime there's obstruction of either blood or air to the brain, it is a life-threatening injury. So Exhibit 72 and 103, the petechia described, you have synovia rivus on the left-hand side, and how do you know that it's petechia? Because it doesn't exist a couple of days later. 3 days later, it has resolved itself in Exhibit 103, and that is the distinction right between those two. October 21st, the photos show the bruising and scratches that cover from the left to the right side of her neck, consistent with the arm placement and pressure for her carotid artery, her jugular vein, and that tracheal occlusion. And you see that all in that space right there. Again, Exhibit 74, same, these are 3 days later. The bruising and the scratch is consistent to the front of her neck, where Fatima is scratching and clawing at her dad's arm to get it off of the front of her neck. That's the tracheal occlusion happening there at the front. Remember, your carotid and your jugular are on the side, and your trachea runs right down the center. Exhibit 81, the side of her neck, and that bruising goes all the way over to the back side of her neck. Again, consistent with the arm hold that is described by all of the witnesses leading up to that point, right? All of this bruising is the result of that, and that right arm and left hand in a chokehold from behind, and pressure for the carotid artery and jugular vein occlusion. So then element 2, again, force or means to produce bodily harm or death. Those symptoms reported in that video evidence tells us, based on the time and those symptoms experienced, that all 3 of those occurred in this case, which means the amount of time it takes to inflict the probability of death is grossly shorter. The force used would have resulted in great bodily harm or death if not interrupted. No injuries to her head are noted by medical staff or reported by her. Defense counsel, I believe in his cross-examination, said, well, if they hit that tree, couldn't this have happened? Couldn't this have happened? What if all of those symptoms are consistent with a head bump? And Dr. Gilbert said, some of them are. Not all of them, no, but some of them are. But also, I did a head to toe in none of those. There's no bumps on her head. There's no bruising. There's no tenderness. Clearly, there's no medical symptoms or science to indicate in any way that she struck her head. All of her injuries and damage is to her neck. All of the symptoms she experienced flow directly from that damage. And that's it. Element 3, acted with the intent to inflict great bodily harm. He's acting in anger for her defiance. That is intentional. That is what Ihsan Ali is doing. He holds her in a rear naked choke for just under a minute, and he is squeezing hard. He knows she is fighting. He knows she is struggling. He knows she is gasping for air. He knows that she is grabbing at his arms. And then she goes limp and stops fighting. But despite that, he continues to strangle her. So you know he is acting with that intent. He's ignoring the strikes and the screams of the kids. They are punching, they are kicking, and it has zero effect. It does not impact or change his behavior in any way. And that is an extended period of time. We know that he already has his arms, in fact, around her neck when they go down to the ground, and he doesn't throw his arms out to catch himself. He's going down with her, and he's gonna hold onto her neck no matter what happens to her in that process, from the beginning to the end. Because at the point that he grabs her by the neck, he is furious. And that is what he's acting with the intent with. It's not to restrain her, it's not to do any of those things. He is now just a grown man strangling a child because he is angry that she has defied him. He's only released Fatima when he is forced to do so by other adults. When you go back to that family household member, that is your B1 special verdict form again, nothing has changed. Back to physical discipline, that force used is lawful as defined, reasonable and moderate, purpose of restraining or correcting, and viewed objectively. So why does this not apply? Well, it applies for charged and lesser offenses. You're going to see that, and you have a whole range of instructions in there about lesser offenses. First, it must be your child. Okay, he meets that. It's his child. It's not somebody else's child. Must be for the purpose of restraining or correcting. It fails immediately there. None of this contact at this point for the assault in the first degree is for restraining or correcting. It is punishment. He's intending it for punishment of this child. Ihsan is angry. He may have gone to the bus stop to get Fatima and take her home, but by the time he grabs her, he is no longer doing that for the purpose of correcting her. I think one of the primary tenets of parenting is that if you are so angry you can't see straight, you do not engage with your child. You walk away. You don't attempt restraint. You don't attempt correction, because you are no longer acting in a manner that is for the child's purpose. By the time you make contact with that child, you are doing so for your own edification. That's exactly what is happening here. Parents don't correct children by strangling them. Parents don't correct children, restrain children by strangling them. It has to be objectively reasonable and moderate. You are deemed to be reasonable people. That's why you're sitting here. It has to be objectively reasonable and moderate use of force, and that is not what occurs in this case. It is unreasonable to strike a child with a closed fist or interfere with their breathing. The medical evidence proves that his acts interfered with her breathing. You have to consider the size, age, and condition. We heard that Fatima is 5'1", 100 pounds, maybe soaking wet. She's a small person. She might be 17 years old, but she's a small 17. And she is certainly grossly smaller than her father. We also heard the testimony of Tracy Arnold. This day occurred. Remember, Fatima's been home, being online. She's not been at school since about September 17th, so they haven't seen her in about a month. And Tracy Arnold, and she looked thinner, way thinner than the last time I saw her, and much more frail. So I submit to you that Fatima is particularly vulnerable. She already was with her size, but even now more so than she was just 4 weeks prior. And we also know that Fatima's throat is particularly vulnerable as a child. And Dr. Stinkus' testimony on behalf of defense also said, yeah, I mean, children obviously are smaller. It's easier to do damage to their windpipes. It's easier to do damage to their necks. She might be 17 again, but she is a small 17, and as a child, she is already more vulnerable than, say, an adult male, right? That placement of that force is extremely dangerous for those jugular veins, the carotid arteries, the trachea, and the spinal cord in the back of the neck, and all of the medical folks talked about that. You have a instruction in there that is very wordy, because again, we're lawyers and that's how we put things in a narrative. But I'm giving you a picture, okay? You start with assault in the first degree. That is what you evaluate first. You do not move on to any other instruction and evaluate it until you have completed assault in the first degree. If you have evaluated and deliberated on assault in the first degree, and you agree unanimously that he is guilty of assault in the first degree, you stop. You don't address assault 2, you don't address assault 4, you stop. Your inquiry is done. If you're like, man, I don't know, then on assault 1, then you move over. Whether it's unanimously not guilty or you're unable to reach a verdict, then you go to assault 2 and you start that process over again. I will tell you that as you go through, you may well say to yourself, well, these two are easy, these two are really obvious, we'll just do those instead. You don't get to. Your instruction says you do assault 1 all the way first, and then if you are unable to complete that, then you move to the other 2. You work your way down, right? But otherwise, your inquiry stops if you all agree unanimously that he is guilty of assault in the first degree. Same thing. Do not begin that analysis until you've reached a decision on assault in the first degree. So then we go to assault in the second degree, that lesser included. When someone intentionally assaults, as it relates to Isan, when the defendant intentionally assaults another and thereby recklessly inflicts substantial bodily harm, or assaults another by strangulation. You now have the definition of reckless, knows of and disregards a substantial risk, and that disregarding is a gross deviation from conduct a reasonable person would exercise in the same situation. And I'm going to show you a ladder here, that mental elements ladder. So remember we talked about if you do something intentionally, then you've done it knowingly. If you've done it knowingly, then you've done it recklessly. So it's a, when recklessness as to a particular fact is required to establish element, it is also established if a person acts intentionally or knowingly as to that fact, right? And that makes sense, because if somebody has disregarded a standard of behavior that is expected, and that is a gross deviation, then we presume that you did so knowingly. I'm sorry, if you've done so intentionally and knowingly, then we presume that you've also done so recklessly, right? It's incorporated therein. So substantial bodily harm, a temporary but substantial loss or impairment of any bodily part or function, or a fracture. And then you have the definition of strangulation, to compress a person's neck, obstruct the person's blood flow or ability to breathe, or do so with the intent to obstruct the person's blood flow or ability to breathe. It's a really obvious, I submit, definition, but we have to give it to you anyway. So count 2, assault in the second degree. These are your definitions. We'll come back to the bottom paragraph, but you essentially have to decide A or B, 1A or B, and you don't have to be unanimous about 1A. So as it applies, same information for October 18th, 2024 in the state of Washington. None of that has changed. So 1A, intentionally assaulted. There are 2 ways that you can, Isan Ali could have done this under the assault in the second degree. 1A, he intentionally assaulted and thereby recklessly inflicted substantial bodily harm. So the evidence you have of the intentionally grabs her twice. This is not an accident. He grabs her the first time and then he grabs her the second time. That moves into that rear naked choke with sustained pressure. Kids are pulling so hard that they have to dislodge him that they have ripped his jacket. And regardless, he maintains his hold throughout. That is intentionality. Can't breathe is a temporary but substantial impairment. Losing consciousness is a temporary but substantial impairment of any organ or function. If you cannot breathe, if you have cut off air to the jugular veins and the carotid artery, or excuse me, blood flow, jugular veins and carotid artery, you have temporarily but substantially impaired their ability to function in the way that they are supposed to. If you have cut off the airflow because you've crushed the trachea or closed the trachea off so the air can't get through, that is a temporary but substantial impairment because that bodily organ cannot function. If you have lost consciousness, your brain is not working the way it is supposed to. It is a temporary, even if you regain it, but substantial impairment because you are intended to stay conscious. That is what your brain is supposed to do, and his behaviors have impacted her ability to do so. Sore pain, sore, painful throat, difficulty swallowing that she describes well after the fact, temporary but substantial impairment, those changes to her voice, those changes to her motor skills, her ability to get up and move around. You've heard that described, that loss of muscle tone, temporary but substantial impairment, and then you have all of that bruising along her neck. By definition, that is temporary but substantial disfigurement. That is not how she appeared prior to, and we're looking at 3 days later and it's scratches and that bruising is still there, those abrasions. So then strangulation, 1B, Exhibit 34, you see him grabs at her neck twice. It's not an accident and refuses to release. You see, again, that's sustained pressure. A lot of that information is the same for strangulation as it was for 1A. You have that her face changes color. You have all of that bruising. And you have the medical reports and the nurse's testimony, and you have that she can't breathe. Again, doctor reports, nurse testimony, and medical reports. So all of that information is the same for 1B. You're going to consistently have overlap in the evidence between many of your charges. When you go to do that evaluation, you have to all unanimously agree that either 1A or 1B occurred. You do not have to agree which of 1A or 1B it is to find that element number 1 has been met beyond a reasonable doubt, okay? And then BB1, family household member, again, exactly the same. When we talk about count 2, as it separates itself, the lesser included for assault in the second degree from assault in the first degree, the initial placement of dad's arms around his daughter's neck and the impediment to her breath, that strangulation is complete. That's it. Assault second is done. As soon as he puts his arms, there's no requirement for loss of consciousness. There's no requirement for any of these other things to do. For strangulation, all he has to do is impede her breath. And the moment he puts his arms around her neck, and you see her standing there grabbing at them before they've even gone to the ground, assault in the second degree is completed. That extended hold of her neck is what distinguishes assault in the first degree from that assault in the second degree. That is why that is not merely assault in the second degree. It is also, but it is not merely. So that's where we were. Back to your roadmap again. If for some reason you're stuck on assault in the second degree, then you go back through that same process. If it's guilty, you stop. If it's not guilty, unanimously, or you are unable to reach a unanimous verdict as to assault 2, then you go to assault in the fourth degree. So there's that definition for assault in the fourth degree. It's simply committing an assault. No bodily injury required whatsoever. Nothing changes for counts 1 and or elements 1 and 2. And the back half of element 1 then, as it relates to Isan, simply that he assaulted Fatima Ali. The touching is harmful. We have all of that testimony of the parents, of those present, the kids, Mr. Denicola, the Wagners, all of the doctor and the medical. And then we have that the touching of Fatima is offensive. She's fighting it. She clearly doesn't want to be touched like that, like how he is touching her. There's no injury required for assault in the fourth degree. So yes, obviously assault in the fourth degree has been met by the evidence before you in this case. And then BBB 1, that's your family household special verdict form again. And that's where you end up. So last count for dad assault in the fourth degree as it relates to Isaiah. What that definition is, we talked about those elements. They are exactly the same as that lesser included was for Fatima, but now it is for Isaiah. We all are likely to agree that none of this information has changed and is not at issue in this case. It is October 18th. That is Isaiah Williams, state of Washington. So what evidence do you have about the assault 4 of Isaiah? That touching of Isaiah is harmful. You have the video of Isan punching Isaiah earlier in Exhibit 34. You have those still shots from Exhibits 8 and 9, 8 and 9 of him punching Isaiah in the head. Not simply a shove, not simply a push, but a closed fist punch to the side of Isaiah, his temple. And then you have the Exhibits 39 to 51 showing his injuries, that redness, bump, the pain. You have Officer Beltran described seeing that in person and taking those photos. And you have that testimony. And also, you saw Isaiah. It's physically much, much smaller than Isan. And you saw him when he was present here, and you see him in the video. They are not the same size individuals, right? And you know that touching is offensive. First of all, I submit to you punching anyone in the head, unless you are engaged in a boxing match, which you've signed up for, is offensive, right? Punching a child in the head is particularly offensive. Notably, no injury is required, but it exists here. There is that bump, that redness, and that swelling and that bump to the side of Isaiah's head. And you see it there, consistent with where he says he is struck and with where you see Exhibit 51, that closed fist strikes him in that bus video. So then you also have the self-defense instruction that is given to you for Isan, saying, well, I'm forced essentially to do this, and the state has to disprove that. So as it relates to count 4, force used by a person who reasonably believes he is about to be injured and the force he uses is not more than necessary. The person using the force may employ such force and means as a reasonably prudent person would use under the same or similar conditions as they appeared to the person, taking into consideration all of those facts and circumstances known to the person at the time of and prior to the incident. Then you have a definition for necessary, as they reasonably appeared to the actor at the time. Not as he claims that they appeared or he'd like them to have been, but as they actually reasonably appeared. That there's no reasonable, effective alternative to the use of force and that the amount of force used was reasonable. And you have that in your definition. There's no duty to retreat, to be very clear. If somebody is attacking you, you're not required to retreat. But still, there's the requirement that the lawful force be not more than is necessary. You don't get to do whatever you want plainly. There are limitations on what force you get to use in response. You also cannot be the person that physically instigates that interaction in order to create the likelihood of provoking a belligerent response from someone so that then you can use self-defense after the fact. And you have that instruction there as well. So why is this not self-defense? First, that force is not lawful. He does not reasonably believe that he is about to be injured when he strikes Isaiah. He is not striking Isaiah to himself. That's not what he is doing. And you'll look at those photos and you'll look at that video again. He is striking Isaiah to prevent Isaiah from interfering any further in his mind with what he gets to do to Fatima. It is objectively unreasonable what he does to Isaiah. He is grabbed at the point that strike hits, and you'll watch that video. He has already grabbed Fatima by the hoodie and he is dragging her by her neck into the dirt. And Isaiah's him trying to pull him off. Isaiah's not striking him. Isaiah's literally trying to disengage Fatima from her dad, who has her by her hoodie front collar and is pulling her forward. It is already choking. That has already started. That is an unreasonable means of restraining your child, I submit. And Isaiah said, just like grab her, like, let's go home. That's not what happens. He's like, he grabs her aggressively. And remember that Isaiah has known Fatima at this point for a couple of years. And he says, I know Fatima. I know what she goes through. And so he is anticipating that this is not simply a, let's go home and have a sit down family talk about it. He is concerned deeply for what might physically happen to Fatima. And almost immediately, when she's getting ready to go, Dad grabs her by that hoodie and starts dragging her. And Fatima says that. It is, as we saw from the parental discipline, our laws recognize that it is objectively unreasonable to throw, to strangle, or punch their own children with a closed fist, let alone someone else's child. And that's when we give more leeway to parents, right? If you look at that video, he's not striking, Isaiah's not striking Isan. The evidence does not support that finding. And we talked about the size of Isan compared to 16-year-old Isaiah, who is 5'5". He didn't know how much he weighed, but I submit to you that he's a pretty thin kid. He's not a big kid. And he's also not punching a grown man who is in the middle of throwing a punch at him. That force used by any objective standard is unreasonable. You heard Elijah describe thunk. He's like, I heard that thunk when it hit. He's punching Isaiah in the head with a closed fist. It's not okay to do that, especially not when and how that punch occurs. It's for the purpose of neutralizing Isaiah so he can get to Fatima. It's not for protecting himself. It's not self-defense. Isan has created this situation. Isaiah did not. Isan's intentional actions were reasonably likely, I submit to you, to provoke a belligerent response from those present. Isaiah to be closest and have the most background information. We talked about that. And from the get-go, Isaiah is trying to assist Fatima, who he believes to be in physical danger. And he's right? And notably, when you look at this self-defense instruction for defense of others, Isaiah is entitled to protection under the same legal principles. So if anyone is entitled to defend themselves, it would be Isaiah. Those strikes by Isaiah on Isan do not occur until Isan is already strangling Fatima on the ground. There's a lot of, well, he hit him like 42 or 32 times, whatever number defense counsel proffered. That doesn't happen until after the fact and they're already on the ground. Isaiah has not struck Isan when Isan punches him in the head. There is the initial, and you'll be able to watch it in Exhibit 5. There is the initial contact, and when you look at that video, when you look at those photos, you'll see he's already dragging. He already has a hold of Fatima by the front of her hoodie collar, which is what Fatima describes, and Isaiah is trying to pull them apart. And see, there's another example of Isaiah, Isan dragging Fatima by the front of her collar, and she is pulling back, and Isaiah is trying to dislodge them. Exhibit 6. You go to Exhibit 7. All he is doing here is, again, trying to get him to let go of his daughter, who he has by the front of her collar, and is throwing her on the ground. That is what Isaiah is doing during the course of this interaction. And now Fatima's down. He's thrown her on the ground, and look at what Isaiah and Isan are doing. Isaiah's hands are out. They're out in the, what are you doing, man? What is happening? Oh my gosh. His hands are down by his side and they are out. And what is Isan doing? He's grabbing him by the front of the collar, and then bam. And look at Isan's face. Does that look like the face of an individual who is protecting themselves? Or does that look like the face of a guy who's real angry? real angry that this kid had the audacity to interfere with how he has decided he wants to parent his child. I submit to you that's exactly what that face is. That has nothing to do with protecting himself and everything to do with exerting his anger and his power and control over this other child that is present. He's not being attacked, he's being thwarted, and he's being interrupted, and he doesn't like it. It's happening because Isan is mad. The force he uses is neither reasonable nor is it moderate in this case. It is not a necessary use of force in either the timing of when it occurred to protect himself, nor is it a necessary amount or reasonable amount of force being used. So now we are at Zara Ali, count 2, assault in the second degree. That completes all of Isan's charges. We are done with Isan. We have hit a milestone. Element 2, pertaining to Zara Ali. The on or about October 18th, assaulted Fatima Ali by strangulation. When you look at this element itself, this count itself, you will note that there is only one type. Whereas with Isan assault in the second degree, we had 1A and 1B, we have those alternatives. For Zara, we only have strangulation. Again, October 18th, state of Washington, none of that changes. Intentionally assaulted, Exhibit 133. She intentionally grabs Fatima at the neck, not an accident. That mom is holding Fatima around the neck at about 2 seconds, grabs it again in 8 seconds, and then those screenshots show that location of her arms, like we talked about before, that she's being pulled backwards. That strangulation for assault too, or that same behaviors, that is separate and apart. You also have that Fatima testifies she can't breathe. In a run, and mom is grabbing her by the throat, and Fatima's pushing her away. Mom is not giving aid, mom is not asking if she's okay. Zayla says she's just trying to grab her and she's grabbing her by the throat. Athena immediately knows it's wrong, and she says so. Like, what are you doing? Mr. Leary asked her a question about whether it's mom or sister, and you remember you heard Athena go, it was mom, and then she goes, well, now that you're asking me and pointing the video, I'm not sure if I know if that's mom or sister, but she is correct. We know from the video it's Zara. Visible, standing away from Fatima, so we know that Penny never puts hands on Fatima. As far as the video shows, we know that it's Zara the whole time, and Athena is correct. So now the child, again, got confused in terms of the direct examination questionings by Mr. Leary, but you watch the video and you know that she is right. She says, mom grabs her by the throat, and I said, what are you doing? You can't do that, because she just watched it happen. Even Athena, who has no medical training whatsoever, knows that that is not proper, and mom has done that. And she is correct. And then you have the testimony that Zara, she's holding on to her by the throat to both keep her from fleeing and to continue those efforts of dad. And Fatima is fighting dad as well. There's no indication by anything that we've seen in terms of evidence that somehow Zara is below average intelligence or has some sort of eyesight problem. Nothing that interferes with her ability to perceive what everyone else testifies about over and over and over again is clear and obvious. Even to Josh Wagner, who after Zara is already on scene, right? She knows that her daughter is unconscious. She knows her daughter is injured because they were her arms helping to do it, and she doesn't ask if she's okay. Just let me talk to my daughter. Those are grossly different response, and you saw the video of that. The grossly different response for the arrest of her husband and the strangulation of her child. And let's be clear, the state's not saying that there is some sort of anticipated, expected response, that everybody's response to an emotional situation has to be a particular way or it has to be consistent. We know that that differs from person to person. But when we're talking about Zara's response for the arrest of her husband compared to the strangulation of her daughter are demonstrated by Zara on body cam to be grossly different. And then we have the strangulation, the medical reports, the doctor and nurse testimony. So the physical discipline defense for Zara is the same analysis as it was for Isan. It is unreasonable to interfere with a child's breathing. That is an inference that you get to make based on that description. Nothing changes about the size, age, and condition of the child. And nothing changes about the location of the injury to Fatima. And that's same special verdict form for assault in the second by Fatima, or for Zara on Fatima. Count 4, burglary in the second degree. Burglary in the second degree occurs when you commit the crime of entering or remaining unlawfully in a building with intent to commit a crime against a person or property therein. That's the definition. Then you have the definition of enter or remains unlawfully. That is again in your instruction packet. You enter or remain unlawfully in or upon premises when you are not then licensed, invited, or otherwise privileged to enter. So enter or remain. Guys, that also means that when somebody has trespassed you from what otherwise would be a public place, that means that you are no longer licensed, invited, or have the otherwise privilege to so enter and remain. Instruction number 44, a person who enters or remains unlawfully in a building may be inferred to have acted with intent to commit a crime or person therein. This inference is not binding, and you decide what weight, if any, to give it. That means the state does not have to also charge underlying offenses and also prove those beyond a reasonable doubt. You get to infer, if you so choose, as to the defendant acting with the intent to commit a crime against person or property therein. And then there are your elements. October 18th, entering or remaining, state of Washington. This slide probably looks very familiar. Again, it doesn't change. Elements 1 and 3 happens on October 18th. It happens in the state of Washington. Backside of element 1. Unlawfully in a building. How do we get to the point where she's unlawfully in that building? You heard the testimony on September 16th. That incident occurs with Isaiah on campus. You hear that Celeste Walter corroborate that, and as a result, I trespassed Mrs. Ali from campus and all North Thurston School District property. You heard the testimony of Ms. Waltermeyer and Officer Howard on September 17th. Haneen comes to try and pick Fatima up early from school, and the school says she needs to stay and you need to tell your mom to come have a meeting with us. So later that afternoon, Zara returns. She meets with Celeste. She meets with Officer Howard in Celeste's office and is presented with that trespass order and those instructions about the order by Officer Howard. You have further that when Zara returns and they serve her with that trespass order and she's given those instructions, Officer Howard offers Zara the language line. And you heard what the language line is. The language line is, if you don't understand, the document that's been provided to you is in English. If you don't understand or you're not comfortable with that, we can provide you assistance. Would you like someone who speaks Arabic directly to be on the language line and have this conversation with us? You can choose to take it, you can choose not to take it, that's your choice. Zara declines the language line. She does not want the language line. Instead, she asks for Haneen to come assist. So Officer Howard and Celeste say, sure, we'll wait. So in the meantime, they're chit-chatting with her in English about a number of topics. And then Haneen, Zara's request, arrives and they go over the order a second time while Haneen is present and assisting. You hear the testimony that she's offered chances to ask questions. She has specifically identified to her the places she can and can't go. You can't go to the baseball fields. You can't go here. You can't come to the building. You can't come to pick up your daughter. It's fine for Isan to come pick up. It's fine for Haneen to come pick up. This only applies to you. You are not allowed to be on the property, period. She has a chance to ask all of those clarifying questions about the parameters. She's given the phone number to call if she has any further questions. Defense counsel said, well, there's nothing on there that says she can appeal that decision, right? There's no requirement. And you're not going to find it in your instructions anywhere. It doesn't exist. She's given a sheet that describes what she is to do. She's been orally advised twice with the interpreter of her choice. She speaks English, to be clear. It may not be her first language, but there are consistent interactions with English. No one's saying that her English is great, but it is certainly enough. You heard Fatima's testimony. They've lived in the United States since Fatima was 6, so we're at 11 years at this point. And Zara is able to communicate in English with these women, and she has done so consistently, and that is described. But even with that, she asks for Haneen to come, they wait for Haneen, and they go through all of this. And that phone number is pointed out and identified. Here, if you have further questions, then call this number. And per Ms. Waltermeyer, that never occurs. There's no questions about it. It is a clear, self-explanatory order that is accompanied by oral explanation. And then you have that trespass letter itself at Exhibit 121. Then on October 18th, she violates that order. She enters or remains unlawfully in a building because she is not allowed to be in that building. You have that she arrives on campus, where she's already expressly been told not to be. She understands that. Moreover, Haneen, the person that had that conversation while she was present, is with her. So Haneen knows as well. She's not there by herself. Then when Fatima escapes her the stranglehold, she chases her into the main office, inside the school building, where she is not allowed to be. She not only goes into the building, she goes into the office and tries to continue to go through the back. And you heard Tracy Arnold say, I had closed those doors and I was using my weight to try and hold those doors closed because I could still hear her and Denise Kinley yelling back and forth. She then leaves, and you see her in the video try and go through the side doors, and Principal Dean cuts her off. Got that intent to commit a crime. The entering or remaining is with an intent to commit a crime against a person or property therein. She knows husband of just strangled is in there. She has demonstrated at this point her ability to physically assault a child. She knows Isaiah. She chased them. She ran after them. And we've heard it over and over again. In her story, there's no evidence to support that whatsoever. If anything, Isaiah is the kid in the story that everybody would, I think, like to have as their kid. He is kind. He is respectful. He is there to help out friends and look for danger to people that he knows are particularly vulnerable. And he demonstrates that on the stand. But she blames him and his family for everything. I submit to you, you heard from Victor Barnes. Victor's Isaiah, listen, we tried to engage. We tried to have a reasonable conversation. We tried to be respectful about what the parents wanted, what Isan expressed he wanted. And so we said, you guys can't see each other. You need to take a break, right? And he was not like over dramatic by any means. He said, I understand that parenting is hard, right? Everybody agrees that parenting is hard. I think everyone would agree that parenting teenagers is not for the faint of heart. It is difficult for sure. And we've talked about that at length. But this goes well beyond that. And Victor says, I understand it's difficult, but you know what? They're teenagers and they're in love, or they think they're in love at least. What are you going to do, right? So we put some boundaries on it, we put some guidelines on it, and it didn't pan out. And this was the response. And for Zara, that is all Isaiah's fault. That is his fault, his fault, his fault. And so what is she doing? She knows there's a no contact provision, so what is she doing when she goes in there and chasing him in? She knows she's violating that order, and she intends to violate that order. She knows she has that with Isaiah. She has to stay 1,000 feet away, and she knows that he is in there because she watched him go into that building. The intent to commit a crime against a person or property therein. Again, I don't have to prove, you don't have to find what crime the defendant acted with the intent to commit therein. That's not in your instructions, and you're not going to find it because it doesn't exist. It could be any number of them. A further assault of Fatima, an assault of Isaiah, a further violation of the no contact order with Isaiah. You must only determine that the entry or remaining within the building was with the intent to commit a crime, but you need not actually identify that that crime has occurred. So there we know she's going in the building because she's actually in the building, right? Exhibit 110, page 6. We know she's in the office itself because there she is, bottom heading towards those back doors. There's Tracy Arnold, exhibit 111, page 9, running through to try and get in front of her because, as you said, when she closed those glass doors at the front of the office, main office, Mrs. Ali goes around her. And there she is yelling at Miss Kinley and arguing, page 11. And still arguing with Paul Dean in front of that campus expectation sign. We know she's not allowed to be. Now, mind you, the burglary doesn't happen until she enters a building. The burglary itself is not for simply being in the parking lot or on the property. The burglary happens, in this case, when she enters the building because that is the definition, okay? So just make sure you make that distinction. Last crime, we're almost there. Count 5, violation of that no contact order with Isaiah Williams. So violation of the court order, you commit the crime of violation of a court order when you knowingly know of the existence of the order and you knowingly violate one of the provisions that's identified within that order. And you have, again, that element instruction in your packet. 4 elements altogether. We're going to go through those elements with the evidence that you've seen for each of those elements. 1 and 4, seen this, same instruction, right? You don't anticipate argument or significant argument, but you still have to find that the state proved it, and you have to find the state proved it for each count that exists, okay? So the court, here's the order, exhibit 36, page 1, that you have. You have the court that has issued that order. Let me go back up for 1 second. There existed a protection order. So let's look at the back half of element 1, existed a protection order. Exhibit 36, page 1, you have the court that has issued that order, Superior Court of Washington, Thurston County. You have the protected person, or you have the effective date until October 24th at 9 a.m. And then you have this order restrains, and then Zara Ali. So clearly identified as the restrained party. It's not an overly complicated order to read. Then you have section 3 on page 2. Protected minor is listed on section 3. There's your section 3 when you're looking for it right there underneath the red dot. And that order protects Isaiah. Page 4, here are all of your provisions that she is restrained from doing and clearly outlined. No harm to Isaiah. And the minor listed in section 3 above. No contact with Isaiah or through a third person. No stalking of Isaiah. Passing, following, monitoring of Isaiah. You have the exclude and stay away by 1,000 feet from Isaiah. His school, himself directly there under D, element D. And then stay 1,000 feet away from the listed residents, and they put in their own listed residents specifically because by that point they know, mom and dad already know where they live because they've shown up at the house, and you heard Victor talk about that, right? That he tried to reason with them, he tried to talk to them, he tried to avoid this, and he was unable to do so based on the way events had been unfolding because they showed up at his house. So the elements that the defendant knew of the existence of this order, you have Officer Hang's testimony that he serves that order on October 16th. Remember that it is issued, let's go back. It's issued October 14th. That's when the order is issued. 2 days later, Officer Hang serves that order. Exhibit 37, you have that proof of service that Hang files with the court. And then you have Exhibit 38, the body camera of that service. He serves it on Zara at her home. You watch that. You see that Haneen is with her at the time of the service, again, at her request. Haneen says, can I stay? I help my mom. Yeah, sure. The two women are communicating with each other back and forth about that order as Hang is describing it. Zara asks questions about it herself in English of Officer Hang. Haneen also asks clarifying questions. You know they understand that Mrs. Ali, Zara Ali, understands what that order is because she demonstrates that. He in fact points out the number to call in the document if she has further questions. He explains it to her in basic terms. He doesn't use overly complicated terms, and it's not a complicated document or set of directives to comply with or understand how to comply with. Moreover, you see her ask that clarifying question. Wait, so if this means I can't contact him, does this mean he can't come to my house either? She understands what the limitations of that order are. Does that mean that if I'm here and he comes to my house, then he gets in trouble too? Well, what does Officer Hang say is, well, if he comes to your house, like you have a right to be in your home, you can call law enforcement if that's the case, right? We know she understands the order. She asked that clarifying question. She provides alternative situations and is trying to decide how that order, those alternative situations fit into this order. So we know she understands what the limitations of that order is. And she has, again, her chosen interpreter present with her, and she's communicating with her throughout. She doesn't demonstrate at any point that she doesn't understand how she is personally restrained, or demonstrate confusion about how she is personally restrained. And then you have element 3, the defendant knowingly violated that restraint provision, prohibiting contact, excluding the defendant from a school, prohibiting the defendant from knowingly coming within a specified distance of the location. So on October 18th at about 2:13 p.m., she's certainly within 1,000 feet of Isaiah. She's physically engaged with Isaiah, and then she chases him and her daughter into Timberline High School, certainly within 1,000 feet. And then you have it again at 2:13, she's in 1,000 feet of his school grounds itself. So there's 2 separate provisions that she has violated. And then she knows exactly some confusion about who Isaiah is, says his name. She tells Hang and Bell and Chavez, you see that in their body cameras. He goes to school here. She knows where Isaiah goes to school. He's a student here. And he just said, Isaiah James Williams.
First Coast News Plus. Right now, you are tuned into the Hakeem Robinson murder trial, aka Queso. Here's what we know. Today is day 5, and we're returning in from lunch recess. Today, we've heard from forensic experts. Queso is charged with the murder of Charles McCormick on January 15th, 2020. You're tuning in to First Coast News Plus.
I suspect that the state is going to rest after this witness. I think this is their last witness that they're calling. So y'all know how it go. We should get some of the defense witnesses this afternoon. So stay tuned, folks. Yes. Yes, D Wood. So we are going to find out if they're going to let Queso's mom testify after this break. Yeah, I don't think she's going to allow her to testify because, regardless, they did know that he was going to identify Queso at some point prior to today. I know that the argument was really around him using the video to make the identification, and that's basically what he's saying. He opened the door once he did that, but they should have already labeled her as a witness, and she should not have been able to listen to Senior's testimony. All right, they invoked their rule. The defense invoked their rule. So unless they got some case law to support what they are intending to, unless they got some case law, I don't see her ruling in their favor. I think she's gonna rule, against it. And here's the thing, right? The judge is supposed to rule in light of the prosecution. Like that's the way that it goes, in the best light for the prosecution. But she's supposed to be fair, and we gonna see. We gonna see. Oh, it absolutely would have made the case a pinch more. Um, it absolutely would have made the case a pinch more interesting. I mean, this case is already interesting. It ain't lacking nothing. You want drama? You got drama. You want lawyers going at it? You got lawyers going at it. You got guilty, Scotty guilty. But I think that it'll be interesting to hear her just come back and say, like, yeah, no, I'm not gonna allow that. They are supposed to be back, Vernisha, but we are just waiting. We don't know what's going on. They were supposed to be back 20 minutes ago. Yeah, I think I think anybody can be looking and be like, okay, yeah, this might be my person, this might not be my person. But he got on the stand and said that he didn't see Queso that entire day. How you know that that's what he had? I don't know. How you even remember this? The man got up there remembering everybody's phone number, couldn't remember address, but couldn't remember emails. Child, I don't know, y'all. I don't know. You know, to each his own. To each his own. He don't know what that boy had on that day. He hadn't seen him. To be honest, ain't no telling when the last time he had seen him. Cause get your butt out of here. But that's why I think they want to rebut some of the stuff that he said, because Queso's argument is that he wasn't really involved with his management. And the prosecution was like, you were involved. Here's the contract. You signed it with your son. Your son signed it, yeah. But was there a falling out? Was he the manager for a while and then he went with a different management company? What occurred? They also said that he didn't show up until Queso started getting buzzed. He started having, he had a little pop about him. So to me, I don't know. I don't trust Junior. Morley up in his office when she's not supposed to be, and she up here playing with drawers. And I think she accidentally pinched her little finger trying to close the drawer. Can you identify your child if he had clothes on, a hoodie, and a mask? Child. It depends. Like, my son got special needs, so yeah, I can identify my son anywhere. He moved funny. He moved the way that I could tell by the way that he moved. Well, I say he moved funny. It's not nice, but he moves different. So it's very distinctive. So I can't say like if it was my daughter, right? Well, she high yellow, okay, and move. She moved funny too. Well, maybe that's just the movement of the child, right? I don't know. That's a good question. I ain't confident. Not to be saying what with 100% accuracy that that's my child in the middle of a daggone criminal case. Now I don't know if I'm gonna be able to do all that. I don't know, because I need it beyond a reasonable doubt that that's my child. But I also wouldn't be testifying against my child either. So, I don't know. I don't know. Aaron says that's not even why I don't believe him, though. The fact that he's willing to say whatever the government wants him to say in 3 other cases that we know of, that's suspicious to me. It is. Very suspicious. These folk, they're going to say whatever it is they want to say to get out of jail. That man even paused before saying, yeah, that's my son. Like, he didn't even want to say it. I don't know. I don't know. Okay, I don't know what they got going on with this here court, with this here trial. We're going to jump back over to closing for Ali until they decide to put the feedback on.
That order, there's no confusion. She knows exactly where his school is. There is no confusion. She knows she's violating that provision of that order. She just doesn't care because it doesn't matter to her. She doesn't care. There's Exhibit 134. There's Isaiah before everybody starts running. There's Exhibit 108, page 2. There's Fatima and Isaiah, Zara right behind with Haneen behind her, certainly within 1,000 feet there, certainly on the school grounds, while Isaiah. Page 109 again, you have them running, and I believe that's at 2:20 of that video, of the 2-minute and 55-second video. Again, you see Fatima and Isaiah. And at 2:41, 21 seconds later, you have Zara chasing after them. She's about 20 seconds behind them in her run, and certainly within 1,000 feet of Isaiah. So that is it. At the conclusion of all of your deliberation, I'm going to ask you to return verdicts of guilty on each of the charge counts and findings of yes for each of the special verdict forms for Isan and Zara Ali as the state has charged them. Thank you.
Members of the jury, at this time, the bailiffs will lead you back to the jury room. We anticipate a 30-minute break, but if you are not done eating lunch after 30 minutes, you tell the bailiff that, and we'll have a longer break. When we return, we will start with the closing arguments by Mr. Kading on behalf of Mr. Ali.
For his testimony. We know from Mr. Barnes and we know from Noah that they were in love. That's what we heard. What we didn't hear, though, was that Mr. Ali knew about that prior to at least September 16th. He did not know that Isaiah was his daughter's boy. He did not know she was in a relationship. He had no way of knowing because she hid that from him. We heard from Isaiah, for example. They had clandestine meetings in the park. They didn't interact with each other's families at all. We know that Isaiah's contact with the family consisted of talking to daughter Haneen on 1 or 2 occasions, and that was it. We do know that Isaiah and his family was aware that Fatima was not to be dating. But they disregarded that, chose to anyway. In order to do that, they had to keep everything secret. So they're living in a secret world. What else do we know about that? We know that all of the information that came to Isaiah was through Fatima. He didn't have contact with anyone else to find anything out. He didn't have a way to corroborate what she was telling him. She was just taking her at her word as to what was happening, right? The problem is, as we found, Fatima is what we would like to call an unreliable narrator, right? She tells stories. She doesn't always tell the truth, but she's controlling the narrative on the non-Ali family side, which includes not only Isaiah, but his friends and the school. We know that Fatima has contact with them. We know that the family contact with the school is pretty limited. As a matter of fact, after September 16th, family contact with the school was 0 until October 18th. Now, we could go into a lot of reasons as to why there was no contact, but it seems pretty clear that when Assistant Principal Walter Meyer decided that Zara Ali was no longer allowed at the school, Zara Ali took steps to put her daughter in a different school. To North Thurston High School was her choice. Eventually, she got set up in online school. Okay? So, where do we get to on October 18th? We have a situation where Mr. Ali is pretty much in the dark. We know from Mr. Barnes that Mr. Ali talked to him on the telephone, apparently, on the 16th of September. Mr. Barnes said he called him, talked to him. We know that Mr. Barnes said that Mr. Ali came to his house the weekend before this incident. And that is what prompted him, at that point, to go get the restraining order on the 14th, which was Monday. Okay? So that is the contact that they've had as families. There's been no talk about the kids. There's been no talk about this relationship. There's been none of that. Okay? And Mr. Ali knows nothing about Isaiah. He's never met him. Never seen him. Okay? So The scene that we have on the 18th is a situation where Fatima has decided that she's going to run away from home. Okay? Why does she want to run away? Because she doesn't want to travel with her mother, her sister, and her 2 little brothers to Iraq. Now, she's been to Iraq before. She said it was okay, but she said there were times that she didn't feel safe. She goes to school after running away on the 18th and talks to her counselor. Let's back up. We know that she was planning to run away because we know on the 17th she said she set her alarm for 4 a.m. so that she could get up and run away the next morning. She gets up, she gathers a few items, she runs out of the house before anyone else is awake. We know that she's hiding out. She goes to between Walmart and Safeway, she goes to the bus stop, she's going around hiding out so that her parents won't find her. She says at some point she saw her parents driving around looking for her in the morning. We know the parents called the police that day, talked to Dr. Hang. Early morning, he said about 8:30. He talks to them. They say she's missing. We don't know where she is. Now, at that point, he doesn't fill out a runaway report. But what does he do? He goes and checks a couple of things. He goes and checks around Safeway. He goes and checks at Isaiah's house. And apparently, according to him, has Isaiah's mom call the school, I guess to see if Isaiah is there. I don't know. I don't know that they would tell her if Fatima was there. But we know the officer Hang did not follow up with the school himself. Okay? So, we have Fatima going to school. I think it's telling what she does first. She goes to a first period class so she can talk to Isaiah. Isaiah, she says to him that she's running away, tells him the story. He's like, okay. She goes and talks to a counselor. She talks to her former mental health counselor, Liz Robinson, and she's talking about, oh, we need to help you because going to Iraq, you don't feel safe. Now, it's an interesting scenario with Mrs. Robinson because she's able to call law enforcement or CPS if she thinks someone's in immediate danger. But she doesn't do that in this case. And she chooses not to call the Ali's at all. She said, well, I have confidentiality. Fatima didn't want me to call. Okay. So the scenario now is Fatima's run away. Her parents have no idea where she is. They've called the police. Fatima's at the school. Nobody from the school calls the Ali's to say, your daughter's safe. I mean, I don't suppose they're required to say, we're calling from the school, your daughter's safe. They could just call and say, your daughter's safe. Don't worry about her. They could do it anonymously. Hey, we have your daughter. We're talking to her. But they don't. They choose not to do that. They leave the Ali family in the dark all day. So, what do the Ali's do during the day? They talk to the police. They're looking around for her. Apparently, according to Walter Meyer, the other daughter, Nora, who we didn't hear much about, was seen at Timberline that day. Now, we don't know why she was there. She wasn't a student at the time, but we can assume maybe she was looking for her sister. Just putting it out there because she was on the videotape in the school. All right? Now, what's happening during the day? Liz Robinson is coordinating to help Fatima get out of her own house. She's arranging shelter. Now, remember, there's no imminent danger. She's just arranging shelter because Fatima has told her, I don't want to go to Iraq. I don't feel safe. She said it was okay, but I don't feel safe all the time. Now, that's an issue right there that's a parental decision on where your kids go. If you're going to Iraq, and you want to take your child with you, that's your choice. It's not somebody else's choice. It's your choice as a parent. So what Liz has done, excuse me, Mrs. Robinson, what she's done is now she's inserted herself into a family decision, right? She's telling Fatima, you don't have to go home. You can go to a shelter. I'll help you. And they get it done. Again, nobody's talking to the Ali family. Nobody's telling them what the plan is. They have no idea. So what else happens that day? Well, we know that Isaiah talks to her again, fourth period. We know that after school, Isaiah meets her at the front of the school. She waits for him, and he comes out, and they go to the bus together. Now, at this point, they walk past Mr. Ali's truck. Let's see if I can get that up there. This is exhibit 106, page 3. We can see there, right here in the sidewalk, Mr. Ali's truck. Oh, nice. Mr. Ali's truck is right here. So clearly, they see Mr. Ali. Mr. Ali can see them. Now, interestingly, the time on this photo, if you look down in the corner, it's not the time of day. It's just the time of the extent of the video, 9 minutes, 29 seconds. Okay? If we look then at page 5, the same exhibit, we're going to note now that Mr. Ali has moved his truck from this spot and he's driving over towards the bus stop. Okay? Now, why is this important? It's important because there was a 2-minute delay there. Okay? Mr. Ali did not immediately jump out of his truck and go grab his daughter. We don't know what he did at that point. We do know that a couple of minutes later, his wife and daughter show up at the parking lot. Okay? So, Mr. Ali is not going, obviously, to the parking lot to grab his daughter because he sees her walk by and he doesn't grab her. She goes off to the bus stop where she's talking to other students. And we know Isaiah's talking to other students. He's talked to Noah. He's talked to, I forgot his name, but he talks to Noah. We remember Noah. They're in love, man, right? That's Noah. He talks to him and says, be prepared. Be ready. Isaiah himself says, I was ready for anything. Okay? So this is occurring while Mr. Ali is in his truck. He has no idea what's going on. He's never even seen Isaiah before this point, right? In his life, he's never seen him. Mr. Ali drives over to the bus stop to go talk to his daughter. Okay? He talks to his daughter, as we heard from several witnesses in a calm voice. You got to come home. She says, no, I don't want to come home. He goes, come home with me. This goes on, back and forth. She refuses to go. Okay? She's his 17-year-old daughter. She's a reported runaway. He wants her to go home. She doesn't want to go. That's where we are. He reaches out and touches her, grabs her shoulder. That's what we heard. Grabbing her shoulder in this situation is not an assault because, as we saw in one of the instructions, you have the right to control your child, right? Parental discipline. You're coming with me, okay? At that point, Isaiah interjects himself into what's happening, okay? What does he do? He says, well, I tried to push him away. Let's take a look and see what we can find here on the video. This is Exhibit 34, the bus video. If we can turn that on. And this is the frame from 2:13:14 seconds, frame number 6, and they're all individually framed. Now, I just noticed, ironically, if you look right here on the left side where the arrow is on the right side photo, there is Haneen and her mother's car that's just now getting to the school. All right. But let's take a closer look at the view of what's happening at the bus stop as the bus comes into view here.
Mr. Kading, can you indicate which camera view
Oh, yeah,
this
I'm
is?
sorry. This is the road view of Exhibit 34 at 2 minutes, 13 seconds, and 14. All right, hang on just a minute here. Let's back up just a little bit. And I've stopped it at 2:13:17. All right, get caught up here on my timeline. Okay, 2:13:17:5 is where we're going to go. And that is going to be 5 frames from here. Now, if we look in this frame right here, we can see Mr. Ali. He's right there, okay? He's standing there. Some of the other people are standing there watching him. There's been no physical contact yet, but you can see something going up in his eye, in his face there. And what you're going to see is you're going to see that it's Isaiah's hand pushing him away, all right? So let's watch this slowly in quarter speed from 2:13:17 to 2:13:18. You can now see the hand right there in front of his face, okay? Now, you can see he's walking backwards and he's still got Isaiah trying to hang on to Fatima. And if we stop it right there, this is just after the punch to Isaiah. Now, if we add on to this view the front door photo, right next to it, you can see, here they are on the right side of the photo. There's a punch here. Now, what you're going to see is you're going to see Isaiah take about 2 steps, and he's going to turn around and he's going to point at Mr. Ali, and he's going to yell to some friends, okay? And you can see that here in the video. Let's play that. Quarter speed, we'll play it. Watch that video on the right. You can see Isaiah doesn't hit the ground. He doesn't go down. He just stands up and he points right there. And then at that point, he starts running towards Mr. Ali. Okay? Now we're back on the left side. You can see him taking...
You're going to give the time that you paused.
Oh, I'm sorry. This is 2:13:25. All right? So let's close this one out. And then we're at 2:13:25, and you can see up here on the right underneath this tree is Caleb, who's going to be coming in here in a second. Now, on the left, we got Mr. Ali, and we've got Fatima who are kind of been, we can back it up just a little bit. Let me back it up just a hair to 2:13:22, and we play that, and we see Mr. Ali go to get his daughter. Now remember, his truck is right here now at this point, and he's trying to get her in the truck. At this point, she's still squirming around, and she's standing up, and she's going to the left. Now, right here, he gets attacked, right?
For cross-exam. All right, let me see court reporter and counsel sidebar. All right, ladies and gentlemen, before we begin, I do want to apologize. It is now almost 2:15, and I know lunch ended 45 minutes ago, and here we are just starting. There are just sometimes matters that need to be taken up outside the presence of the jury. This was one such event. It's been handled, and now we will continue. I make every effort to see that your time is not wasted, that there are no unreasonable delays, and I do sincerely apologize for that, but there was a matter I needed to tend to. But with that, we will now call upon defense for Mr. Robinson to cross-examine. Thank you.
Sir. Good afternoon.
Afternoon.
January 15th, 2020. You get assigned this case, right?
Yes.
You very quickly are able to develop a print that ties back to a firearm that was not used in the commission of this crime. Agree?
Yes, the day after the incident.
And that fingerprint was from my client.
Yes.
At that point in time, you'd agree that you start looking at Hakeem Robinson.
Yes.
You didn't know him before that.
No.
You didn't know of Queso.
No.
And you start looking at him.
Yes.
You as an officer, you would agree that you have to objectively investigate cases, right?
Yes.
Now, at that point in time, you already knew that Dominique Barner was involved to some extent, right?
Perhaps given the burglary incident.
What was the first warrant that you issued in this case?
For the car?
I'm asking you, you get that big binder in front of you, the very first warrant. Now, to explain for the jury, when you want to collect evidence, there's something out there that you want to get. You have a judge sign a warrant, you type up an affidavit with the information for why you believe that it's relevant, and then you send it out and you get the items back, right?
That's correct.
Very first warrant that you do in this case has nothing to do with Dominique Barner, right?
No, not at that time.
It was for my client's Instagram account.
That was not the first warrant. The first warrant was for the car.
So you do remember now.
Just
On February 5th, 2020, first suspect that you send a warrant out for, to collect information, not about a car, but to collect information, not to search the vehicle that we're not contesting here, was to collect records from my client's Instagram account, correct?
With respect to the question you asked, the first question you asked was.
Just answer this question now, please.
I am answering a question, but I'm going to basically say what I got to say. You asked me what the first warrant I got was. It was for the car. So then you then asked what the first suspect information I got was. Yes, it was for Mr. Robinson.
And we'll go back even further because I was talking about Dominique Barner. You didn't get a search warrant for any of his items, and you knew he was involved.
Not at that time.
Wasn't until months later. Right?
Right.
At that point in time, days after this happens, you're focused on Hakeem Robinson.
Yes, because I have the fingerprint in the car from the gun.
Now, you didn't have a fingerprint in the car. You had a fingerprint on a gun that was in the car.
And again, I said from the gun that was in the car.
Understand. Now, you've watched the entire Bang It Out music video, right?
Yes.
There's firearms throughout that, right?
Correct.
In fact, the one that the government is trying to say may or may not have been the one that was used in the homicide, it's held by a bunch of different people.
Correct.
You have no way of saying that the fingerprint on the gun that was found inside of the car was left on that gun even remotely close to January 15th, right?
No way, no.
Let's talk about your investigation. Of course, you're shaking your head. I don't know if you had something to add. Okay. In your investigation, of course, you speak to the eyewitnesses, right?
Yes.
There was a young kid working at Hibbett Sports, pretty much right next door to where the murder happened. Jarvis Roberts, did you speak to him?
No, my partner did.
Okay, but you as the lead, when one of your colleagues speaks to somebody, that information, all the information goes to you, right?
Eventually, yes.
And you combine that into your reports because you are the lead, right?
That's correct.
Jarvis Roberts, and I'm not going to ask you for what he said, but he gave a description of who he saw.
Without going to Detective Dishman's report, I can't exactly say what the report said.
In January of 2020, you authored a 59-page report that included all the reports of your colleagues, right?
Only the officers who did major case addendums.
There was also somebody else. There was a guy, Michael Williams. He was working out at the Baileys. He was on a Stairmaster. One of your colleagues spoke to him as well, too, right?
I believe I spoke to him.
And he gave a description of what he saw.
He did.
Now, we're talking about witnesses and who may have seen something. Abir Ahmad, who is a homeowner west of where the car crashed. We're not talking about the shooting, but the car crashes. 2 run eastbound, 1 runs westbound. She lives in that westbound direction, correct?
I believe so.
And she saw somebody walking through her backyard. Correct? I'm not going to ask you for her words, but she saw something, right?
I know she witnessed some part of it, but I don't have it in front of me to tell you exactly what.
All right, and again, we're just talking about people that I'm not asking you for their statements. One of your colleagues spoke to her, right?
Correct.
And they got what she gave as a description of what she saw.
Correct.
Renata Boston, right? Another witness.
Yes.
She saw somebody, correct?
Yes.
You got those descriptions.
Yes.
So, you're doing your investigation. You've seen the dash cam video by this point, right?
At what point is this?
Before the arrest of my client.
Yes.
All right. You have the dash cam video. It shows what it shows. You have these civilian witnesses that you've spoken to, and there was many more civilian witnesses, right?
Yes.
There was somebody that was pumping gas that could see, right?
Without telling you a specific name, I know there was one person I spoke to that was at the gas station.
So you had unbiased eyewitnesses, no connection to this case, not being prosecuted, give you a description of what they saw.
Yes.
And as you're investigating, Hakeem, you haven't met him before.
No.
You have a description on what the shooter was like, and on the day that he comes into the station, was ultimately arrested, You met him for the first time, right?
Yes.
And you were surprised by how big he was.
Like his weight, yeah.
No, you were surprised with how big he was, height and weight.
I'd say weight. He looks a little skinnier on Instagram back then, from my recollection.
Would it refresh your recollection to see your reaction in the interrogation video?
No, again, I said there was the weight that kind of threw me off.
The day that you met with him, and this is for impeachment, the day that you met with him, there was a recording device in the interview room, correct?
Correct.
And at one point in time, he went out to go to the bathroom, right?
Without watching it, I don't remember.
And you walked back into the interview room and he was in front of you.
Okay. I don't understand exactly what you're saying.
He answered the question.
Right?
Your Honor,
Okay.
Sidebar, I disagree that it was answered.
All right, well, if you're going to show the video, only he is to see the video because the video is not in evidence.
Okay. It's for impeachment, but I'll show it to him.
But it's only to be shown to him
I'm sorry?
first.
Well, the only thing is there's audio, Your Honor,
Then I need to excuse the jurors.
or I can bring him over here and play it for him.
And the audio won't still be an issue?
It would be very low.
No. I mean, I'm going to have to excuse the jurors at this point because then I also have to be able to see and hear it.
Understood.
And I won't be able to if it's low over there. So, ladies and gentlemen, I'm going to ask y'all to have a step into your jury room for a quick moment, and then we'll bring you right back out here.
Staying on the topic that we were on, September of 2020, was it? You first meet Mr. Robinson?
That's correct.
You're with Detective Dishman, your colleague?
Yes.
Never met him in person before?
Yes, sir.
Had spent months investigating this case, getting the descriptions of a shooter that was 5'5", 5'8", 5'9".
Sustained.
So, officer, there's CAD notes in this case, right? Call action detail notes.
Yes.
You've collected those, you've reviewed those.
Yes.
And your colleagues, as they were under the stress of the moment, were calling out over the radio the height and the weight of the person that they saw, right?
Yes.
And it wasn't just one, it wasn't just Officer Collins, there was another officer, Graham, right?
I vaguely remember, yes.
They both gave descriptions of the person that them as seasoned officers saw with their own eyes, right?
Yes.
You also had the civilians that saw the shooting, right?
Yes.
Mr. Robinson's in an interview room. You come into the interview room, he's sitting down, right?
Yes.
You talk to him for a minute, he hasn't stood up yet, right?
I don't know if it was a minute. I think he almost immediately asked to go to the bathroom.
Then he walks out and he goes to the bathroom.
Okay. Yes, sir.
Is that correct? I wasn't.
That's accurate, yes.
As he's walking back in, this is the first time he's standing up, you make a comment, you're a lot bigger than I thought you'd be,
Yes.
right?
I said yes.
Not, you're the exact same size of the shooter that I've been investigating. Either consciously or subconsciously, you say, you're bigger than I thought you'd be. Right?
I've already answered this, but yes.
Please answer it again. They're not objecting. You don't get to make that choice.
Yes.
All right. Now, it wasn't just about his weight, was it?
It was about his weight.
And why didn't you say it before he stood up?
I vaguely remember being in that room briefly. I don't think we made too many comments to each other.
If I'm sitting down, you can tell from my face, from my body, you can tell if I'm wide-shouldered, right? You can't tell my height until I stand up.
At that point, I don't remember looking at his body. I was looking at his face, and then I think he asked to go to the bathroom. And then as he comes back from the bathroom, that's when I make the comment.
You agree that you made the comment?
Yes, never done that.
Yeah. My client was arrested that day?
Yes,
You didn't take any photos of him, did you?
we did not.
No. One moment, Your Honor. I'm showing you one of the government's exhibits, but you guys took photos of Dominique Barner, multiple photos.
Yes,
So, understanding that we may have a recording, we could have had photographs just like this for this jury to see his exact size on that day,
correct.
but you chose not to take photos.
With respect to Dominique Barner, the tattoos that he had at that date and time were the reason he was photographed.
Isn't the first photo with him with a shirt on?
Yes, they do overall photos.
Thank you, Your Honor. We're having a tech issue there for a second.
Okay.
So, this photograph, this is taken so you know who you're taking the photograph of, right?
That's correct.
There's no policy, there's no law, there's nothing saying that you couldn't have taken the similar photographs of my client, Hakeem Robinson.
No, there's no.
Be able to see what kind of weight he's carrying. Right?
Right.
You agree, though, that he doesn't have a single tattoo?
I have not seen the extent of his body, so I can't say that for sure.
Well, if there was tattoos, you'd be taking photos.
If they were described by a witness or a victim as it relates to the case, and it makes sense, yes.
Let's move on now. Call action detail notes. Now, again, this is back in the day when they had the CB radio. Now it's digital radios. But anything that's going out there from all the different officers, it's going to a central location and being recorded, right?
Yes.
It's both typed out and audio recorded, right?
Yes.
So somewhere out there, there's an audio recording of two of your colleagues giving a description of the person they're chasing.
Yes.
Why don't we have that? Richardson hearing.
What? Okay, if I can have a grounds for the objection? Okay. Will overrule the objection.
There's an audio recording of your colleagues, literally as they're chasing after the person, going out on the radio. I need backup. I'm chasing somebody and giving a description. Right?
At some point, yes.
At some point?
Yes, there would have been.
Okay. Now, both the call action detail notes and the recording, those are kept in the normal course of business for JSO, right?
That's correct.
They're created literally live. So they're created at or near the time of when the items are being reported, right?
Yes.
And they're organized and collected by somebody with personal knowledge about what they're doing. It's somebody from JSO.
I believe someone in the comm center, but yes.
Now let's talk about body cams. January 15, 2020, body cams were required for officers, right?
Yes, I believe so.
Officer Collins, although he was getting a rap at Publix, he was on duty that day.
I don't know if he was on duty or going to secondary employment.
If he were on duty and in uniform, he would have been on that date wearing a body cam.
He should have been, yes.
And per your policy, if somebody is chasing after somebody else in a vehicle and then on foot, they're supposed to activate that body cam.
Yes.
Now, obviously, sometimes that doesn't happen, right?
Yes.
But sometimes there are recordings, right?
Yes.
You as a lead detective, is there a recording?
Of?
Officer Collins chasing on foot the shooter?
No.
Doesn't exist or it can't be found?
I don't believe it exists. I asked for all body-worn camera from that incident. I never had that.
Now, presumably, if that camera was on, we would have live images of the shooter, right?
Reasonably depending on when he got out of the car and what his body cam would call. I can't speak to that.
Let's go back to warrants now. Let's talk about search warrants. Now, you were looking at my client. You had probable cause basis to request those meta records, right?
Yes.
Did you ever search my client's residence?
No.
Did you ever search anywhere and find either the Nike tech suit that the shooter wore?
No.
The shoes that the shooter wore?
No.
You would agree that if you were to execute a search warrant on my client where he was living at that time at his mother's house, and that isn't there, that could lead to an argument of those aren't his clothes.
Potentially.
Now, these Nike tech suits, Nike tech fleece suit is what you think the shooter may have been wearing?
Sorry, perhaps, yes.
Wildly popular. They're popular. Right?
I have seen them, yes, but I don't know how popular they are. Can't speak to it.
You're the lead detective. You didn't look into this?
How popular a Nike tech suit is at that time?
We're not talking about a unique, suit jacket covered in rhinestones. We're talking about Nike, popular brand, right?
Yes.
And their sportswear is big, both domestically and internationally.
Yes.
So what I'm getting at here is that there's more than one of them out there in the world.
Yes.
More than one of them out there in this county.
Presumably.
So it would be speculation to say that the one that we saw in the video with my client on the FaceTime call, that's the same one. That would be speculation, right?
Yes.
You don't even see the full thing.
You can't from the video.
Now let's talk about the posts. The shooter that you interviewed in this case, they covered up their appearance, at least their face, right?
Yes.
There was attempts to evade the police, to run from them, right?
Yes.
There was destruction of evidence. Some stuff was burned, right?
Yes.
You'd agree this is sort of like Crime 101. You get away with it, right?
I'm sorry. When you say Crime 101, what are you referring to? Burning stuff?
The people that committed this crime, the shooter that covered their face, the people that ran from the cops, the burning of the evidence, the cell phones under other names, those are people trying to protect their identity, to hide it, right?
Yes.
Okay. So about a week later, my client posted post on social media about doing something and getting his toes done. Right?
Yes.
And you believe that that's evidence of this murder?
In context of everything else that was posted, yes.
So there's all these attempts to cover up identity, and then he goes out into social media with, how many followers does he have? Hundreds of thousands?
Without looking at his page, I couldn't tell you.
You know that it's a lot.
Yes.
Right. That he then goes out there and confesses? That's your belief, that he everything is done to hide in the moment, and then 5 days later, I'll just confess to the world.
Yes.
That's your belief?
Yes.
All right. Now that statement, and I'm not going to repeat it like the government has a couple times. That statement, that could apply to anything, right?
As far as?
If one of your say the government, one of our witnesses, and they have a riveting cross-examination. I killed him. I killed that witness. Doesn't mean they actually killed him, does it?
No.
Have you ever heard the phrase, for some people, I could only hope that someday my life is as interesting as I make it seem on social media. Have you ever heard that?
Can't say I have.
Now, you know that my client's an artist, right?
Yes.
You know from the videos and from the followers, right?
Yes.
Do you have any way of saying that he wasn't just co-opting the life that he saw growing up to sell records?
I can't say that.
Because who else would be stupid enough to post on Instagram, yeah, I just killed a guy, but the person that is trying to sell records to go, you know what? People out there are going to believe it because they don't know it, but I feel secure enough that I'm not going to be charged with this because I know I didn't do it. You understand the question?
No, if you could repeat it, that'd be great.
Have you ever heard the phrase, you can't be smart and stupid at the same time?
Can't say I have. I haven't heard that one.
It would be smart if somebody were trying to hide their identity in the moment. It would be stupid of them to then go onto social media and confess it if they were actually involved, right?
Yes.
Now, we're not saying that my client didn't like Willie Addison. We're not saying that my client didn't dislike Charles McCormick. But him disliking Charles McCormick doesn't mean that alone doesn't mean that he killed him, right?
No.
Posting, bye, that could just be a reflection of him disliking the guy, not necessarily killing him, right?
Right.
You agree?
Just the post itself? No, I agree.
This guy's dead. I mean, agreeably, it may not be tasteful. I don't like this guy. This guy is rapping about something, about somebody that me and others cared about. I don't like that. He's now been killed. Bye. And you want to know what? I'll probably get a bump in records too. You agree with that? How about this? We'll move on. You can think up something. We'll come back to it, okay? Now, Charles McCormick. Charles McCormick was never a suspect in the Willie Addison murder, right?
Not that I'm aware of.
So he's rapping about something that he was never involved in, right?
As of now, I did not investigate that case. I cannot say who was or was not a person of interest in that case.
You're being asked this question right now. Charles McCormick, to the best of your knowledge, was he rapping about something that he was never involved in?
As far as I can say, I can't say he had any involvement in the murder.
You can't say that he had any
I'd say
involvement.
that.
So it's okay for Charles McCormick, but it's not okay for the guy that actually has the record. Is that what you're saying?
It's not okay for the guy who has a fingerprint on a gun inside that vehicle that was used to murder him.
You already agreed with me that that fingerprint could have been left at any time.
It could have been, but is there any vehicle that could be tied to Charles McCormick? I can't say. I know you probably can't say as well, but I don't think I would be posting or rapping about something I might have remotely had anything to do with.
Let's go back to the fingerprint now. After you got that fingerprint, you didn't arrest my client, right?
No.
Because it wasn't enough.
No.
You didn't arrest Chifton Hogan,
No.
right? His DNA's in there.
I followed the evidence to verify where they were at that day.
You followed the evidence as far as the fingerprint and then just kept on that track.
The fingerprint and then the DNA when it came back.
The DNA that easily could have been transferred from the shirt that had my client's DNA on it.
I don't know the specifics of how it got on there. I can't tell you that.
Should we save that testimony for the DNA expert?
Yes.
All right. Now, let's talk about those civilian witnesses again. Renata Boston, she got vaguely a look at the person, right?
Yes.
Jarvis Roberts, right?
Yes.
Michael Williams.
Yes.
But Renata, it was something different because the person's hood was down, right?
Yes.
You never went out there with a photographic lineup to see if she could identify anybody, right?
Yeah.
There's nothing stopping you.
Yeah.
If she were to come back and identify the wrong person, your case would be toast.
No, not necessarily. I just have to if she picked out the wrong person or picked nobody, I'd verify who the person is that she picked and see where he was at on the day in question.
But it was never done.
No.
We don't know what we don't know.
She saw him, I believe, from the second floor.
No, she was sitting right there talking to her friend. She was sitting on the stoop. Saw the person come out of the woods. Was able to describe the hair, the skin tone. No photo lineup was ever shown to her.
No.
Now, let's talk about House of Pain. And you know the relevance here, right?
I'm sorry.
houseofpain904@gmail.com.
Yes.
You remember that, right?
Yes.
Okay. Now, you were born last century, right?
Yes.
I was born in the 70s. About the same age?
No.
House of Pain was big in the, it made me feel old with that one. House of Pain was big in the 80s and the 90s, right?
Is that the jump around?
Yep.
There you go.
Jump up, get down, that one. That's way after my client's time, right?
Yes.
But it's within the time frame of Blue, Abdul Sr.,
That's correct.
right? Now, you did look into Abdul Sr., right?
Yes.
His Instagram account is h.o.p_CEO, right?
Yes.
A bunch of stuff when you searched his house, there was a bunch of House of Pain paraphernalia, right?
Yes.
Are you able to say who that email account belonged to?
No.
Now, you could have found that out, right?
Perhaps, but then if they did the same thing that happened with the iCloud, where there wasn't like a direct name, then that'd still be dead in the water.
Let's do this. We got a whole box over there of Instagram records, call detail records, Meta, Facebook.
Yes.
You're the one that's the lead on this throughout the entire case.
Yes.
There's never a search warrant sent to Meta, that's Facebook and Instagram's parent company, to collect the records for HOP CEO Instagram account, right?
No.
Got it from my client days after the shooting.
Yes.
Never got it for that.
That's correct.
Okay. You could have also, you could have gone right to the source. You could have sent a search warrant to Google because it's a Gmail account, right?
That's correct.
And we could see, to get to the bottom of it, who this account belongs to.
Potentially.
Potentially?
I don't know what information that the Google account would have contained.
Now, all we know is that there's a few photos of my client that tie back to the iCloud, the Apple, right?
That's correct.
So you guys get the records from Apple, but not from Google, and not from Meta.
I'm sorry, Meta. When you say Meta, we
Facebook, Instagram.
do have records from Facebook.
So Meta is Facebook and Instagram. You don't get records from them.
I do have, I'm sorry, you said I did not?
Let's back up. HOP CEO, that Instagram account.
Yeah, specifically that Instagram account, no, I did not get that one.
Okay, that's Meta. Now, for the House of Pain 904 Gmail account, you could have sent a search warrant to Google to get you could have seen all the emails.
Could have, potentially, yes.
You say could have. You had the basis to send out search warrants. You did it on everything else.
Yes.
You did it on the Apple account. It would have been the same thing. You just change out Apple for Google.
Yes.
But we don't have that.
We do not.
But you get the Apple account, and there's some selfies of my client, right?
Yes.
You're not able to say that Blue, Abdul Sr., who was admittedly doing some management for my client before he signed up, that he didn't have access to my client's Instagram, right?
I can't say that, no.
Okay. You can't say that my client, maybe was visiting, and I won't refer to him as his father, but Abdul Sr., he was seeing him and took a selfie on his phone. Right?
No, I can't say that.
Ms. Kawas and I are generally always together from work. If I were to take a selfie with her phone, that doesn't mean that's my phone.
Right, but generally, most of the photos on that device would have been of her, not you. I'm sorry, does that make sense?
It doesn't. What we're talking about, though, is who the House of Pain email account belongs to.
Correct.
More work could have been done to other companies to find out the answer to this.
Again, as it relates to the House of Pain, yes, I could have subpoenaed, I guess, Meta to see if there's any other accounts tied to that account email.
So, but when you see a selfie of my client from the Apple return, it's just, okay, that's good enough. That's his account.
It wasn't just a selfie, it was multiple pictures, but okay.
We have the evidence. There's about a dozen photos, right?
Yeah, there's multiple photos.
Dozen.
Still multiple.
Okay. My client's phone, the 1595 that we have in evidence, how many thousands of photos are in that?
It's different. I have the entire device. I don't have the entire device for that 478 number.
At the end of the day, you cannot confidently say who that email address belonged to.
No.
House of Pain 904 at Gmail.
No.
Let's talk about Raekwon Howard. Now, you've seen the meta records for Raekwon Howard, right?
Correct.
Now, we have to assume that that's actually the Raekwon Howard's Instagram, right?
Yes.
You've met with Raekwon.
Yes.
He's next door in the jail right now.
I don't know exactly where he's currently being housed, but I know he is in jail somewhere.
Now, Raekwon Howard at one point in time tried to kill two of the witnesses in this case.
That's correct.
It's the next question, Your Honor.
Okay, I'll allow one more question to see if you can type relevance.
Never tried to kill my client. Right?
I don't know what all he's tried to do.
So let's back up to make sure that we're clear. You answered yes, that he did try to kill witnesses. He tried to kill Torgon Williams and Natalie Gant.
That's correct.
He's been charged with that.
Yes.
You know of no time when he's tried to kill Hakeem Robinson.
No, I can't say so.
Now, the relevance here is that these warring factions on the street, that they don't get along, right?
That's correct.
All right. That could have been payback for the murder of Charles McCormick. Happened months later, right?
It did.
Okay. So let's get into the meta records of Raekwon Howard, or somebody that could be Raekwon Howard. We'd have to hear from him to know that these are his records, right?
There's several pictures of him on that account. The email address is Raekwon Howard 4.
Are you saying that Raekwon is a unusual name?
I don't know, without looking it up, I don't know how many Raekwon Howards are in the world.
Didn't Raekwon Howard try to kill another Raekwon? If you know.
I don't know.
All right. Give me 1 second, Your Honor. I've got to DJ over to another screen. I'm getting better. No, we're good. We got it here. Okay. I'm going to wait to publish it. I don't want to show it yet. Okay, let's just jump into this. Let me know if you can see that on the screen.
Yes.
So what I'm showing you is admitted into evidence as a state's exhibit. Unfortunately, I don't have the number, but I'm sure that either Ms. Kawas or the government can tell me what it is. Raekwon Howard's meta records. Meta records. Oh, yeah, this one would be Hakeem's. The whole thing. Huh? Hold on, Joe. Yeah, we'll enter the whole thing. Yeah, that's fine. So, you've reviewed these records, right?
Sorry, yes.
All right, now what we're talking about, we're going to focus on Hakeem Robinson's records.
Okay.
His meta records. You've reviewed those because you received them, right?
Yes.
Raekwon Howard. One of his usernames is rpg.poppy.
Yes.
Now, there's several other names, but that's one of them, right?
Yes.
Now, the records that you get, it's only for a small period of time.
Yes.
And within that, you looked at the communications of all your communications in December before the murder, right?
I believe so.
And then after it.
Yes.
In December of 2019, my client's having conversations. They're texting back and forth and speaking, both my client and RPG Poppy. Would it refresh your recollection to take a look? One moment, Your Honor. Starting on page 5,960. Do me a favor. Take a look. Scroll down there. I want you to start on, you'll see the username highlighted.
Let me move this just so I have someone to kind of place that. Oh, knock it down.
Just let me know when that helps your memory.
All right.
Does that help your memory?
Yes.
Can you replace the microphone back where it was? Thank you.
In December, the month before the murder, they were talking regularly, right?
Yes. Sorry, one second. Yes.
One of the comments was LMFAOOO,
It was.
right? There was another comment about somebody losing weight.
Vaguely remember that, but yes.
Now, these communications continue through the time of the murder, right?
Yes.
And up until the end of the records, which were about a week after the murder.
From best I remember, yes.
So it wasn't uncommon for my client to be speaking to Raekwon Howard.
No.
Your belief is that my client killed one of his people, one of his group.
Associate, maybe, yes.
Doesn't that prove more that my client is not part of all of this? That he's not at war with this group like the others that are involved? They can't give you the answer.
Sorry.
You got to look at me.
He stood up. Sorry. No, I don't know. Just without knowing all the context of their conversations, I don't know what they're saying to each other.
You saw the text messages.
Yeah, I saw them teasing each other, but that doesn't necessarily mean that it's not still bad blood there. I think it's weird that they talk as much as they do. I'll give you that, but it doesn't mean that they wouldn't have to.
Let's break it down. You view my client, you're like, he killed somebody that's part of this group 6 block. It's weird that he's talking to somebody from 6 block, right?
Yes.
Doesn't that weirdness go away when you finally admit, oh, wait, maybe my client didn't have a problem with this group 6 block, and that was everybody else that was still battling on the streets?
I'm sorry, repeat the question.
You think it's weird because you believe that my client has this problem with all the group 6 block, right?
Yes.
Doesn't that weirdness, that weird feeling you have, doesn't that go away?
No.
You admit that.
And the reason that
I could ask a question.
Sorry. Go ahead.
All right, we just need one person speaking at a time. So let the attorney ask the question, and then we'll let the witness answer the question without interruption on both ends. Go ahead and ask your question.
Doesn't that weirdness go away if you realize, wait a second, if Hakeem gets along with Raekwon and they're even joking around, and you can't speculate whether it was positive or negative, that maybe he isn't part of this rivalry in between the two. That clears up the weirdness.
It does not, because he mentions Bibby almost every chance he gets.
Sidebar, Your Honor?
Okay, let's come sidebar. All right, thank you. Ladies and gentlemen, we're back on the record. We're going to take another restroom break. There's been a request for a bio break, so I'm going to ask y'all both of the juries to step back into the jury rooms for just a short while, and then we'll bring you right back out here.
Boomer Miller, you better go grab you something. You absolutely better go grab you something, because baby, the plot is getting thick over here. The plot is getting thick. I'm not sure why he can't say Bibby. I don't know the significance of this. So hopefully we get a little insight on who is Bibby and why is he off limits. I might have to do a little research on the side. Oh, they say Queso unalived him. And so is he saying that Now that's interesting right there, Demetrius. Demetrius said they say that queso unalive, baby. Oh, that's Fulio brother, his baby brother. See, I look at that. Shout out to everybody that got background knowledge of what be going on down there in Jacksonville, because we are an older crowd over here, so we don't know these kids, we don't know these folks. So we appreciate y'all for getting us up to speed, because what? Queso's next trial is for Bibby. Demetrius said he stay in Duval. Miss Mara says that he was also unalive. So that's the other M that Queso on. Because he got two. Child. He said that's what the bald head said. Ooh. So what's he's child. So he's implying that he is talking to his 6 block member, bringing up the person that he's accused of unaliving. So it's a taunt to that person, and not that they have a mutual respect or friendship, or that they've squashed the beef. He's just saying, like, yeah, they talking, but he bringing up Bibby, so it ain't in the context of what the defense is trying to present. That's what I'm gathering, y'all. Help me out, because I had to order the kids some food too. So I kind of missed a little bit, which means I'm gonna have to read this part of the transcript when I get it later on today. But help me understand. I don't give a sorry, I only watched the last few days. Can y'all give me a Spark Notes version real quick? Or which part? Beta say right. Okay, so I got it. Okay. And y'all know what I was thinking about? A lot of these little kids' fathers be out here into the internet mess, because I remember the little dude, 23 Island. I want to say he from Florida too, right, y'all? And his daddy had beef with somebody, and they end up unaliving him. On Bibi and the relevance to Queso. So so what I just learned, I don't give a tuck, is that Queso is also pending. Oh, he's from Louisiana. Okay, thanks, Pat Stacks. When I heard 23, I'm like, is this the same crew? But obviously not. I appreciate that. So Queso has a second murder trial pending. Allegedly, is for the murder of Bibi. And on the stand, the detective was the defense was questioning the I can't even get it out. Questioning the detective about a conversation between Queso and another person from 6 block. And 6 block is the ops. And he said that every chance that Queso got, he was bringing up Bibi, which kind of refuted the fact that, or the argument that, well, he was trying to refute the argument that the defense was making, that they were having a conversation, but it may not have been malicious. To you, go listen to Who I Smoke by Young and Ace. Girl, is it PG-30? You welcome. I don't give it to. Is it Amara? Is it PG-30? Because I can't listen to them kids long enough. I can't listen to them long. I can't listen to them long at all. You got a timestamp for me? Or just listen to the whole thing? I might need a little help. Raekwon. So Raekwon is Bibi, Shay. that's the, you gotta ask because everything don't be PG-30. It be PG-13. Okay, so Raekwon is not Bibby. Queso didn't kill Bibby. He just dissed him. That's it. That's what Boomin says. I might be enjoying this conversation a little too much, y'all, because I feel like I'm getting hip. I really do. Oh, that's who Queso was talking to. Got you. Was Bibby the kid that got gunned down in the apartments? Y'all know these children. No, says Drill Kenzo says no, y'all. He's from KTA. Y'all, Shaden did a deep dive. She did a deep dive and she understanding what's going on out here. I appreciate this no judgment zone that we got going on and everybody is, participating and getting us hip because, child, we'll be lost in the sauce right now. But I appreciate this safe space. KTA, ATK, come on now, y'all. Y'all can't tell us that ain't confusing. All right, well, let's finish up these closing so we can get the verdict watch on Ali.
From anything. He's mad and he attacks Mr. Ali. Now, we have another photo. This is exhibit 501. If I could just put this on for a moment. Remember 501. This is the photo of the frame where Isaiah has his arm up in the air and he's taking a swing at Mr. Ali and Fatima's there. Now, what's interesting about this is that he can't really see Fatima from this point. I mean, he's coming in at the same angle as the camera. He says that he's trying to protect her, but really what he's doing is he's taking a swing at Mr. Ali because he's mad at him. Okay, that's what he said. And what he does after this is he pushes him into that tree. Thank you, Madam Clerk. Can you go back to the video? Now I'm going to back up the video here just a hair so we can see a little bit better what's going on. And we're at 2:13:27. Let's back it up just a little bit to 2:13:25. Okay, and so here's Mr. Ali. He's wrestling with Fatima, but he doesn't have arms around her neck. Okay, that's what we kept hearing people say. He's got his arms around her in a reverse chokehold. No, he doesn't. We can see he's got his elbow up on this side and his hand over on this side. She's squirming around over here, and clearly she's trying to get away from him. Okay, so here comes Isaiah. Boom, hits him. Caleb comes in.
You indicate what time he stopped.
Oh, I'm sorry. This is 2:13:26. Caleb comes in from the right side. Now, he's not pulling anyone away. You can see he's pretty clearly pushing Mr. Ali, or excuse me, he's pushing Isaiah in the back. Mr. Ali here next to the tree, and these are the legs of Fatima over here. Okay? So, there was no falling to the ground. This was clearly being tackled to the ground by at least these two people, and I think we're going to see Zayla. All right? You can see him hit the tree, and boom. At this point, everybody's on the ground, and right there, excuse me, I'm going to pause it again, 2:13:29, so we haven't gone very far in the video here. The first thing we see is Isaiah kicking Mr. Ali in the head, right? He's on the ground kicking Mr. Ali in the head. Start it up again. Now, right there, between 213.29 and 213.30, frame 8, you can see Mr. Ali on the ground, underneath Caleb's feet here. And if you watch him, after he gets kicked in the head, right there, he kind of curls up at that point, all right? And then additional hitting and kicking is happening very quickly. We're 3 seconds in here, he's getting hit in the head, he's getting kicked in the head, and he's hanging on to Fatima. Now, remember the scenario. We're at the bus stop, somebody we don't know comes up to us, gets between us and our daughter. This is Isaiah at the time, and he starts putting his hands up in my throat, my neck area, because I'm trying to take my daughter home, okay? Mr. Ali takes one punch at him to get him away, doesn't even knock him to the ground, he just kind of gets him off. Then, he's heading over to still get his daughter into the car. He's the father, he's the concerned father who hasn't heard anything about where she's been all day, other than here she sits at the bus stop, right? He does not know these people. These people come at him and attack him at that point. He's got his daughter with him. He's trying to control his daughter. She's trying to get away. And so what does he do? He hangs on, okay? He's hanging on to his daughter. She's in front of him on the ground, and he's got her. He's kind of curled around her, and he's hanging on. Now, the government would have you think that at that point, he's strangling her, and he's intending to kill her. When in fact, what we see is a man laying on the ground who just got kicked in the head, holding on to his daughter. Now, why is that important? Well, because if you remember when we were talking to Dr. Gilbert, I asked her a couple of things about blows to the head, right? I said, well, what about hitting the tree with your head? And she said, well, Fatima didn't have anything on her head. And I said, well, what about if you kick somebody in the head? Oh, yeah, that can cause problems. That can cause cerebral edema or concussion. What happens when you get those? Well, your body functions, but you can't control it, right? That's where we're at. We're at a place where a guy is on the ground, he's being attacked, he's being punched, he's being kicked in the head while he has his daughter. Apparently, while that's happening in these few seconds, he's forming some sort of an intent to strangle her. There's no evidence that was ever put forth that he was intending to strangle her. What we have here is we have a melee, a mob, right? We have chaos going on. And at this point, what happens is they start yelling and screaming at him to let her go. That's what they're screaming, right? I'm going to start the video here at 2:13:34. Let's play it at full speed for the next few seconds. Turn on some audio as well, all right? So let's watch what happens. I don't know where the audio is. Stopping it now, 2:13:38, frame 9. You can see Isaiah is right there pounding on Mr. Ali's head. Up and down, many times. Now, we haven't got to the point yet where Caleb drags Mr. Ali. He doesn't grab his arm and try and pull his arm free. What he does is he grabs him by the bottom of the coat and yanks it up. You can see Mr. Ali's back come up. He drags him away from the tree. That's where he's going with that. Doesn't drag him very far, but he drags him away from the tree. Let's watch that. I'm going to start at 2:13:38. Right there. Now, he's not grabbing at his arms. He's grabbing at his coat, he's grabbing on his back, and he's yanking him across the ground. Meanwhile, Fatima, who allegedly they're trying to protect, is underneath Mr. Ali. Mr. Ali is on his stomach right there. He is on his stomach, being dragged by somebody he doesn't know, punched by somebody he doesn't know, across the ground, with his daughter with him, and he's hanging on. He doesn't want anyone to snatch.
The terminology, that's it.
Give us.
We say a pre-meeting, it's just a meeting.
You have a conversation with Dominique Barner, who's now about to become a witness in a case, and the very first meeting that you have where all of you are in there is not recorded.
That's correct.
Then you go into the room and you do the recording.
Yes.
All right. You're in the room for that conversation.
Yes.
ASA Cooper is asking the questions.
Yes.
Now, I want to make it clear that I'm not trying to argue that they told any witness what to say. Okay, so I'm prefacing it, I'm not saying that. The questions that were asked in that room, they were in a leading fashion, right?
I'm sorry, when you say in the room, you talking about the meeting or the sworn?
The sworn statement, the one after the rehearsal where you're having the conversation, it's recorded, and if you need to review it to refresh your recollection, let me know. But the questions that are being asked are leading questions.
For the most part, they're just yes or no questions.
Yes or no for Barner to say yes or no.
Yes.
It wasn't a situation of, Mr. Barner, we have the camera, tell us what you know.
No.
You believe from the cases that you have that Dominique Barner is a dangerous person.
Yes.
You also know that this guy, he's smart, right? Not book smart, street smart.
To an extent, yes.
He's the one that figured out, I'm going to go onto CORE, the CORE computer system, find a case for Charles McCormick to figure out an address, right?
Yes.
He also had fake Instagram accounts to track him when he was on vacation, right?
I was not aware of the fake Instagram account, but
You know that he was clever in the ways that he figured out how to hunt Charles McCormick.
at times, yes.
Are you saying that he is not clever enough to figure out what it is that y'all want to hear?
I couldn't say that. Again, everything that he's told us was corroborated by the evidence that I had.
Now, if I sit down and I'm in that room instead, and you're butter, and I ask you and I go, was there a phone call in the car and I'm holding a stack of papers? You as butter, you could be like, yeah, that could happen, right?
If I led with a question like that, yes, I said.
So what we're saying is that this person that wants a deal, that knows what you guys want, is it beyond this known murderer's ability to craft his statement in line with your facts?
Again, all we ever asked him for was the truth, and that's what he told us.
And we have to rely on him whether he's truthful or not.
Yes.
You do know that he's taken lives.
I'm sorry?
You do know that he's taken lives, right?
He's taken lives?
Yeah, sustained.
Through your investigation, you knew that Dominique Barner was involved in the Rothermill case, right?
Yes.
Okay. Safe to assume that you would be of the opinion that he's a dangerous person?
Yes.
Okay. What's harder, shooting somebody or lying?
What's harder?
Yeah.
I'd say shooting somebody.
So now, let's stay on this topic of the way that you do the conversation, then the interview. Later in time, you spoke to other people. You spoke to Torgon Williams under the same parameters, right?
Yes.
But you just chose altogether, we're not even going to record this one. Right?
I didn't choose that. I don't take sworn statements.
All right. You were there.
I was there.
There's no policy that says you can't do it.
When it's an agreement between the two attorneys and they're facilitating this meeting, we met under the pretenses that they already established.
There's no law that says that you can't record it, right?
No, there's not a law that says I can't record, no.
Police can actually surreptitiously record things, right?
Yes.
But you're saying that the prosecutor, not you, but the prosecutors in Torgon's.
Yeah, I'm just short leash here on relevance. I think we're going down. I'm going to sustain the objection.
When you're speaking to motivated witnesses, we spoke before about Dominique Barner, that it wasn't a situation that you went in there with a recording going, tell us what you know. That it was instead leading questions. Now we're moving on to Torgon Williams, somebody else. Torgon Williams was involved in this, right?
Yes.
You're having a conversation with him, and I think what you said is that the attorneys, not you, agreed to not record it.
Sustained.
We don't have a recording of that conversation.
Of a conversation with Torgon Williams?
Correct.
Correct.
So we don't know the evolution. Counsel? We don't know the evolution of his statements, both pre-interview, the interview, we don't know any of that.
I'm sorry? Okay, I'm going to have to see attorneys at sidebar. Let me see.
Go, Your Honor.
If the court reporter's ready, you may continue. Yes.
Yeah, she gave me the nod.
All right, very good.
Remind me, colleagues of yours or yourself spoke to Raekwon Howard, right?
Yes.
That too was not recorded.
That's correct.
Let's talk about Natalie Gant. I'm showing you what's been entered into evidence. One of the state's exhibits. What's Natalie Gant's phone number?
I believe it's 904-485-7529.
And you've reviewed the cast report from the FBI agent, right?
Yes.
You recognize that, right?
There we go. Yes. Sorry.
7529.
Yep.
Are you sure that's actually your phone number and it's not 7259? Let me strike that. Would it refresh your recollection if I were to show you the subscriber info and the call detail records that you received?
Yes.
Your Honor, may I approach?
Yes.
Do me a favor. You're gonna go, if you're an Apple guy, you'll know.
1 second.
Here, I'll hold it. And you're gonna go back and forth between the two. So you can go like that. Then like that. Yep. If you want to.
No, sorry.
It's the wrong phone number, right?
Correct.
It's not 7529, it's 7259.
Correct.
When dealing with a homicide investigation, accuracy is important, right?
It is.
If you bring an FBI agent to testify about the plotting of cell phone records, you need to make sure that you have the right number, right?
Yes.
Now, mistakes happen. This is incorrect, right?
That isn't.
7529 is not Natalie Gant's phone number, right?
Yes, that's correct.
7259. No question from your investigation in this case that she was involved, right?
That's right.
She was never arrested.
No.
Now, the government asked you a line of questioning about Chris Brown and DNA that was inside of the car, and how Chris Brown's DNA wasn't inside of there. So I'm just giving you a heading of where we're going. Dominique Barner's wasn't found in there either, right?
It was not.
In your conversation with Dominique Barner, specifically that interview, he tells you that Chris Brown was involved, right?
I said yes.
He says, well, Chris Brown was a lookout.
Before he left, or I don't know if you call it a lookout or verifying the car information.
But Barner let you know, and I'm not saying that Barner said, he let you know Chris Brown was involved. Right?
To an extent, yes.
You went, you tried to speak to Chris Brown like you did with Torgon Williams and Raekwon?
I'm sorry, repeat the question?
Did you go and try to speak to Chris Brown like you did Raekwon Howard and Torgon Williams?
Oliver, if that's the question, is there an objection to that question? Did he speak to Chris Brown? Okay, then you may proceed to answer the question.
Did you try to speak to him?
No.
Your Honor. Sir, I'm showing you what's been entered in as defense one. Oh. It's showing it.
And nothing's on any of the monitors.
Well, it's up at the top, but it's not showing at all.
No.
You can see like the time right at the top, or at least you can here. Oh, I'm plugged in. Full source. Screencasting. Okay. Where do you want it at? Still crest on? There we go. Just took a minute, Your Honor.
Okay.
Showing you defense one. It's Chris Brown, right?
Yes.
Butter pecan skin.
That is your judgment on his skin color, sure, that's fine.
This photo could have been put in a photo lineup and shown to Renata Boston, correct?
Correct.
Did you ever acquire? Now, Dominique Barnard has already said he was involved. That's a crime, right? What Dominique Barnard told you makes him an accomplice, a co-conspirator, co-defendant.
Yes, to an extent.
Now, the gradient on that, the extent, the spectrum, it's still pretty high on murder, right? Even on the low end.
Can be.
You didn't request any phone records for Chris Brown?
Never found any phone numbers connected to him.
I'm sorry?
I never found any phone numbers connected to him.
You never tried to find any?
No, with respect to the rest of the evidence as far as cell phones are concerned, no.
No social media?
Sorry, no.
No social media?
No.
No search warrants?
No.
Nothing. You collected nothing on this man that Dominique Barnard, your star witness, you collected nothing on this man?
No.
Now, again, we're not getting up here and saying that it was Chris Brown. We're talking about objective and withdrawn, Your Honor. There was other people who would have had a motive to kill Charles McCormick, correct?
I can't speak to who wanted to kill Charles McCormick.
You investigated this case, right?
Yes, but I can't just say a group of people wanted to kill him.
There's a music group that you know to be known as ATK, right?
Correct.
There's more people that are affiliated with that group than have been mentioned during this examination, right?
Correct.
We know that there are multiple people in things like the Bang It Out music video, right?
Yes.
Those people very well could have a motive to also dislike Charles McCormick, right?
Could, but I can't be a spokesperson for ATK and what they would and would not do.
Malkeith Worthen,
Okay. Yes, sir. That's me.
a.k.a. Kesey, did you look into him?
No.
Somebody that goes by the name of Sosa, did you look into him?
No.
Keonta Bullard?
No.
There's a whole bunch of other names, right?
Yes.
And any one of them could easily fit the description of the shooter.
Without literally sitting here looking at shut photos of them, I can't say. Sorry.
You didn't get any records for any of them?
No.
Didn't investigate any of them?
Nope.
From February 5th, 2020, possibly before that, you were focused on Hakeem Robinson.
And I'm sorry, say the dates again.
February 5th, 2020, when you sent out your first search warrant against a person, not against a vehicle.
To what date, sir? I'm sorry. I thought you were saying the date range, just why I'm confused.
Okay. We'll move on.
Okay.
Let's talk about the government exhibit. This may take a minute again. So on direct examination, you were shown some color-coded phone calls. It will take a minute to pop up here. Now, you were shown a series of phone calls. You remember these?
Yes.
And I think your words were there was a lot of activity, of a lot of communication, right?
Yes.
Now, the first one here in red, that's a conversation between, and correct me if I'm wrong, it's real small on this screen, between my client and his brother, Abdul Jr.
Can you like zoom in like a tad bit? Sorry.
And what exhibit is this?
This is 10F, States 239.
Okay.
So, sir, I'll make it easier for you. You'd agree that the communications with Red is the state's belief that it involved my client, right? And what I can tell you, what I see here is that it's a conversation in between the number ending in 3604 and the known number for my client ending in 1595.
Yeah, yes, but I just asked you to zoom in just a tad bit. Sorry. If you can, it's okay.
I think I can. Give me 1 second. That's what I didn't want to happen. So, unfortunately, it doesn't give me the ability to be able to do that cleanly.
Fair enough.
I'm try to do it again. You see it any better now?
Yes, there we go.
Okay. So that is a phone call in between my client through his known number and his brother, right?
Yes.
And then you testified on direct that there was a lot of activity, in and around the time of the murder, right?
Yes.
No red.
No red, no sir.
No red, none.
Not in the pages that are on my screen.
All these people talking back and forth, Dominique Barner, right?
Yeah,
Abdul Jr., Torgon Williams, no red.
No red.
One of the items that you have in evidence in this case is my client's actual phone for the 1595 number, right?
Yes.
You've looked through that.
Yes.
You've looked at the notes that are in there as well too, right?
The notes are kind of hard to look at on the Cellbrite reader.
So I'm now going to show you what's been entered in as state. We got Exhibit 9U 229. All right. Now the government entered into evidence these notes, but there's no date or time. You see that?
No.
It'll pop up it takes a minute to transfer. You see that, right?
Yes.
No date and time.
That is from the iCloud return.
If you were to access the actual phone that we have here in court, you can see the actual date and time of those notes, right?
Potentially if they still exist on the device.
All right. So for instance, this first note, if we look into the phone, December 4th, 2018. Would it refresh your recollection to take a look at the phone?
Yeah, because I don't even see where you're getting the date from.
One second.
Yes.
So type that. Take a look at that note. Let me know if that helps.
Okay.
Have a fresher recollection?
Yes.
So this first one, the one that the government entered into evidence, real killer, I'm a hunter, you don't want to see me with a gun, that's actually from December 4th of 2018.
According to the note section, yes.
a month of the shooting of Charles McCormick?
No, because I left to look at it through the Cellbrite reader.
More so than the actual phone?
Yes, because that's what we go by, is a Cellbrite reader.
But this is the Celebrate report, right?
Yes,
It says Celebrate.
but that's the iCloud, and I don't know, I'm just speaking, I don't know if, when it backs up, if it saves the dates. I can't speak to the efficacy of the backups.
So what we're showing you on the screen right now is the government's exhibit. You see Celebrate in the top right-hand corner, right?
I do?
There's no dates, there's no times, right?
Yes, and again, that's the iCloud warrant return.
Now, the whole purpose of Celebrate for the jury here is this, that cell phone, you're able to view it because it has an operating system, right?
Yes,
And so it organizes the information, right?
correct.
Now, when you get the information, the data from Apple, you need something to interpret all the data, right?
Yes,
And because you use PCs, you're not using an Apple iOS device operating system, you have Celebrate to understand and organize the information.
it puts it into a readable format, yes.
But it's still the same data.
But again, what I'm saying is it's an iCloud warrant return, so I don't know if it saves the dates and times when stuff was created.
All right. You have Celebrate in front of you, you have the actual phone.
Yes,
All of the information you have shows that it was December 4th, 2018, right?
for the phone, yes.
Now, I'm not going to go through each one of them, but I will ask the question. Do you know if any of those are within a month of when the murder happened? Any of these notes in here?
I can't tell just from looking at the Cellbrite reader.
Did you also search that phone for any emails whatsoever for House of Pain 904 at Gmail? Let me strike that, let me ask it in a different way. You've already said you reviewed the phone. There's nothing in there, even for emails that go back 5 years before the murder, that tied to House of Pain 904 at gmail.com.
Not that I recall.
Now, let's go to the one second for this to toggle over. Now. If it's with him. So I want to make sure that this is not zoomed in. You remember on direct examination talking about the IP address, right?
Yes,
How you recognize that IP address.
correct.
Okay. So within the meta records, now, at the same time we're showing this, but we're also talking about the meta records. For my client, you can see the IP address that was logged into during the time of the murder, right?
Roughly, yes.
Okay. If you need to take a look at it, let me know, and I can refresh your recollection with it, okay?
Okay.
But you remember taking a look. Sec. You remember taking a look in that's what? 32 characters? Roughly for an IP address?
Roughly.
And that's a unique thing that's tied, like this computer right here, IP address. This laptop that I have, IP address. This phone, IP address. Right?
Yes.
You know from the medical records a unique IP address that my client was using during the time of, so basically, you can see that he was logged into his Instagram account under a certain IP address.
It has upload IP addresses as well.
It's not that IP address.
Literally, without looking at it, I don't have the whole thing memorized.
Would it refresh your recollection to take a look?
Yes.
Okay. One second, Your Honor. counsel, page 6 of 6,717. So let me do this, if you need to reference it. I'll take the phone because the state wants it. On January 15, 2020, was my client logged in to Instagram, and do you see an IP address?
I do.
The IP address that you see in the meta records that are your evidence, it doesn't match the IP address of that upload, right?
From the information I got from T-Mobile, the first 4 of those little brackets you see are from the carrier itself. The last brackets are from the device. So they don't always match up. So the most important characters are the first 4 brackets you see there.
Now, you just brought up that you get a response from T-Mobile. You actually got what's called an objection back from T-Mobile, right?
Objection? I don't.
If I can approach.
Okay.
You actually requested from T-Mobile for any information with respect to the IP address from the meta records, right?
For that, but I had to, again, go ahead.
That's a yes, right?
That's yes.
Now, what you were asking for is T-Mobile. You have this 478-305-9583 number. Do you tie that at all to the IP address of my client, his meta records?
I believe that IP address is in there. I can't, without using the data records to refresh my memory.
T-Mobile responded to you and said no, right?
Right.
You don't have any record of that.
But again, it's the first 4 blocks that are the important ones from my understanding.
The IP addresses do not match, correct?
Not the entire thing, no. But again, what I'm trying to say is the first 4 blocks is what they told me was the important part, that the carrier themselves had in their records. That makes sense. But that particular one, okay.
You asked T-Mobile about that, and in response, they said, do you know records were found?
But that's different IP address. And that one, I'm sorry, the one that's currently on the screen for everybody to see, that one appears to be different because it's 2607, not 2601.
Do me a favor, and I'll re-ask the question.
Yep.
You see that?
Yep. No, what I'm saying is
Hold on.
Go ahead. Yeah, because again, that's 2601, not 2607. It's different. That's the issue.
My question is to you. You communicated with T-Mobile, and we're trying to find out if they had any connection between the IP addresses, and the response that they gave you back was no.
And again, the reason is it's 2607, not 2601.
So are you saying that you made a mistake?
I'm human. It happens. I don't know if, but again, without looking at the actual subpoena request, I don't know if I provided them with the correct one and they gave me that. Again, I haven't seen it.
Of course, you followed up with the correct IP address.
Yes, I should have.
But you don't know.
I can't recall this minute. Again, this is 5 years of investigating work.
So as you sit here today, you have no way of saying that my client ever was logged into Instagram on that phone number 478-305-9583.
And I'm saying that the objection letter that you just showed me was 2607, not 2601. So the IP address is different, is what I'm saying.
I get that. I understand you requested the wrong one, but you never followed up and got the right one.
I believe I did. I got a 47. I'm telling you, I got a record from that, the IP addresses.
Sitting here today, you can reference no piece of evidence that ties my client definitively to that phone.
Without going to, again, as I said, I've done an iCloud search warrant for the House of Pain. I've seen all the photos attached to it. Literally where I got that number from was from the IP addresses, from the Instagram account for Queso 23X. So that is how I tied it back to him.
We're talking about the IP address for my client's Meta. Of course, it's going to tie back to him. What I'm talking about are connections over to the 478-305-9583. Sitting here today, the only thing that you can reference is the House of Pain email, which we've already discussed, right?
Yes.
One brief moment, Your Honor.
All right. right, is there any redirect?
Using what's on the ALMA? If not, I want to return to the clerk. This one.
Sergeant, may it please the court?
Yes?
Thank you, Judge. So, turning to the screen in front of you that shows that YouTube video that defense counsel was just referencing,
Yes.
you see the IP address for the upload IP, correct?
Yes.
All right. And the first four digits, or first four groupings of numbers are what exactly?
Sorry, 4 digits.
The first four groupings, 2601, colon, and then what's the next set of groupings?
344 colon C000 colon A990 colon.
And I think you were explaining or attempting to explain when you spoke to T-Mobile and you got records associated with requests that you sent in, you were also advised for an IP address what was the most pertinent part of the IP address. Is that correct?
Overruled.
Yes, the first 4 blocks are the most important
And what is your understanding as why the first 4 blocks are what you need to look at?
because the first 4 are signed by the carrier, and then the last 4 come from the device itself.
And does the device itself, is that allowed to randomly pick the last 4 groupings of numbers as part of the IP address?
Yeah, if he has no personal knowledge about it, then I'll sustain the objection, but you can inquire to see if he does.
Do you have personal knowledge as to how the last 4 groupings of numbers are assigned?
From the record response I got from T-Mobile, that is what was indicated to me,
Which was what?
that the last 4 assigned by the device can be random.
I'm sorry, the last part I couldn't hear.
Last 4 can be random.
It'll be random, okay. So the first 4. So that specific 4 groupings, 2601, colon, 344, colon, C000, colon, A9990. You've seen that IP address before, correct?
Yes.
And going back to Hakeem Robinson's Instagram account, the Queso23X, where did you see that specific first 4 groupings of numbers for an IP address?
I remember it seen on the login IPs.
Do you recall the nail salon video posting?
Yes,
Right. And was that on January 20th of 2020?
it was.
What was the first 4 grouping of numbers for that IP address?
It's the 2601-344-C000-A990 that you see there.
All right. And when you reviewed those Instagram records and saw those first 4 groupings for the IP address, is that what made you then send in subpoena requests trying to identify phone numbers associated with that IP address?
Yes.
And as a result of the records you obtained in response to that, what phone number did you identify?
478-305-9583.
And then you sent record requests to what company?
Apple.
And is that when you got the House of Pain iCloud account information back?
Yes.
Do you recall on direct a long time ago when you were looking at the cell phone records?
Sustained.
I apologize.
Well, I haven't heard the question.
When you were looking at the cell phone records for these phone numbers, 478-305-9583, do you recall doing that?
Yes.
Do you recall when that phone number was activated?
The date it was activated was 11/12 of 2019.
When was the House of Pain iCloud account activated in relation to that? Do you recall?
I believe it was the same day.
And so when you were asked a bunch of questions about House of Pain, Gmail account, and not seeing any of that on 704-1595 number related to Hakeem Robinson going back 5 years, the House of Pain iCloud account didn't exist 5 years prior to that date. Is that correct?
That'd be correct.
So it didn't come into effect, I believe, that you said until when?
11/12/2019.
Now, when you reviewed the iCloud account associated with House of Pain, you were asked about photographs and videos and selfies. And there was, I believe your testimony was there were multiple selfies and photos. Is that correct?
That's correct.
Now, you looked at hundreds of photos and videos on that iCloud account. Is that correct?
Yes.
Now, were all of those photos and all of those videos, did they all contain Hakeem Robinson?
For the most part, yes.
And it was either, let me ask it this way, were they either selfies or included Hakeem Robinson with someone else?
Yes, sir.
So it's not just a couple selfies.
Okay, sustained.
Is it more than just a couple?
Yes.
In fact, it's hundreds.
Sustained.
Is it hundreds?
It was, yes.
You were asked questions about the 704-1595 cell phone number attributed to Hakeem Robinson, and I think you were shown some records showing activity on January 15th, 2020 in the morning. Is that right?
Yes.
Do those cell phone records show whether or not FaceTime calls were made?
No.
So that's not contained within call detail records?
Overruled.
Is it,
I'm sorry, say the question again.
are FaceTime calls contained within call detail records?
They are not.
Are FaceTime calls data files?
Yes.
Now, when reviewing the cell phone records for 704-1595, it was on in the early morning hours, a little after 5 a.m. I believe you testified previously. Does that sound familiar?
Yes.
When did it stop receiving activity? Data, calls, when did all of that stop on January 15, 2020, if you recall?
I can't recall specifically, but I want to say it was around 9 a.m.
Would it help you if you actually saw the records?
Yes.
Do you see what's on this monitor in front of you?
Yes.
All right. And are these those records for the 704-1595 number?
They are.
And currently, what time is reflected on these records for January 15, 2020?
It's 11:03 UTC time at the latest, and the earliest is 10:14 UTC.
So what would that equate to in Eastern Standard?
It's 5:14 a.m. for the 10:14, and for the 11:03 it is 6:03 a.m.
And then what is line 42? What time is that?
It's 12:11 or 7:11 a.m.
Line 43, the very next line for activity, what time is reflected?
18:10.
What is that?
That would be -5, 1:10.
So prior to that activity at 7:11 a.m., and then the next activity is not till 1:10 p.m.?
Sustained. Rephrase your question.
Activity stops at what time?
12:11. I'm sorry, which is 7:11
a.m.?
a.m.
And then the next activity is how many hours later approximately?
The next activity is at 1:10 p.m.
So from the period of 7 a.m. approximately till a little after 1 p.m., there was no activity on the records for that phone? Objection. Standing objection.
Well, no standing objections here, but I will sustain the objection.
Was there any activity on the phone between the hours of 7 a.m. and 1 p.m.?
According to these records, no.
You were asked a lot of questions about different witnesses at the Merrill Road Shopping Plaza, and in this case, is that right?
Yes.
Now, in this case, was it somewhat unique actually had a dash cam video that captured the murder.
Yes.
And on that dash cam video, can you actually see Mr. McCormick before he is killed?
Yes.
Can you also see the shooter?
Yes.
And based on the witnesses that were on the scene, do you recall Victor Kruger?
Yes.
And are you familiar with Tashita Saunders?
Yes.
Who were the two witnesses that were the closest to this shooting?
Ms. Saunders and Mr. Kruger.
And are you aware of the descriptions they provided?
Vaguely, without refreshing my notes. From my notes.
But they were asked.
They were.
And they were the two closest. With regard to other witnesses that were further away, that they provided some descriptions, correct?
Correct.
And did those descriptions vary among the civilians that were at different locations, different vantage points?
Yes.
And with regard to Ms. Boston, who was at the apartment complex on Arlington Expressway, you were asked about showing her a photo spread, is that right?
Yes.
Did she indicate that she would have been able to identify the person if she saw them again?
I don't believe she did.
Would that have factored into whether or not a photo spread was shown to her?
Yes.
You were asked a lot of questions about Dominic Varner and Chris Brown. Is the only evidence in this case throughout the entire investigation that you received that brings Christopher Brown into it Dominic Varner himself?
Overruled.
Yes.
So if Dominic Varner wouldn't have mentioned Christopher Brown to you, is there any other piece of evidence that you have that would have told you he may have been involved in any way?
No.
And Dominic Varner is a co-defendant of Christopher Brown in a separate homicide case, the Damon Rothmel case, is that right?
That's correct.
And is Dominic Varner testifying against Christopher Brown in that homicide case?
I believe he is.
And so, is Dominic Varner protecting Christopher Brown in that other case?
No.
Okay. If he knows, he can answer. Otherwise, I'll sustain the objection.
Is he a witness against Christopher Brown in the other homicide case?
He is.
Now, your investigation and the evidence that you collected in this case, does it go beyond Dominic Varner?
Yes.
Now, going back to the dash cam video for a moment, did that identify a vehicle in this case?
It did.
And what vehicle was that?
A silver Nissan Altima.
And was that silver Nissan Altima pursued out of the shopping plaza?
It was.
And it crashed?
It did.
Based on the dash cam video as well as the video surveillance you recovered from the Townsend neighborhood, how many suspects were you looking for related to the Nissan Altima?
3.
And one of those individuals you believe to be Dominic Varner?
Yes.
And he's confessed?
Yes.
So that leaves how many more suspects?
2.
How many guns were recovered in the car?
2.
And what were they?
It was a Glock handgun and an M&P rifle.
And were both of those, and let's talk about the rifle, was the rifle loaded?
Yes.
Where was the rifle located in that Nissan Altima?
The rear floorboard.
And on that rear seat, what else was located?
A white T-shirt.
And was there DNA on that white T-shirt?
There was.
Whose?
I believe it was Mr. Whitaker's.
And then in the front of the vehicle, was there something else that was located?
Another white shirt.
And what DNA was on that?
Hakeem's. Robinson, sorry.
And the firearm, that Glock that was up in the front seat, had fingerprints?
Yes.
Whose fingerprints?
Hakeem Robinson's.
So if you have 3 suspects and you remove Dominic Varner, who's confessed, and you are left with 2, how many pieces of forensic evidence or DNA or fingerprints do you have for suspects in that vehicle?
3.
Identified.
Sorry, 3.
Take Dominic Varner out of it.
Oh, sorry, 2.
And those are for who?
Mr. Whitaker and Mr. Robinson.
Overruled.
Now, going from that Nissan Altima down further down Townsend to 1033 Townsend, Miss Buckley's residence, right?
Yes,
And how many suspects were believed to be involved in that, according to Miss Buckley?
2.
And did you get DNA results during the course of this investigation related to 2 different individuals in Miss Buckley's home?
Yes.
Who were they?
Dominique Barner and Larry Whitaker.
Going back to a question that was asked of you regarding Miss Boston and Christopher Brown, you were shown a photograph, a defense exhibit of Christopher Brown, and asked if he had butter pecan skin tone.
Yes.
In your opinion, looking at that photograph and looking at Hakeem Robinson, do they have the same skin tone?
Roughly.
Does Barner know who the shooter is in this case?
I believe he does, yes.
Natalie Gant. There are several questions regarding her phone records, right?
Yes.
You receive her phone records,
Yes.
right? And the subscriber information.
Yes.
Did you submit the correct phone records to the FBI agent to see if they could map them?
Yes.
So regardless of whether or not there is a scrivener's error on his report, did he receive the correct records from you?
Yes.
Your Honor, may I approach the witness?
Yes?
Sergeant, did you, when you received the 704-1595 number, cell phone, did you review it?
Yes.
And did you review the data that was able to be recovered from it?
Yes.
And I know that you were asked some questions regarding notes on that phone by defense counsel a few moments ago. Is that right?
That's correct.
The notes that you were shown, were there additional notes that you saw on that phone?
Yes.
Including those, or were there notes that were close in time to Charles McCormick murder?
It's closer in time than the ones he showed me, yes.
Some even from the same month?
I'm sorry.
Were there some from the same month of 2020, January 2020?
Yes.
Your Honor, may I approach the witness?
Yes?
Can you take a look at this device for a moment and tell me if you recognize that specific note, sir?
Okay. Is there a question that precedes this?
Do you remember verbatim the note in January of 2020?
No.
With looking at this device and allowing me to read that note, refresh your memory.
Yes.
Can you tell us when that note was made?
The note was made on January 31st of 2020.
And can you tell us what the content of that note is? Objection.
And what's the objection? All right. Let me see court and counsel. Yes.
Other than the date, just the date.
Okay. It is from January 31st of 2020.
Is that a note that is contained within on that phone?
Yes.
And are there notes that are in close proximity to the time of the murder on January 2020?
Without looking at the phone, I can't say exactly.
That one of the notes in close proximity to the time of the murder?
Yes.
There were some questions regarding communications between Hakeem Robinson's Instagram account and Raekwon Howard. Do you remember that?
Yes.
And specifically, questions going back between communications into, I believe, December of 2019. Do you remember that?
Yes.
Are you aware whether or not Hakeem Robinson's mother's home was shot up in December of 2019?
And the grounds? Okay, I don't understand the relevance. I'll give you one question to try to tie it up.
In relation to the communication between Hakeem Robinson and Raekwon Howard, who are on opposite groups, right?
Yes.
I believe there were questions related to why they would be communicating kind of jovially, right?
Yes.
Was there still indications that there was friction between the two groups?
Overruled. If he knows he can answer, if not, then I will sustain.
Sorry, can you ask the question again?
Sure. So regardless of the communication taking place between Hakeem Robinson and Raekwon Howard, opposite groups, was there still indications that there was friction between the two groups?
Yes.
Did Raekwon Howard personally put out a diss song regarding Willie Addison?
No.
Who did that?
Mr. McCormick.
You were asked a lot of questions about Abdul Robinson Sr.'s email account, is that right?
I don't know if it was his Gmail account as much as it was his Instagram account.
Okay, excuse me, Instagram account. Did you identify Abdul Robinson Sr.'s cell phone number?
Yes.
And did you actually, in fact, recover that cell phone?
Yes.
As well as cell phone records associated with that number for the time of January 15, 2020?
Yes.
And based on the records that you received for Abdul Robinson Sr.'s phone number, did you submit that to FBI so that it could be mapped as well?
Yes.
And did those results tell you exactly where Abdul Robinson Sr.'s device was on January 15, 2020?
Yes.
And did you also get video surveillance from 1430 Townsend Boulevard that captured a vehicle on January 15, 2020?
I did.
And do you recall what vehicle was captured?
An orange Dodge Challenger.
And based on Abdul Robinson Sr.'s phone records, was he anywhere near the Merrill Road Shopping Plaza at the time of the murder?
All right, if you'll clarify the question.
Based on the cell phone records you obtained for Abdul Robinson Sr.'s phone number, was that device located in the area of the Merrill Road Shopping Plaza at the time of the murder?
It was not.
And the two 478 area code numbers in this case, one 478-305-9583, the other 478-491-2831, I believe.
Yes.
Those were both activated on the same account?
Yes.
And were they activated on the same day?
They were.
And the 478-491-2831 you identified as belonging to who?
Abdul Robinson Jr.
I'm sorry to interrupt you, Mr. Cooper. I have, as I've told the jury, if anyone needs to reach you in any type of emergency, we are here to receive messages and convey them to you without delay. So juror number 4 on this jury, your husband needs you to call him immediately. So we're going to take a recess. I'll let you go ahead and leave quickly first.
bus driver who said he was loosening any remaining grip from around Fatima's throat. All right? Now, there was a point, and we've seen it, where Fatima goes limp, okay? What I want to tell you is, you can see, at this point, I will give you the exact frame, 214:02.8, she starts moving her feet, okay? So we can assume at that point that whatever has been compressing her throat has been removed. Now, let's assume for a minute that it is her dad's arm that's compressing her throat. Seems reasonable, right? We can all agree on that. Whether or not there's a crime, though, requires more than that, okay? There has to be an intent to assault, okay? And intent is not just, oh, well, there's obviously intent because it happens. No. Intent requires purpose, right? You have to be acting to make something happen. I'm going to give you an example, all right? This is one of my favorite intent examples. You're in a basketball game. There's 2 seconds left in the game. You're on defense, right? You're down at the other team's offensive end, and the guy's dribbling. You steal the ball from him. You win the game, right? Enjoy a celebration with a second left. You throw the ball up in the air, right? It goes through the basket. You lose the game because you threw it up before the clock went, right? You didn't intend it to happen. It certainly happened. There certainly were consequences of it happening because the ball went through the hoop. That doesn't mean you intended for the ball to go through the hoop just because you threw it in the air, right? You didn't have the purpose. Cost you the game. You lost. No intent. Bad consequence. That happens. Accidents happen. Situations happen where you're attacked by a mob and you don't know exactly what's going on. You've got people yelling, people kicking, people hitting you. You're laying there. You don't know what's happening. You're hanging on. You've been kicked in the head. You could have edema, cerebral edema. You could have a concussion. You could have any of these things. And you say, well, where's the evidence of that? The evidence of that is that when asked, Mr. Ali, 40 minutes after this incident, you want to see a doctor? He says no. That's the medical that we have on Mr. Ali. There's no way to know what happened at that time because no medical exam was done. They listened to a guy who just clearly been beat about the head and neck area, right? He'd been beat severely. They asked him for his opinion on whether he needs to go to the doctor. Doesn't make any sense. He's been knocked out. According to Isaiah, he punched him enough times, he broke his hand on his head, and he knocked him out. That's where we are, okay? Now that, let me play the video for just a couple more seconds here. We're at 2:14:02. Let's play it. Until there. You can see at that point, it's kind of hard. I'm sorry, Your Honor. 2:14:08, frame 6. Again, you guys will have all of this in the room. You can take a look at it. If you look right here, you can see that Fatima is laying there next to her father. And at this point, this is the hat right here of Mr. Wagner, and he then sits on Mr. Ali for the remainder. Mr. Ali no longer moves from that point for the next several minutes, okay? And it's not until Officer Hang comes and arrests him. So that's the end of that video, 2:14:08. That's the 53 seconds that we're talking about. That's the amount of time for all of this to happen where Mr. Ali allegedly formed the intent to kill his daughter. That's what they're thinking that he was doing. A man who called the police when his daughter was missing. Not just once, but at least twice. A man who spent the day looking for his daughter. He finds her. He wants to take her home. He has no idea what's going on, except that she ran away that morning. No one has had the courtesy to call him and tell him what's happening. So what does he do? He goes, he tries to take her home.
Yes, as you know, I excused both juries because juror number 4's husband needed her to call him immediately. She's just gotten word her daughter's being life-flighted to a hospital. She is upset. I could tell from when the door was open she is crying. I'll let the parties inquire if they want, but Ms. Schlax, if you'll talk to your client about what he wants to do. That means your alternate number 2 would now be on the jury, and that is who was originally juror 62, who neither side had objections to when he was seated as an alternate. But just so if you want to look through your notes and whatnot. Okay.
at that point informed intent to either A, kill his daughter, which obviously didn't want to do, or B, seriously maim her. Assault 1, no. The question is, did he strangle her with an intent? Did he intend it? Was it intended at all when he's there? Or is it just circumstantial, right? Just because I'm on the ground, I've been tackled, I've been dragged, I've been kicked, I've been punched, I'm hanging on to my daughter. I don't know who these people are trying to take her, but I sure don't want to let her go. Something a father would do. Something a father would want to do, hang on to his child. Now, is it unfortunate that her neck was compressed? Yes, it was. But that is not a crime if you don't intend it. Okay? Now, it probably would have been better in this case if all the witnesses hadn't watched this video before coming to testify, because it's possible some of their testimony could have been contaminated by what they saw, which is different than what they remembered, but it all was the same pretty much, except they still made mistakes, right? They still made mistakes because they didn't want to know what they had done. I want to just talk a little bit more about the witnesses that we heard from. We heard from Dr. Gilbert. She's the one who testified. She said the body's an amazing thing. What she also said, if you're knocked unconscious, it says the body's functioning, but the ability to control it is not there. Okay? If you're hit in the head and you're concussed, you lose your abilities to use your brain. If you don't have the ability to use your brain, you can't form the intent necessary to commit the crimes that the government is alleging. Right? They said he did not go to school with a plan to kill his daughter. He did not develop a plan to kill his daughter between when he got out of his truck and when he was tackled to the ground. What he did was develop the intent to hang on, to protect his daughter. They showed nothing else. They showed no evidence of anything. They didn't have him saying, I'm going to do this, I'm going to do that. They had no evidence of anyone hearing him making any threats. They had no evidence of any of that because there wasn't any. No intent. What was in his mind? Did they prove it to you beyond a reasonable doubt? Get into jury instructions beyond a reasonable doubt. Something, a doubt for which there is a reason. Okay? As to any single element of a crime. And in this case, intent. Is there a doubt as to his intent? Yes, there is. How do we know? Because they didn't provide us any evidence. They provided us physical activities that were going on. A mob beating a man getting punched and kicked in the head, a man getting dragged across the ground, a man hanging onto his daughter. And from that, they're trying to have you think, well, intent to kill. If not intent to kill, intent to maim. If not intent to maim, intent to strangle. None of that was proven. None of that was proven in this case. No intent. And let's talk about parental rights, right? You have the right, when your daughter is gone, run away, to take her home. That is your parental right. Okay? Grabbing her by the shoulder, taking her home is not against the law. Okay? What happened here, though? Isaiah got himself involved in this. He put himself.
The state has been presenting against you, is that correct? And you understand that it's the state's burden to prove these two charges against you beyond a reasonable doubt. Do you understand that? That means that you do not have the burden to prove or disprove anything in this case. Do you understand? That also means that you do not have to testify in this case. You have the absolute right to remain silent. Do you understand that? But of course, that also means, if you wish, you have the right to testify if you choose to do so. You understand that? Now, this decision of whether or not to testify or not testify is yours and yours alone to make. You have a very skilled attorney whose advice you should certainly listen to and consider. But at the end of the day, the only person who can decide whether to testify in this case is Leroy Whitaker. Do you understand that? Now, if you choose not to testify in this case, I will advise the jury, as I already have, that every defendant has a right to remain silent and that at no time is it the duty of the defendant, or I should say that at no time does the defendant or is the jury permitted to draw any inference of guilt from your exercising of your right to remain silent. Do you understand that? Yes, ma'am. I will also instruct them that the fact that you did not take the witness stand must not influence their verdict in any manner whatsoever. Do you understand? Yes, ma'am. Of course, if you choose to testify, you will be treated like any other witness. You will come forward, you will be placed under oath, you will sit in that chair where all the witnesses have been seated throughout the trial, and then you will be examined by your attorney, and then you would be cross-examined by the state attorney. Do you understand that? And like with any witness, if you have any convictions for felonies or crimes of dishonesty, your credibility could be impeached with the existence of those convictions. Do you understand that? Now, just so we're all on the same page, does Mr. Whitaker have any convictions for felonies or crimes of dishonesty? Okay, and that's your estimation as well, Ms. Schlack?
I think he had adjudicated as a delinquent, as a juvenile, but.
Okay. As adult, okay.
He was only 19.
All right. So, Mr. Whitaker, have you had enough time to consult with your attorney about whether or not you wish to testify? Has she answered all of your questions to your satisfaction with regard to that issue? Do you need any more time to consult with her about whether or not you wish to testify? Have you made a decision about whether or not you wish to testify? And what decision have you made? You don't want to testify. Has anyone threatened you or coerced you in any way in order to get you to make that decision? Has anyone promised you anything in order to get you to make that decision? Are you making that decision freely, willingly, and voluntarily? Okay. In addition, Ms. Schlax has announced that she is not going to be calling any additional witnesses. She's cross-examined all these witnesses, but she's not going to be calling any witnesses in a defense case. Do you understand that? And do you agree with that decision? Were there any witnesses you wanted her to call that she's not calling? Were there any documents or other exhibits and evidence that you wanted her to introduce that she's not introducing? Have you been satisfied with her representation to this point? All right. And now again, because the state hasn't formally rested, once they rest and once we come back together for what's called the judgment of acquittal argument, I'm going to just ask you one last time to make sure you haven't changed your mind and that you still do not want to testify. You understand? All right. So, because up until that point, if you change your mind and wish to testify, you are free to do so. You understand that? Okay, then you may resume your seat. All right. Okay, we have everyone here. Is everyone ready to bring the jury out and conclude with the testimony of this witness? Okay. Then let's jury's out and let's continue. Thank you.
He stuck his hand up in his face. He pulled on Fatima, and he was wrestling with Mr. Ali. Again, Mr. Ali doesn't even know him. Doesn't know who this guy is. Doesn't know what his intent is with his daughter. Right? Mr. Ali does what? He punches him one time to get him away. He doesn't knock him to the ground. He doesn't knock him out. He hits him. Isaiah literally takes one step back before he turns, points, and yells. Starts running back towards Mr. Ali. He doesn't run to protect Fatima. He runs to get Mr. Ali, the man who just did it. He's angry. Okay? So the question is, was the punch that Mr. Ali threw reasonable? If it's not reasonable, it's not self-defense. But what does he have? He has a guy he doesn't know, grabbing at his throat area, pushing him around, turns around, takes one swing at him, turns around and walks away. Right? He doesn't go beat him up. He doesn't pound him into the ground. He doesn't kick him in the head. He punches him once, goes back to what he's doing. He's trying to get his runaway daughter home. Okay? Trying to get his runaway daughter home, not a crime. All right? Striking someone when they're interfering with you, getting your daughter, by grabbing at you, you can defend yourself as long as it's reasonable. Right? He didn't pull a gun out and shoot Isaiah. That would be unreasonable, right? He got him, he hit him once, he turned around, he went away. That's self-defense. All right? Now, what about some of the other issues that they're bringing in? Again, they become kind of irrelevant. There's no intent to kill. There's no intent to do serious bodily injury.
Got both Mr. Atkinson and Ms. Kawas, and we're going to continue then with the redirect of the witness. Go ahead, Mr. Cooper.
Sergeant, you were asked about some exhibits that are in evidence regarding Dominique Varner, photographs that were taken of him on January 15, 2020.
Yes.
When Hakeem Robinson was arrested in September of 2020, there would have been a booking photograph taken of him at that time as well, right?
Yes.
And additionally, during the course of the investigation, based on cell phone exams and other records that you've obtained that are in evidence, did you find photographs of Hakeem Robinson close in time to the murder of January 15, 2020?
Yes.
And did those photographs show what Hakeem Robinson looked like in January of 2020?
Yes.
And there were some questions regarding the Bang It Out video and the fact that there were guns in Hakeem Robinson's hands as well as other individuals. Is that right?
Yes.
The fingerprint that was found on the Glock handgun in the Nissan Altima, where was that print? Was it on the handle or was it on the slide?
I believe it was on the slide.
No further questions, Judge. Thank you.
All right, thank you. And ladies and gentlemen, let me give you one other instruction that I failed to give you before you viewed the YouTube video that has been moved into evidence as State's Exhibit number 193. That, if you recall, is the video that was lacking in audio for the most part. So ladies and gentlemen, the court instructs you that that recording has been edited to eliminate the irrelevant portions that would not add to your understanding of the case. The fact that the recording has been edited should not concern you in any way and must not impact the way that you view, listen to, or consider that evidence. But with the close of this witness, then I'll call upon the state. All right, ladies and gentlemen, the state has rested its case. This does require us to take up a matter, once again, outside of your presence. I promise it shouldn't take long, and then we will be continuing here shortly, but I'm going to have to ask you to once again leave your notepads on your seats and have a step into your respective jury rooms, and then we'll bring you out here just as soon as we can.
Mediastinum. What did we hear about pneumomediastinum? We heard that usually it just goes away, right? It's air in your cavity. It went away in this case. By 8:30 the next morning, it was not getting worse. She had been monitored, no problems noted. It's over. That is not a serious bodily injury, a great bodily injury. It's none of those things, okay? What you're going to be asked to do is look at these different things, and you're going to have to say, well, did he intend this? Well, I'm saying he didn't intend anything. But if you read it, first of all, for assault one, did he intend great bodily injury? Okay? That's permanent injury. Did you plan on permanently injuring somebody? Did you plan on permanently disfiguring them? Did you cut a finger off or cut their ear off or cut their nose off or something? No. Did you cause a permanent functional issue with one of their organs? Did you pop an eye out? Did you do any of those things? No, you didn't. That's great bodily injury. You're going to notice in your instructions, which are a freight train, I know, assault 2 is different. Assault 2 is substantial bodily injury. That's already significantly less than great bodily injury. That's substantial bodily injury. The definition for substantial bodily injury. Was it something that happened that is somewhat temporary, right? I mean, you could say, I guess if you intended to strangle someone and cut off their air and blood, you could say, well, that's substantial bodily injury because it temporarily cut off the blood flow, right? It's not great bodily injury because it didn't cause any permanent damage. It didn't have anything that was going to last forever, all right? So part of the issue with the jury instructions is they're quite long. They're quite lengthy for all the different crimes, okay? But the definitions are all there. And so what you have to do is you have to take a look at them and say, okay, of the elements, what did they prove? Did they prove intent on all the assaults and the murder, attempted murder? Did they prove intent? What evidence did we have that we can now find factually that they have proved that beyond a reasonable doubt? They've proved it beyond the point where we have no reason to doubt their evidence. Not a single reason. Okay? It doesn't have to be a series of reasons, and it doesn't have to be a series of elements. It has to be one reason for an element not being proved. One reason to give you a doubt. Now,
Mr. Barner testified that he had the intent in the early morning hours of the 15th, that he's with Chris Brown going out to the apartment complex, that he's calling Admiral Robinson. He does not articulate any conversation or any actions by my client that would actually constitute, and therefore we would ask the court to direct a verdict as to that count in our favor. Additionally, Your Honor, in regards to the burglary charge, again, the testimony was that allegedly the second intruder, once again, not any real testimony of what he supposedly said or did to show any kind of intent to commit any kind of offense within the Buckley home. And so we would also ask for a directed verdict as to count 2, because the only evidence of supposedly any actions, again, relies on the credibility of Mr. Barner, that we would suggest to the court is so wholly insufficient that a directed verdict should be granted.
All right, thank you. State wish to respond?
Unless the court has any specific questions, it's clear, the language is favorable to the state, that the defendant was a full participant in the first-degree murder as well as the burglary of assault and battery. All elements were satisfied based on the testimony of Donald Barner and so specific questions for all that.
Okay, thank you. Well, of course, as the parties know, as the attorneys are well aware, at this juncture, the court must take the evidence in the light most favorable to the state. Any issues of credibility of Mr. Barner or any other witness that has testified is strictly an issue for the jury to determine. Based upon that, I'm going to find that in the light most favorable to the state, that the state has established a prima facie case as to first-degree murder and as a principle, and burglary with an assault or battery, given not only Dominic Barner's testimony, but of course Barbara Buckley's testimony, and deny the motion for judgment of acquittal at this time. All right, I'll hear from defendant for Mr. Robinson.
Thank you, Your Honor. At this time, on behalf of Mr. Robinson, at first, the defense would like to review all previous motions and objections, including any motions that were made during jury selection. At this time, taking the light most favorable to the state, the defense would move for its first judgment of acquittal, understanding that the letter at this time is a prima facie showing, and that the court must take evidence in light most favorable to the state. The main issue seems to center
Okay, thank you. And likewise, again, as you've acknowledged, in the light most favorable to the state, I will find that the state has established a prima facie case as to murder in the first degree for Mr. Robinson. Again, the credibility of the witnesses, whether Mr. Barner, Abdul Sr., or anyone else, is for the jury's determination. Given that and the testimony that we've heard over the course of the week, I'm going to deny the motion for judgment of acquittal at this time. All right. Then, when we bring the jury back, I'm going to turn to Mr. Whitaker's table. I'm going to ask if Defendant Whitaker has any evidence it wishes to present. You can rest in their presence if you are not going to call anybody. And so, as I promised you I would, now, Mr. Whitaker, that the state has formally and officially rested from the moment just not too long ago that I colloquied with you, that I talked to you, have you changed your mind at all about whether or not you wish to testify? If you could please stand, sir. Thank you. And is it still your intention that you do not want to testify in this case? Okay, sir, thank you. So, so that we don't then have to send the jury back out, do you want to make your second JOA now?
Yes, Your Honor, we would renew our motion, again pointing out to the court the credibility of Mr. Barner and the absence of any specificity or detail to give this court any kind of confidence that Mr. Barner has articulated that my client is a principal.
All right, thank you. I'll deny the second motion for judgment of acquittal. And so then when we return, as stated, Defendant Whitaker will rest in the presence of the jury, and then I'm going to turn to Defendant Robinson and ask if the defense for Mr. Robinson has any witnesses it wishes to call. So, Ms. Kawas, did you have an opportunity to check with any witnesses? Will they be testifying this afternoon? Okay. 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 Yes, we'll get him a letter. Madam Clerks, can we do that? So before we leave today, we can provide him a letter of some sort?
I mean, he has our defense email, but it says for the week, but I just think that he has that for Monday, if he couldn't give anything before
Okay, we'll excuse them for yesterday and today. Okay.
And Your Honor, my client and I would like to absent ourselves for any further testimony.
All right, since these are not your witnesses, okay. Well, let me just confirm with Mr. Whitaker, you don't wish, Mr. Whitaker, if you'll please stand again. Of course, your case is rested. These are not going to be your witnesses. These are Mr. Hakeem Robinson's witnesses, but you wish to be absent during that part of the testimony? And you don't want your attorney to question those witnesses in any way? All right, and have you had sufficient time to talk to your attorney about that? And has she answered all your questions to your satisfaction with regard to that issue? All right, and this is for just Mr. Howell and Mr. Roberts who are going to testify today, or does this include witnesses for tomorrow?
I will reconfirm with Mr. Costa and Ms. Glass, but I do not anticipate any testimony that I think would be helpful to our jurors or would be helpful to our case. Honestly, we were speaking of things that have no application to Mr. Whitaker or Mr. Whitaker.
So then does Mr. Whitaker's jury even need to be here? No, right, that's what, I just wanted to be sure.
That's our primary reason.
Okay.
For absenting yourself. And I will stay, Your Honor, because I understand that the court's going to want my physical presence at the charge conference, and Mr. Whitaker will have to stay as well to handle that charge conference.
Are we doing charge conference today?
Whatever the court wants.
Okay. Well, we'll see what time we get to, because, I have to excuse the staff as well, and it's already past 5 o'clock. But what's the state's position? I mean, if these witnesses are not being called by Defendant Whitaker, can't Defendant Whitaker's jury be excused?
It just makes me nervous. I appreciate what the shop's saying. We're talking about witnesses that were at the scene. I don't know whether
Okay. Is that a legal objection?
whole purpose, we joined these trials, and there's been no evidence that one jury is hearing something they shouldn't hear. Now, we are going to separate the witnesses from evidence, and I'm uncomfortable. That's going to play into the closings, and I don't know, there's no unringing the bell, if something should come up in the direct across. Suddenly, Mr. Schlack says, oh my gosh, we need that. I appreciate what you're saying. I'm not criticizing, I don't understand. I'm just, these trials have been tried together, they're not severed, and these are witnesses being called. They will talk about things.
Well, and if we do this, then we would need to do two closings.
Right, the state does not want to do two closings, you want to do one closing in front of both juries. And again, there's no evidence here. It's rejoined. I don't anticipate any evidence presented by Robinson would not be admissible against the defendant. So although it may not be overly probative, it's not prejudicial. They have already, through the course of this trial, listened to a ton of evidence that relates only to one defendant and vice versa. So we don't have much time, and I think we can crack through this pretty quickly. I appreciate it.
Yeah.
So I think that's, a legal objection is these defendants are joined, we're taking evidence and issuing this.
What is the prejudice for you to remain, Ms. Schlax, if I don't grant your request to absent yourself during this part of the trial, given that the defendants were indeed joined in the indictment to be tried together?
Your Honor, my understanding of what they intend to present and for the purpose, they appear to want to attack the original description of the shooter, for their ultimate argument that someone else is the shooter. I understand that the state of Florida has stood up in opening statement and told my jury that Lee Whitaker is not the shooter. However, our jury has heard evidence of my client's DNA in the Buckley home, as well as the Buckley home DNA is far more problematic in terms of the emphasis that's taken put on it in terms of when that DNA could possibly be left there, thus putting my client in that car. I am very concerned about the repeated explanations in front of my jury describing the shooter to be far smaller than what it appears Mr. Robinson is currently now, which would make it much more commensurate with my current size. And I don't want a jury to run away and start trying to interpret evidence over and over again. Oh, well, yeah, I keep hearing how these attorneys are talking about how the shooter is so small. I think that guy was in the car.
You are so convinced that that will never change, okay? You are not going to wake up tomorrow and say, oh, you know what, I just thought. They didn't prove this, right? Because they failed to do this. An abiding belief means you're going to remember that for the rest of your life.
My ruling, that they were joined in the indictment. We're going to try them together.
Didn't meet the burden for attempted murder because they didn't show any intent to kill. They didn't meet the burden for assault, assault 1 because they didn't show the intent necessary to get to assault 1. Okay? They showed a couple of minor injuries. All of those injuries could be associated with an accidental situation, right? I have my arms around you, a guy's dragging me on top of you. I could be strangling you at that point. The other thing is to remember about strangulation is it doesn't take much, right? It doesn't take much to strangle somebody. 4 pounds of pressure is what I heard from Dr. Gilbert, if you stop some sort of a vein, and 11 pounds of pressure if it's an artery, okay? Interestingly, she threw in 6 pounds of pressure for a pistol trigger, right? And much more than that for even a soft handshake. Much more than 11 pounds. A firm handshake, more than that, but not very much. Think about a handshake. That's how much pressure is more than 11 pounds. It could happen in a situation where you're hanging on to somebody, your hands get up around their neck, and you get dragged across the ground. At that point, after being kicked in the head, you may not realize what you're doing, right? You may not have the ability to know what your body's doing. People are screaming at you. People are kicking you. Up until the very last minute, Isaiah was punching him in the head. Up until the very last minute when Zara comes in and pushes Isaiah off. She pushes Isaiah. Isaiah says at that point he's knocked him out. Mr. Ali's laying on the ground. He's not moving. Everything's over at that point. Okay? He's that close to getting knocked out when all of this is happening. We don't know at what point he lost his ability to reason and function. Now, I've already touched on a couple of these things. One of the things that you're to talk about in instruction 1, I just want to mention a couple of things. I'm not going to go through all of them. Anyone that has personal interest in the outcome can have bias, okay? Personal interest in this case, essentially everyone involved in this case has a personal interest, right? They all say, well, that's what I saw. Well, did you? Because a lot of what I heard from the testimony was different than what we saw in the video, okay? Proof beyond a reasonable doubt, we just talked about briefly. Instruction 12 is the intent instruction. Proof to you beyond a reasonable doubt the objective or purpose of the defendant's actions was to accomplish a result that constitutes a crime. Again, objective or purpose, okay? You have to set out to do something. I can easily imagine a situation where you intend to strangle somebody. They're standing over there, you're mad at them, you go and you grab them around the throat and you strangle them, right? That would be clear intent. There's no mistakes, no accident, no way that you couldn't mean to do what you're doing. That demonstrates intent. We don't have that in this case. I think that the prosecutor's already touched on some of the other ones, like recklessly. Again, the degrees of injuries are different. The intent element, mens rea, the mind's thought process is different between assault 1 and assault 2. Okay? So make sure that you read the instructions carefully. And instruction 25, I made a note. And if you read instruction 25, let me just take a quick look and see what I did here. It says, this is about recklessness, right? A person is reckless or acts recklessly when he or she knows of and disregards substantial risk that a wrongful act may occur, and this disregard is a gross deviation from conduct that a reasonable person would exercise in the same situation. Okay? So, was he reckless? Was Mr. Ali reckless? Well, let's talk about the situation. He's on the ground, getting beat and kicked by people he doesn't know. Okay? And at that point, he hangs on to his daughter. Is that reckless? If you were in the same situation, a reasonable person, and that was going on, what would you be expected to do? Would you be expected to do something different? If you were going to act the same, you're not being reckless, right? Reckless, deviating from what they're doing in the same situation. Gross deviation, okay? Now, this all comes down to what a parent would do in a similar situation. Your daughter's run away. You don't know what's happening. You see her at the bus stop. You go to talk to her. She tells you she doesn't want to go. She's your child. You have the parental duty to parent, right? That's your duty as a parent. You say, we're coming home. She says, no, I don't want to go. A struggle ensues. And here we are. That's what this case is all about. There's no nefarious intents. There's no intents to hurt anybody badly. There's no intents to kill anybody. There's an intent to take her daughter home. 17-year-old daughter's run away. We know she's run away before, because we know from Mr. Barnes and Corporal Stanford that that's why they were at the house looking for him the weekend before. She'd run away. That's why Officer Hang went to her mother, went to the mother of Isaiah and had her call the school. They're looking for her. They know she's a runaway. So, I put to you that the state has not met its heavy burden in this case. They've not shown you proof of intent. And intent is what matters. Okay? Intent is the key. Look back through the evidence. What was the intent? Where did they show you anything in the evidence that you can say factually, there it is? They can't. They can say, oh, well, all of this bad stuff happened, which indicates intent. No, that's not it. We say, if it happened accidentally, then clearly it's not a crime. It's not intent. You can't say, well, somebody was injured, so they must have intended it. It's like your basketball guy. He made the basket, he must have intended it. No, he didn't intend it. It was wrong, it was a mistake. Bad things happen. without crimes being committed. Now remember now, Mr. Leary's going to have an opportunity to talk to you. He's going to talk to you a lot more about what happened after. But at this point, Mr. Ali has not been shown to have committed these crimes. I'm going to ask you to find not guilty of anything. If you do decide to go through on the lesser includeds, do it carefully, okay? Just because you say, well, maybe it wasn't in assault 1, it must have been an assault 2. No, intent is still required. Number 3, was there an assault 4? Take a look at it carefully. Did he intend it? Intent goes to all of them. Okay, totally forgot about unlawful imprisonment. I'm going to go back now, sorry. Unlawful imprisonment. Again, you have the ability to control your daughter, right? She's a runaway. He grabs her by the shoulder. That's not unlawful imprisonment. He hangs on to her. That's not unlawful imprisonment. Okay? What's he doing? He's trying to get his daughter into his car so he can take her home. That's it. That's not unlawful imprisonment at all. If it is, a lot of people in trouble. All right? I am going to leave it at that point and let you hear from Mr. Leary. Thank you very much.
Thank you.
Thank you.
Members of the jury, we're actually going to take a 10-minute recess at this time, and then when you come back, Mr. Leary will make his closing argument. Again, we are not done with this process. Do not
You hope, you pray that they do the right thing, and that when mistakes are made, that they're not devastating, that the child can learn from them, and when they emerge into their 20s, into their late 20s, you can look back, laugh, and cry, and be grateful that you're still together. I'm reminded of a story in jury selection that I think you were all there for, when the guy's talking about his daughter who ran away on a horse. And I asked him, well, where's she now? Oh, she lives next door. That's what one could hope for. But instead, the night of October 14th, or the late afternoon of October 18th, she's sitting in the car. Despite all of her efforts to track down and protect her daughter, she lost her daughter. We now have seen Exhibit 34 up until 214. So we know that the bus is passing her in the turn lane at 214, and she is then about to turn in behind the bus. How do we know that? We know that from Exhibit 114, and that is the parking lot surveillance video that shows the bus on Mullen Road and the arrival of the Honda Element. So there we see it turning in behind the bus. And we will see, or not. When you watch it back, when you're deliberating, you will see her run through the parking lot and the time it takes to go from when the car turns in, and you can time it up to when the fight occurs, to then running across the parking lot and to when she arrives. Okay, so in terms of this discussion about what other witnesses see and what they describe, none of that is she's privy to. She doesn't see the punch. She doesn't see the punches to her husband, the kicks, at least initially until she arrives. All right, so we're going to try something different. And we're going to try to go to Exhibit 34. And this will just take me a second to load up. So, we talk about what Exhibit 34 shows, it is something that I anticipate that you're going to spend a considerable amount of time. Because fortunately for my client, in 2025, 2024, we have surveillance video, and we're not relying on the testimony of eyewitnesses. Because as has been on full display in this case, eyewitness testimony can be all over the map in terms of what people saw, what they perceived, versus what actually happened. When we One more shot. Okay, so now I have Exhibit 34 up on the screen. Now, as we work through it, we are all in agreement.
Can you indicate what time you have up there,
Yep.
please? Thanks.
So at 2:13:56, we see Mr. Wagner walking across the street. We know a significant amount of physical activity has occurred in terms of Mr. Ali being punched, the dragging, and the bus driver getting out of the bus and coming to the aid, frankly, of Mr. Ali and his daughter.
All right, here we go, y'all. We are back in the room for a case. So I know it's been weird, the camera movement, plus me trying to bounce back between two different feeds. But it's only because the news, the First Coast News, they keep doing stuff like this, which is confusing me. So I'm not sure, like, dang, do I just go ahead and stream so we don't miss anything, or just keep, staying over where we are? Hopefully they pull it together. Okay, they're gonna, I don't know, this can't be the cameraman from the last couple of days, because this one right here is tripping. Okay, we had a little bit of a consistency throughout the trial, and then we get to the end, and now he get the jacking it up. So I do know that there's another channel that's streaming. I'm gonna check and see if they're using the same feed or not. That's what I'm checking right now, because if they aren't, then we will switch to that one. It's like a Fox somebody. Okay, we're gonna switch over here. And we're gonna let this one go. All right, so we're gonna rock out with the Jackson Fox News local channel, and we're gonna let First Coast go, because they killing us over here. Literally killing us. I feel a little bit better with this one, so I will still go back to Ali closings, and I will trust these folks over here to let us know when the trial is really back.
Hitting play. Okay, so now we are at 2:13:59.
What you doing?
What we see right here I don't know why I use technology. Okay, what we see here is we see Mr. Wagner. We see the individual in the beige sweatsuit, okay? Right above his left shoulder, you can see the head of my client.
All right, we'll be in recess for 5 minutes. All right, Mr. Leary, you may continue.
Thank you for your patience. Thank you for being here. You might be surprised I am somewhat averse to using technology, and this only confirms that. Okay, so if we can have the screen. Did work in your absence. Okay. All right, so we have the screen, Exhibit 34, at 13:57, zoomed in, and we see this truck crossing the bike lane white stripe, and you will see my client emerge from screen right by the tree, and I'm going to work my way through. So you can see, as I'm going frame by frame, you can see her now walk in front of the tree and extend her hands out. And you can see Isaiah, his hand and face slightly above the bus driver. And we see Mr. Wagner go down. And we are at 14:01, frame 3. And you will see my client then begin to step back. Okay, so we are at 14:04, frame 6. And what you can see is you will see the camo hat of Mr. Wagner. You see the individual in the beige orangish sweatsuit, male with the backpack. And over his right shoulder, you will see my client standing to get out of the way of Mr. Wagner as he prepares to go down. Moving frame through. Mr. Wagner then goes down. We are at 2:14:07, and you can still see my client. She's very clear here, standing above the right shoulder of the individual in the beige sweatsuit. She is standing as Mr. Wagner goes down to intervene. So now I'm going to go back to 2:14:07 and hit play. You see Isaiah walking around. We see him momentarily start talking with Haneen. Haneen is filming him. He's upset, threatens to punch her, and that's at 2:14:36 as I stop it, okay? So we see Zayla Carter and take him away from Haneen as I hit play again. You can see the bus driver just...
Okay.
All right, the judge just announced we're on the last witness of the day.
All right, sir, if you'll please come forward and be sworn.
Yes, ma'am.
All right, be sure to sit closely to those microphones and please speak loudly and clearly into them. Thank you. Counsel, you may proceed.
Good afternoon, sir.
Good afternoon.
I take it from the uniform you're a police officer?
Yes, sir.
What's your current rank?
Sergeant.
I want to turn your attention to January 14th of 2020 at around 3 o'clock in the afternoon. do you remember being in your department's property room on that day?
Yes.
While you were in the property room, did you see my client, Hakeem Robinson?
Yes.
Did you sit down and have a conversation with him?
Yes, I did.
Now, the case that we have before these juries happens less than right around 12 hours later, 12 to 18 hours later. I want to ask you questions about what my client looked like.
Okay.
You remember what his hair looked like?
Somewhat, yeah.
Now, if we can use gentleman here with the gray suit and the red shirt, would you agree that my client's hair was around the same length, maybe a little bit longer, but twisted?
Correct, yes. It was, I think a little bit longer than that.
It wasn't dreads down to his chin?
No, not at all.
It was consistent with that type haircut where it's trimmed around the edges, twists, maybe a little bit longer,
From what I remember.
but not much longer.
From what I remember, yeah. I can't recall too much, though.
Sergeant, I have two questions for you. You had a conversation for what, maybe about a half hour with my client?
If that, yes.
Would you ever use the word slender to describe Hakeem Robinson?
I would not know.
What about short?
No.
One brief moment, Your Honor.
Okay.
Nothing further. Thank you.
Okay. Any cross?
Yes, Good evening, Sergeant Howell.
Hey, how are you, sir?
Good. Have you had the opportunity to view video recording at the JSO property room that shows Defendant Robinson and your interaction?
Prior to coming in here?
Yes, sir.
No.
Would that help refresh your memory about how the Defendant Robinson looked at the time of your interaction?
Yes.
I'm going to show you what's been pre-marked as State's Identification 10R, the videos. They have been part of discovery. I've shown you. I've downloaded it onto my computer, so it makes it easier to move around. Showing you the lobby, Sergeant Howell.
Objection. This is refreshing. The witness can look at it. Ask the question again.
Okay.
Let me ask this. Does this video taken on, does this video take,
Okay. I need to hear the question. I mean, if,
video
uh-huh.
taken on January 14th fairly and accurately display Hakeem Robinson when he comes to the property?
All right, I'll overrule the objection to that question. That's an appropriate question.
Right here, correct. He's got a hoodie over his head, correct.
And Sergeant, as we fast forward through that video, do we see you?
Yes.
And are you in a red t-shirt in this video?
Yes.
Your Honor, this time I would move into evidence states all as the appropriate number.
Okay, any objection? All right, let me see it.
See, this is the time that we absolutely need to see what's going on, because right now they are presenting what he looked like up in that office on a certain day. And this officer is saying that he's not short, he's not slender, and his hair is a certain type of length. Now they introducing it, so I feel like it is possibly something that's going to support the state's theory over the defenses, but I want to see it, you know, because sometimes these prosecutors, they can be a little delusional. They can be so caught up into the case that they kind of overlook or want to, you know, make it something that it isn't. So this is one of those times again in this trial where it sucks because we are not able to see the evidence. We know that, but I don't feel like the defense has articulated it. Maybe it's more in the evidence, but I don't feel like the defense has articulated or made a distinction, a good distinction of locks versus twists.
All right, you ready, Madam Court Reporter? All right, ladies and gentlemen, we're going to go a little bit back out of order. We're going to go back to direct examination, and then Mr. Mizrahi will conclude his cross. Yes.
I'm sorry. Clerk first. I got you. One brief moment, Your Honor, while we
All right.
mark.
if Your Honor allows, I could lay the foundation while that's being marked.
All right, and just for the record, we're marking what? Defense Exhibit number 2?
Pre-marked is defense 3.
Okay, defense. Okay, then no need to lay the predicate. Defense Exhibit number 3, which shall be marked into evidence.
Sergeant, have you had an opportunity to look at defense 3?
I don't know what defense 3 is.
Did you, in the hallway before coming in here, have a chance to take a look at some videos from the property room?
Yes.
It's got you wearing the red shirt.
Yes.
It's got Mr. Robinson first getting dropped off out front, walking into the facility, going inside,
Yes.
and then you having a conversation with him and him exiting?
Yes.
All right. You reviewed that before you testified?
Yes.
And in any way, did that change the testimony that you gave in here?
No, I mean, go ahead, I'm sorry.
Hair, build, height?
Like I said, hair from what I saw from the front, correct. That's what the size of what we're saying Mr. Whitaker is.
Nothing further. Thank you, Your Honor.
All right, cross-exam, continuation.
Sure, I published statements.
All right.
Is this the laptop HDMI? You're good. You're good. Texas. Okay. Sergeant Howard, we're showing you Defense Exhibit 3. Is that the defendant, Mr. Hakeem Robinson, wearing a hoodie?
Yes.
Does Defense 3 fairly and accurately depict the way Hakeem Robinson looked on January 14th of 2020?
Yes.
I'm going to show you a couple more brief ones. First of all, the lobby. Again, Defense Exhibit 3, is this the inside of the property room, Sergeant?
Yes, that is.
I'm going to fast forward just to show the jury you're generally the same build as you were at the time,
Yes.
meaning today versus,
What is that?
the computer
Dennis
just
Quaid?
throws up.
Okay, sorry.
Is, Sergeant, is that you in the red shirt here? And who are you talking to?
It'd be Mr. Robinson, yes, and that's me.
And then one more angle. In Defense Exhibit number 3, do we see the door here where Mr. Robinson is leaving? Got it. So we're seeing in Defense 3 in the red shirt, is that you, Sergeant?
Yes.
And in front of you is Mr. Hakeem Robinson?
Correct.
Sergeant, approximately was your height and weight at the time, January of 2020?
Then was 6'3", 15".
Sergeant, was the defendant, Hakeem Robinson, was there to pick up a cell phone, correct?
Correct.
I have a moment, Your Honor.
Okay. All right, any questions from Mr. Whitaker?
No, Your Honor.
Okay. Any redirect?
Yes, Your Honor. Sergeant, does that video change in any way what you saw with your own eyes that day?
No, I mean,
Mr. Robinson is either short or skinny.
correct.
Nothing further. Thank you, Your Honor. Thank you, Sergeant.
All right, may this witness be excused?
Yes, Your Honor.
Okay. Thank you, Sergeant. You're excused and free to go.
Thank you.
All right, ladies and gentlemen, I lied. There is one more short witness. I'm so sorry. Shorter. So we are going to call this last witness and then we will be excused for the day. Thank you. So defense, you may call your next witness.
Defense calls Michael Williams.
Okay. All right, so if you'll be sure to sit closely to the mic.
Oh, since we got a little break, I would so use that in closing arguments so bad. My client was like, yeah. You know what I'm saying? My client picked up their phone from the police department the day before. No data extraction done from it. We know that he was the owner from it. He came and collected it. Man, I eat that down in closing arguments so bad. I ain't gonna lie, y'all. This feed done pissed me off today. It really has. The whole entire trial watch today has been so bumpy. It has not made today fun whatsoever. It has been more difficult than ever to watch this trial end. None of the other, it's the same feed for all the other channels that are streaming it. I'm exhausted. We can't see the evidence. We can't hear the trial. I'm exhausted. Well, Andrew, they had one more witness, and that witness was supposed to take the stand, and it was supposed to be a very short and brief witness. But when they took the stand, I don't know if that was a lay person that they weren't supposed to show or what have you, but they showed that witness, and then they went to the floor. First Coast News says that court is in recess. Nobody has audio, so I don't know if court is over or not. Yeah, somebody is actively on the stand, and she did mention that they were staying late. So I understand it's 6, but that lady just told us, and we just watched somebody get up there on that stand. All right, y'all. I can't take it. If anything comes up, I will add it to the recap. Today in court was crazy. It was a difficult day to watch that stream, and they going in the recap for jacking it up today for sure. So as usual, thank all of y'all for rocking out with me. I'll post the recap whenever I get the transcript because there was pieces of this trial today. Of course, I got to reread because the volume ain't, but it only go up to 2 notches. Okay. We will be back tomorrow, same place, same time. If you didn't hit the like button, make sure you hit it on your way out. Y'all have a good evening.